before we commence the hearing?
Good morning, Presiding Commissioner McKissick. I have heard from all parties and from commission staff that all parties are willing to excuse Walmart witness Steve Chris. I am planning to file a formal motion in the docket, but would request that his direct testimony that was filed in this docket and then the settlement testimony that I believe was filed yesterday, along with the summaries of each, be admitted into the record, and that he be waived from the hearing.
Without objection, your motion's allowed. We'll look forward to receiving the formal written order excusing, and that we will then, in fact, issue an order officially excusing. But as of now, assume that that is a closed issue.
Thank you so much, Presiding Commissioner McKissick.
Absolutely.
Good morning, Presiding Commissioner McKissick, Marcus Trathan for CUCA. I have a similar request for CUCA's remaining witness, Billy LeConte. The parties that had previously reserved cross-examination have agreed to waive cross, and I have not heard any objection to excusing Ms. LeConte from the proceeding. I'm unaware as to whether or not the commission has questions for her, but we would propose to file a motion to excuse her attendance, assuming that the commission does not have questions.
Without objection, your motion is allowed. We will look forward to receiving a formal written request for excusing, and we will issue a formal order. I've consulted with commission's staff, and there are no questions.
Thank you.
Thank you. Are there any other preliminary matters before we begin? Yes.
Presiding Commissioner, just so that parties are aware and the commission's aware, the public staff has two witnesses that are currently traveling to be here in Raleigh and in the commission room. We expect them this afternoon. To the extent that it does interrupt sort of the order of witnesses that we have pre-filed, I understand Counsel for the Public Staff has notified all parties that the Walters and Fahey panel and then the Lucas McCullough panel potentially could be called out of order. So just bringing that to the commission's attention. And if that's the case, I believe the Thomas and Williamson panel would be after the large load panel if needed.
That has been brought to my attention, and certainly we're willing to change the order based upon witness availability at a given time.
Thank you, Presiding Commissioner.
Absolutely. Any other preliminary matters from any attorneys? Not seeing any. What we will do is go ahead and affirm this panel in its entirety. Do you all solemnly swear to tell the truth, the whole truth, and nothing but the truth in your testimony giving in connection with this proceeding today?
Yes.
I so affirm.
I do.
Absolutely. And I'm affirming you all, not singling out anyone.
Thank you, Presiding Commissioner. Mr. Lucas, would you please state your name, business address, and current position for the record?
My name is Jay Lucas. My business address is 430 North Salisbury Street in Raleigh. I am the manager of rates and energy services in the public staff's energy division.
Dr. Weaver, would you please state your name, business address, and current position for the record?
My name is Leah Weaver. My business address is 430 North Salisbury Street in Raleigh, North Carolina, and I'm an engineer in the energy division of the public staff.
Thank you. And Dr. Singanzi, would you please state your name, business address, and current position for the record?
My name is Jethro Singanzi. My business address is 430 North Salisbury Street, Raleigh, North Carolina, and I'm a utilities engineer with the energy division of the public staff.
And just for clarity of the record, this panel is appearing as the large load panel. Just wanted to note that. Panel, on May 29th, 2026, did you prepare and cause to be pre-filed direct joint testimony in this docket consisting of 62 pages, 5 exhibits, and 3 appendices?
Yes.
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 Did your testimony contain both confidential and highly confidential information?
Yes.
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 On June 18th, 2026, did you prepare and cause to be pre-filed an errata and corrections to your pre-filed joint direct testimony and exhibits?
Yes.
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 On July 2nd, 2026, did you prepare and cause to be pre-filed a second set of errata and corrections to your pre-filed joint direct testimony and exhibits 2, 3, and 4?
Yes.
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 Do you have any additional corrections to your pre-filed direct joint testimony or exhibits?
Not at this time.
No.
No.
And if I were to ask you those same questions in your corrected pre-filed joint direct testimony today while appearing at the witness stand, would your answers be the same?
Yes,
Yes.
Yes.
Did you prepare and cause to be pre-filed on July 6, 2026, a summary of your joint direct testimony in docket number E7 sub 1329A?
yes,
Yes.
Yes.
Presiding Commissioner, at this time, I would move that the pre-filed joint direct testimony of the large load panel as corrected, consisting of 62 pages, 5 exhibits as corrected, and 3 appendices, and the pre-filed summary of joint testimony of the large load panel be entered into the record as if given orally from the stand at the appropriate time.
Without objection, your motion is allowed.
Presiding Commissioner McKissick, the large load panel is available for cross-examination and commission questions.
Very good. First in queue is Amazon.
Thank you, Presiding Commissioner McKissick. Good morning. My name is Robert Josie. I'm with the law firm Nelson Mullins, and I'm here on behalf of Amazon Data Services. The panel's testimony states that the biggest risk associated with large load is the possibility of significant utility investment for loads that fail to materialize, thus leaving the cost of stranded assets to be borne by the entire customer base. Is that correct?
yes,
And those stranded assets are only borne by the entire customer base to the extent that they are not covered by the liquidated damages associated with the ESA that customer signs and executes with Duke, correct?
well, it could be liquidated damages, plus it could be any upfront payments that customer made. So any kind of payments that the customers made up front or committed to pay for failure to either show up or not show up with the anticipated load. But you're correct, there is some mechanism in place where Duke can recover the money, and that would lessen the harm to other customers.
Okay, and do you know whether or not when Duke is setting those liquidated damages, whether they look at the amount of investment that is needed to make to serve that customer in setting those liquidated damages?
I'm not exactly sure how Duke has done it in every case. We've had a lot of different electric service agreements with different requirements, so it's not the same for every customer.
Part of that is because each site that each customer is looking to build at or interconnect into the grid from is different, correct?
Well, the sites are different, and also the timing is different. Duke Energy's been signing electric service agreements for years, and they've changed. They've evolved over the years, so there are different requirements for different customers.
And just a little further down in your testimony, the panel states that the same risk exists if the project does materialize, but decides to reduce or terminate service before Duke recovers its capital costs. And those costs will be redistributed across the remaining customer base, correct?
That could happen, yes.
Yeah, but again, that is subject to the significant liquidated damages a customer would have to pay if it was terminating or not showing up on.
Well, some customers might have to pay liquidated damages. I'm not sure exactly what they are in all of the ESAs.
And I'm not asking for specifics on it.
Not specific, but there are, and some of those ESAs do contain liquidated damages that the customer would have to pay if it reduced load.
If I could just add as well, I can't speak to exactly Duke's process in the ESAs, but they've communicated to us in their proposed rebuttal tariff that damages amount isn't necessarily intended to cover all of the incremental infrastructure that would be required to serve customers. So that's contributing to that potential stranded asset risk.
Correct. Is it your understanding that those liquidated damages are there to make Duke whole? That's the point of liquidated damages.
It's an attempt to make whole. I'm not sure if Duke will be able to recover every dollar it invested.
But the credit performances that are required when signing those ESAs, the customers are required to put up performance guarantees that would equal the liquidated damages.
Yeah, some of them do. Some of the electric service agreements, especially the newer ones, do have those requirements.
Mr. Lucas, would you please just pull your microphone and closer to you? Thank you.
Okay, and isn't it true that the load ramp that that allows the company to, the load ramp allows the company to build out some of the infrastructure, enabling a portion of the service to be taken by the customer prior to full service taken.
Yeah, some of these electric service agreements do have load ramps. I don't know if they were specifically matched up to Duke building infrastructure. Some of that could have been set to allow the customer to build its facilities and begin taking load over a period of years.
But the effect of the load ramp is that Duke would build some infrastructure and then allow the customer to take service and start paying for some of that, for that service. Correct?
Yeah, it would begin, once the day it began taking service, it would start paying rates for that service and, in some cases ahead of time, would have made payments in advance and also made commitments. Yeah, any delay in coming to full load would give Duke Energy more time to build its infrastructure.
Okay. And as the customer begins paying for service, it is at least in part paying for that infrastructure.
If the electric service agreement does have payments in advance, then that customer would be paying ahead of time before it's began taking service.
But even the demand charge associated with service would pay for some of those infrastructure.
Yeah, on its first electric bill, that customer would be paying demand charges and start paying for some of that infrastructure.
Okay, so would you agree with me that the load ramp is a way to reduce the risk of stranded assets?
I might
Go ahead.
speak a little bit to that. And I'll let witness Lucas add. The load ramp can provide some clarity in terms of how a customer is going to increase their load over time. However, we have seen in some data responses that there have been delays with some large projects or customers in terms of the load that they're bringing online. So when we express some concerns about load materializing, we are influenced by what we've seen in terms of delays by customers in their own desires. There have even been reductions at times from the set desired load from the original ESA to a new updated ESA of sorts. And I'll let witness Lucas speak a little bit more.
Yes, one thing that the customer has to do, it has to sign a contract term to be 15 years. The load ramp's not necessarily matched up the length of the contract term. The load ramp could be done and the customer would be committed to taking full service long before the contract term is over. And it could be something that in which the customer reduces load after it's finished ramping to full load, but before the contract term is over. So that is a concern of ours.
But the point of a load ramp would be that if that customer were to have to delay their construction on their facility, it would allow Duke to adjust its construction timelines as well, correct?
I think,
Go ahead.
if I might add, I think it's highly dependent on the notice that, let's say, these customers are able to provide to Duke. And also, sometimes with these assets that are being put online for distribution or transmission, they're not things that can be incrementally increased. Let's say, for example, if we're talking about a 200 megawatt load at the end of an ESA, for Duke to be able to serve that large load, there's some components that they might put in place knowing that, okay, in the long term, this customer needs 200 megawatts. But there's some, let's say, distribution components or transmission components that from the get-go are designed to provide load for that 200 megawatts. And if you were to ramp up, let's say, from 25 megawatts to 50 megawatts to 100 megawatts, the availability of that particular, let's say, transmission or distribution resource would be in many ways perhaps slightly underutilized, let's say at the earlier parts of the load ramp, with the understanding that when the end goal load is reached, the invested in transmission assets and distribution assets will be more fully utilized.
Yeah, and I can add to what Dr. Sanganzi said. Some of the assets that Duke installs are are large. Like he used an example of a 200 megawatt load. Well, if Duke Energy is installing 100 megavolt ampere transformers, installs one to meet the increasing ramp, installs a second. We use an unofficial term called lumpy. These investments just don't come in smoothly, little piece by piece, month after month, or quarter after quarter. They come in big pieces. And so Duke has to make the investments ahead of time before that load shows up. The load ramp could be altered some if Duke had not invested in the assets to serve that load ahead of time. That could happen, but I'm not sure that it always would.
And also to add a bit more, there are challenges because some of these assets do have long lead times in terms of months or years. So a change in load at the end of an ESA can have impact on what Duke might want to do. Duke might have a plan that's pretty solid, but if there are changes on the end user, it can really impact whether or not that asset is being used economically or not.
Okay, but you would agree that changes in a customer's, plans to build a facility are more likely to change early on in the development than later on in the development, as you are suggesting.
We cannot agree to that. Like I said, some of these contracts are 15 years long, and a customer could reduce load after 12 years, after the ramp. So there's no prediction as to when a customer might reduce load.
Okay, but I'm just talking about the ramp specifically, not anything. I mean, we can cover, whether or not the customer decides to reduce load and the provisions that you've proposed to cover that scenario at another time. But what I'm talking about is the load ramp itself, de-risking the utilities upfront investments.
So in theory, it should, but I think what we found is in some investigation of ESAs is that there's a lot of discretion that Duke might have with particular customers about the particulars of an ESA. And one thing that is hashed out a lot in these ESAs is what is the load ramp going to look like? For different customers, they might want to step up relatively gradually. For different customers, they might want to reach their max load relatively quickly. I think you provide some good arguments, but there is some concern because the ESAs can be very fluid at times, depending on various factors that might change. And there's a lot of discretion that Duke might have with a prospective customer to change that load ramp and try to keep them whole. But I think witness Lucas has some more.
Yeah, what you're talking about could happen if Duke anticipates that a customer will not come to full ramp for a period of years, could have some flexibility. It just depends on how Duke has to time its investments.
Yeah. At this time, I'd like to point you to potential ADS potential cross exhibit 18, which yeah, Dr. Weaver's got it.
Yeah, we've got it.
Okay, and this is a
What was the number of that one again?
potential exhibit number 18.
18. Thank you.
And this is a response from DEC to a public staff data request. Is that correct?
Let's see, this data request 242.
242-3.
242. All right. Presiding Commissioner McKissick, I would like to mark ADS potential cross exhibit number 18 as ADS cross public staff large load panel direct exhibit 1.
Hereby duly noted, marked, and identified for purposes of the record.
Okay, thank you. According to DEC's response, in the second sentence of subpart A, it reads, longer load ramps provide more time for the company to integrate such load and reduce the risk that major investments would be made early in the customer's project development when there are the greatest risk for delays and material changes. Did I read that correctly?
That's correct.
Okay. And so in DEC's opinion, a longer load ramp schedule would reduce the risk that there would be stranded assets, correct?
That's what the response says,
Okay.
yes.
So as we were talking about at the very beginning, the public staff's worried about stranded assets, but it puts a cap on the load ramp.
Yes,
And I'm just trying to understand exactly why public staff would put a cap on a load ramp schedule if it would de-risk the idea of stranded assets.
well, we're not in agreement with that. We've put a cap on the load ramp because Duke is having to make investments. And like I said previously, these investments don't come smoothly month by month, quarter by quarter. They could be large investments for one specific piece of equipment, like 100 megavolt ampere transformer. We wanted a cap on the load ramp to make sure that customer is committed. 5 years is, we figured, an adequate time to get that customer's facility up, built and running, and start paying for what it said it was going to use.
But again, it is paying for the service it is taking during that load ramp.
Well, see, the load ramp, the customer's not taking full service. It's not using it's not using all the demand. It's not using all the energy. It's making some payments, but it's not coming to full load and making all the payments that it would be at full load.
Yeah,
If I could
agreed. Oh,
add as well to your original question, part of our concern as well is that when there's no cap, depending on how the ESA is structured, the customer could just continually come in and extend their load ramp and change what their demand is in that way as well. And so, you know, that's an additional risk that Duke could be making these investments. And then we've seen load ramps change in the ESAs we've been given. So that's a potential risk as well, that the customer could just, you know, extend the load ramp without any specific limit.
But I can say we have put in our DEP testimony having a curtailment that sort of matches that load ramp.
and we'll get to that.
Okay.
All right. All right, I'm gonna turn to the notification and termination provisions and the specifically the exit fees that the public staff has proposed, which would include the net present value of extra facilities, the net present value of the required facilities charges not yet recovered, and 75% of the minimum bills for the remainder of the initial term. Is that correct?
That's correct.
And that's if the customer provides the required notice that the public staff is proposing. If they do not provide sufficient notice, the exit fee would include 100% of the annual minimum monthly bills. Is that correct?
Wait a second, let me find that. Are you specifically looking at the large load tariff or our testimony?
The testimony, I believe.
Okay, and just give me the page and line number, please.
Yeah, I believe it's around page 32, where the bulleted terms of your contract are, or your tariff.
Okay, we've got two sections. We've got paragraph 4 and paragraph 5.
Which paragraph are you?
This is our testimony, page 31, paragraphs 4 and paragraph 5 talk about what a customer must do if it reduces or terminates load.
And the public staff considers, and then we're going to move around from required facilities and these termination payments a little bit, but public staff considers required facilities to be all projects that serve the customer, including those projects that will serve other customers, correct?
Yes.
But isn't one of the purposes of the demand charge to recover the cost of infrastructure to build, serve the customer? I believe we were talking about this earlier.
Yes, that demand, that's the intent of that demand charge, but our concern is that Duke Energy is going to make lots and lots of investments before that customer begins taking service. And it's true over a period of time, those demand charges will begin to reimburse Duke for its investments, but that was our concern. That's why we added these requirements in case the customer terminates load or reduces load before it makes all its demand payments to pay for the infrastructure.
If we could just add also, and I think Dr. Sanganzi is going to clarify this, but that required facilities, it's not all infrastructure needed to serve the customer. It's things that the customer is triggering specifically. Otherwise, that would just be the entire system. The entire system is serving the customer.
Yes, and I think because I think you'd also mentioned before when a large load customer pays, let's say a certain demand charge, or they're also, let's say, paying revenue, that it'd be going towards, let's say, the transmission infrastructure or distribution infrastructure that they caused. I'd like to highlight table 2 in our testimony on page 52, where we go over a cost allocation breakdown of various customer class groups. And one thing we try to discuss here is that for various plant that's being put into the system, whether for transmission or distribution plant, the allocation varies a decent amount depending on the class of service that you are at. So we show that, let's say, with the residential customer class, if we were to aggregate all the residential customer classes together, a lot of what they pay for reaches about 50% of addressing transmission plant. 63% is also going towards distribution plant from the residential customers in typical payments. A large load customer typically in DC would likely be on an OPTV tariff, and their contributions, as we show here, as a customer class in general, for the transmission would be at about 16.2% for the larger system and 4.8% in distribution for the larger system. So I think to say that what a large load customer would provide in payments from the get-go, once maybe they start taking service, would be fully going towards the costs that they've caused, is not a full picture of the cost allocation with regards to some of that infrastructure.
All right, but it is the intent of the public staff for the large load customers to pay for required facilities and the typical cost to serve. Is that correct?
Well, classified as dedicated and required facilities. Dedicated facilities, the customer would pay for all of it and their portion of required facilities.
Okay, and so it's the public staff's intent that the exit fees will cover the majority, if not all, of the infrastructure costs associated with that customer. That's just a general question.
Yeah, so it's our intent that that exit fee would cover both all of those required and dedicated facilities that have been allocated to the customer, as well as help manage that stranded asset risk that we discussed earlier.
Yeah, but there's no guarantee that what we've put here will allow Duke to cover every single dollar that it invested.
I guess the point being is that you're asking for a recovery of the extra facilities charges, the required facilities charges, and 75% of the minimum bills, which include demand charge. So isn't that double recovering?
So what we actually are proposing with regards to the EFC or extra facilities charge revenue is that we actually would essentially give that back, and not actually double count. With some of the, let's say, the disallowance that we were talking about, yes, we'd want to remove, let's say, the things that we are, let's say, are looking at with regards to, let's say, the dedicated facilities. But because we are looking at disallowance for those dedicated facilities, we do want to understand that those EFCs for that extra facility benefit would actually be given back. So we try to address the concept of double counting by giving it back essentially and not allowing it to be used towards a larger cost of service.
If I could try to clarify that a little bit, I think, say in the next general rate case, we would be direct assigning those extra facilities charges. The extra facilities charges would be set based on those specific project amounts. And so when you go to set rates, those costs have been removed. And so the demand charges are not recovering those specific project costs.
And I can go more specifically. This is page 31, lines 14 and 15 of our testimony, 13, 14, and 15. We talk about extra facilities charges and required facilities charges not yet recovered by DEC. And right, those last 5 words we hope will prevent any kind of double recovery.
And if I could just add as well, these provisions that we're suggesting in terms of termination fees, there are similar provisions in other states. Evergy, Kansas, and Missouri, for example, they have, this requirement for all of the minimum billing demand to be recovered in termination fees. So we don't think that this is extreme relative to what's happening in other places.
Do they also require required facilities to be recovered as well?
I would imagine that if there are extra facilities charges that customer is paying, that those would also be recovered, but I can't say for sure without the tariff in front of me.
Okay, and as we've stated, you're looking for the exit fee to recover as much of Duke's, potential spend from that customer. And then you have the notification provision requiring a customer prior to termination to notify the company between 12, 24, and 36 months, depending on the size of the customer, correct?
That's correct.
Okay. And can you turn to ADS potential cross exhibit 17?
We have it.
And is that Duke response to a public staff data request?
Yes, this is Duke's response to public staff data request 242-1.
Presiding Commissioner McKissick, I would like to mark this potential exhibit 17 for identification as ADS cross public staff large load panel direct exhibit 2.
Duly marked and identified for purposes of the record.
Thank you. Okay, do you see the answer to subpart C there?
That's correct. We see it.
Yeah. Does it state that the potential negative impacts of early termination are primarily related to underutilized system resources, and that the proposed notification requirements and termination damages provide adequate time to redeploy and best utilize system resources?
That's what it says.
Okay. And the purpose of that notification, according to that, is to allow Duke to change its construction plans and update its load forecasting, or find a similar load that matches that loss, correct?
That's what Duke's intent is here. And it's true that what Duke's saying could help mitigate changes in plans by the customers, but there's no guarantee that Duke will recover all of his expenditures that it made to serve that customer.
But on the other side, given that Duke should be able to change its construction plans and its load forecasting based on the notification periods proposed, wouldn't the exit fee proposed by the public staff recover significantly more than Duke is likely to spend in the future? I mean, we're talking about the demand charges for the entire length of the contract, plus the required facilities and the extra facilities charges not yet recovered.
Duke could recover a large part of it, but like I said earlier, we've got our parameters. Here we've set up on page 31, exit fee and notification of reduction or termination of load. This is an attempt to allow Duke to recover its expenditures, but like I previously said, there's no guarantee that Duke will be able to get every dollar back that it invested.
Well, it's a guarantee that they'll get every dollar back that's listed in liquidated damages, correct?
Yes, assuming that liquidated damages were set correctly.
Skip that. Okay, let's turn to the curtailment provisions on page 32, starting at line 21.
I'm sorry, say that again, please.
Can we, we're going to turn to the curtailment provisions that you propose on line or page 32, starting at line 21.
Yeah, we're there.
Okay. This curtailment provision as proposed in this testimony has an unlimited time period, correct?
That's correct.
And but in your DEC, or excuse me, DEP case, in the testimony filed by the public staff in that case, you proposed that curtailment provision apply for the first 5 years of service.
Yes, upon getting more information by Duke's rebuttal and testimony of interveners, in the DEC case, we decided in our DEP recommendation to change that curtailment period and have limited to 5 years, but possibly have an extension if warranted.
So would the public staff now propose that modification in this case as well?
Yeah, we believe that could apply to DEC as well.
And in discussing the proposed curtailment provision, you describe it as a tool for system operators to maintain system reliability for emergency or extreme economic conditions. Is that correct?
Can you tell me which page and line number?
I believe it is further down. Second. Okay, page 32, starting at lines 21 down to 33, line 1.
Yeah, we're there. We see it. And yeah, that's what it says.
And do you have a definition for emergency?
Anytime that Duke's not able to provide power for any reason.
I think also witness Sam Holman in the CPRP hearing of late mentioned how curtailment can be used as a tool in the toolbox to address emergency situations. So in many ways, we would defer to the expertise of Duke for those emergency situations at times for use of curtailment.
Okay, but you don't know what those emergency situations are, if there's a definition perhaps tied to a NERC reliability standard.
I don't recall one. There could be, but I don't recall one.
And then do you have a definition for extreme economic conditions?
We consider that, yes. Anytime if Duke was not able to provide sufficient power to its customers and had to go into the open market, it can only purchase power at extremely high rates. We would consider that an economic hardship, and Duke should be able to curtail a customer if it just could not provide power, but can only provide power if it paid exorbitant rates.
Okay, and I'll try to do this without entering in another exhibit, because since you meant the abnormally high prices, do you have a definition for what abnormally high prices are?
No, it would depend on the situation and what the price was.
Okay.
Duke would have to make that determination.
Okay, but theoretically, they could set that abnormally high standard. at
Yeah,
whatever.
Duke would have to be reasonable in that determination.
I mean, do you think it's important for customers to know, for customers and Duke to know the specifics of these definitions prior to, their implementation?
I think customers should, if they're concerned about it, they should talk to Duke and understand what those curtailments, what kind of events would create those curtailments. They should talk to their account manager.
Okay, would a separate docket where these things are discussed be helpful in that regard?
No, this is fairly simple to solve. They could, these large load customers have account managers at Duke, and they could contact that account manager anytime and say, hey, what are my potential provisions?
We also have a separate docket where this has been discussed in E100 sub 208.
All right, and it sounds like, excuse me. You also state that within the 100-hour period, only 50 hours can be used for non-emergency demand response or financial gain, correct?
Can you
Yep.
point to that in testimony,
Yeah,
please?
that would be page 33, lines 10 and 11.
Yeah, we see that, yes.
Okay. And so do you see a difference between the use of financial gain in that sentence and extreme economic or abnormally high, extreme economic situations or abnormally high prices?
I mean, this description is our interpretation of the EPA's, the Environmental Protection Agency's rules and limitations on diesel generators. And I think the goal of this paragraph was just to try to explain where that 95% for 50 hours or 50% at 100 hours, where that is coming from. But that is in alignment with what Duke currently has in its ESAs. So we were just trying to provide some additional context there.
But it does seem to be a little less strenuous than the high abnormal prices or extreme economic conditions. We can move on.
And we could, that financial gain, is just, like I said, only 50 hours. So, somebody doesn't have a whole lot to play with there. So if somehow, serving the customer would create some, unusual financial loss to the company, company should be able to curtail.
All right, and then on page 36, lines 15 and 16, you state that all new customers and incremental expansion by existing customers as of January 2027 served under LGS, I, OPTV, HLF, or HP tariffs with a 15-minute aggregate demand of 50 megawatts or more will be required to take service under the public staff's proposed tariff. Is that correct?
That's correct.
Okay, and how does the public staff define new customer?
Any customer that begins its first day of service on or after January 1st of 2027.
Okay, and so the public staff intends this new tariff to apply retroactively to customers that have already signed ESAs, but have yet to take service?
Yes.
Okay, and would this also apply to an existing customer who's currently taking service in a load ramp schedule that would incrementally increase its load over?
Yeah, if it ramped up to over 50 megawatts and 80% load factor, it would also come under our tariff, our proposed tariff.
Even if it's already taking service right now?
Yes, if it expands service above 50 megawatts and over 80% load factor.
And it's the public staff's intent to require these new customers to adhere to additional terms in the public staff's proposed ESA application form as well?
If they've already signed an ESA application, No, the ESA application terms will not apply. They've already, this is our proposed ESA application, and Exhibit 4 is for customers that sign ESAs on or after January 1st, 2027.
So it's just the tariff that would apply?
Yes.
Okay. And the public staff is requesting that the commission amend those previously or require those customers with ESAs to fall under this tariff, and it believes that the commission has that power.
Yes.
Do you know of an example of this?
There are recent examples of the commission requiring service of specific customer groups. In the case of net metered customers, residential net metered customers are required to take service under Schedule TOU CPP, and that was intentional to ensure that those customers are, meeting their cost of service.
And in that docket you mentioned, I believe it's E100 sub 180, the net metering tariff docket, that was opened due to a specific legislative requirement in House Bill 589, correct?
That's correct. And to be clear, the commission can change tariffs, issue new tariffs in a general rate case or any other proceeding.
Okay. But has the legislature passed a similar law requiring the commission to develop a large load tariff at this time?
No, the General Assembly has not.
But that doesn't mean that the commission doesn't have the authority to do it.
And so if we're going back to what we were originally talking about with the load ramp, if a customer who has a signed ESA, hypothetically with a load ramp, let's say longer than 5 years, would that customer then have to shorten the load ramp to 5 years to comply with the tariff?
Not if it already agreed in its ESA.
Okay, so if in that particular situation, tariff wouldn't apply the same to every ESA.
Let me check real quick. If the customer had already agreed to a load ramp in an ESA, we would not force that load ramp to change according to the tariff.
Okay, all right, thank you. Those are all the questions I have. Presiding Commissioner McKissick, at this time, I would like to move the cross exhibits I identified into the record.
So it'd be as Exhibit 1 was your potential number 18, and Exhibit 2, your potential exhibit number 17.
Correct.
Without objection, your motion is allowed.
Thank you.
Next in the queue, who was reserved time, I don't know if you want to exercise it, is the Attorney General's office.
Good morning, Rita Coxton on behalf of the AG's office. Have you all read the AG's testimony regarding large loads? It was filed by Justin Brandt.
Yes.
Can you explain the difference between, or the reason why the public staff chose the benchmark of 50 megawatts as opposed to something lower?
And we talk about that in our testimony. Give me a moment, please.
If you could direct us to that page, Mr. Lucas, it would be appreciated, sir.
And which version of the testimony?
Yeah, I'm looking at the last.
See this page 27, where we start talking about the tiers.
Thank you, sir. And you're looking at the last corrected version of your testimony, is that?
No, let's make sure we've got. Okay, and we don't have the last
I
correct.
believe this would be on page 27 of the,
I'm seeing it on page 27.
Okay,
okay.
that's in this.
Yep.
In the original version too. Um. And that's where we explain how we set 50 megawatts as the top tier. We didn't want to capture too many smaller customers and have them conform to this because they would have lower effects on the grid. But once a customer does reach 50 megawatts and an 80% load factor, they are having more significant effects on the grid. And that's where we wanted our tariff to start at that load.
Can you quantify significant impacts on the grid?
It's impossible to quantify, to mathematically determine if a 48 megawatt customer or a 52 megawatt customer would have differing effects on the grid. It's possible to say exactly why it's 50.
No further questions.
Thank you. Looks like Sigfer is next in the queue.
Thank you. Good morning to the panel. I want to take a step back here and ask a few table setting questions. Let's start with the public staff's proposal in this rate case. It's correct that the public staff is proposing that the commission adopt a new large load tariff, Schedule LL, as proposed in your direct testimony that has since been corrected twice.
Yes, that's correct.
And you acknowledge on page 5, line 10 of your testimony that there is no universally accepted definition or threshold that exists within the utility industry for a large load. Is that correct?
Yes, but earlier, in that same paragraph, we consider a large load to be a substantial concentrated electrical demand with a high load factor originating from a single user or a facility at a specific point on the grid or multiple points in close proximity.
Thank you. And the public staff's proposed Schedule LL is mandatory, correct?
Yes,
And specifically, the tariff would be required for all new customers after January 1st, 2027 that meet the size and load factor criteria.
yes, or if a customer, an existing customer crosses those thresholds, it would also have to conform to that Schedule LL.
And it would be tacked on to existing tariffs and not offered as an optional add-on tariff, just to be clear for the
Yes,
record.
yes.
Thank you. Beyond new customers, and you just alluded to this a moment ago, you also recommend that the commission require DEC to monitor the load characteristics of new customers whose load and load factors meet the criteria for Schedule LL and require those customers to take service under Schedule LL, even if it's retroactive in nature. Is that correct?
I wouldn't call it I wouldn't call it retroactive. Customer meets those thresholds. It's growing. If an existing customer's load is growing and meets those thresholds, they should be aware that it's going to have to meet this tariff.
So it's fair to say that an existing customer currently in DEC's service territory could potentially be subjected to this Schedule LL if their load characteristics change in the future.
Yes.
Is the public staff planning to also monitor the load characteristics of existing customers whose load and load factors meet the criteria for Schedule LL and potentially require those customers, even if they are currently taking service under a different rate schedule, to migrate over to Schedule LL?
Well, a couple of things. First, the public staff's not going to do that monitoring. We're requiring Duke Energy to. And it's not really a migration. That customer would have to be under an existing schedule and also conform to our tacked on Schedule LL.
So the eligibility criteria as for which customers are going to be subjected to this mandatory Schedule LL, it includes potentially existing customers currently being served under LGS, OPTV, HLF, or HP tariffs, correct?
That's correct.
Let's say a traditional manufacturer that does not currently do business in North Carolina has decided to open a new facility here. Let's say it has a peak demand of 50 megawatts and an 80% load factor. Such a customer under the public staff's proposal would be required to take service under Schedule LL, correct?
Yes, because they could have a significant potential effect on the grid.
And the public staff's proposed Schedule LL is designed to be layered on top of existing tariffs as well as layered on top of the 12 CP jurisdictional and modified average and excess customer class cost allocation methodology, correct?
No, we haven't gone into cost allocation methodologies. It's just those tariffs we outlined, and you mentioned them also. It would be tacked on. It's not a function of cost of service allocation.
Dr. Singansi testified earlier this morning about cost allocation, correct?
Yes, from table 2, I believe, of page. Give me a moment. Of page 52.
Dr. Singansi, did the public staff perform or sponsor its own class cost of service study in this proceeding or any other proceeding related to large loads?
So some of those things that I understand with regards to large loads were covered by witness David Williamson in the previous panel.
In fact, the public staff is a party, a stipulating party to the cost of service stipulation that has been entered into the record in this rate case, correct?
I can't remember. We didn't work on that. And to be clear, our recommendations are for a customer to pay its fair share of the costs that it creates. And nothing more. If Duke feels that it's not going to recover or has a risk of not recovering a cost from a customer, it can request potential for liquidated damages or request advancements.
So I want to go back, Mr. Lucas, to what you just testified about the public staff wanting to make sure that customers pay their fair share. Is that what you contend the public staff is doing here?
Yes.
Why has the public staff advocated for years to apportion revenue requirement in such a way that the residential class is subsidized by other classes of customers?
I can't testify to that. We didn't do that analysis for our testimony.
It's true, is it not, that the OPT class of customers currently and has historically subsidized other customer classes?
We did not do that analysis.
Can you speak to that as you sit here this morning?
No, I can't.
Presiding Commissioner, the panels indicated that the cost of service and the rates panel was the better panel for cost of service questions. This panel's here for their large load testimony. So if we can just keep the questions direct and material to the topics that they've covered in their testimony.
And respectfully, if I may, Presiding Commissioner McKissick, this panel testifies about cost allocation issues, specifically transmission and distribution plant and how those costs are allocated across customer classes. I think cost of service questions are absolutely appropriate for this panel, given what they put in their direct testimony.
I would ask the panel to answer the questions to the extent that you have knowledge relating to it, cost of service, but to the extent to which it is best directed to another panel, then certainly feel free to direct the attorney to the other panel to get more thoughtful, deliberate, and analytical responses but answer it to the extent you have knowledge or possess knowledge relating to the specific issue that's posed to you.
Thank you. Dr. Singanzi, since you testified earlier this morning regarding cost allocation specifically, I'm going to direct this question to you. Would you agree, subject to check, that the OPT class currently subsidizes other customer classes to the tune of $57 million annually?
I cannot speak to that. I have not done an analysis to assess that. It would be interesting to look at the background work papers and analysis for that number that you're presenting.
Have you seen Jonathan Bird's direct supplemental exhibit number 4?
I'd like to take a look at it.
Have you not seen it as you sit here today, being the witness that sponsored this testimony in which you discuss cost allocation issues specifically?
Give me a moment.
I don't think we have a copy of it. And we've looked at thousands of pages of testimony exhibits. If you want us to have us look at it now, we can.
And so I'm asking the panel, as you sit here today, can you tell us whether or not you have reviewed that document?
I can't remember specifically. I've looked at lots and lots of documents.
Thank you. Dr. Singanzi, back to you. Are you aware, subject to check, that residential customers, DEC's residential customers currently are being subsidized by other customer classes to the tune of $136 million annually?
Again, I am not able to speak to that. I think a lot of that was something that David Williamson was able to provide some clarity on from the cost of service panel. And I think a lot of things that we describe in table 2 in our testimony here on page 52 are not describing things that we are proposing ourselves with regards to cost allocation. We're describing things that are already in place with various cost classes.
Thank you. And you would agree that an updated cost of service study will be filed by the company before or at the time of when it files its next general rate case?
It likely will before the next general rate case. Typically, before general rate case, the company does file a cost of service study.
And at that time, would you agree that the commission is going to need to address a number of cost allocation issues, including but not limited to DEC?
I just can't testify about cost of service.
If you could let me finish my question first, that would be great. Would you agree, related to DEP and DEC's upcoming merger, that there are going to be some cost allocation issues to resolve in the next general rate case?
Presiding Commissioner, I just renew my objection to questions squarely on the cost of service study, future cost of service studies, and future rate cases. Those were all addressed by witness Williamson and witness Fernandez in their pre-filed direct testimony. They've actually already answered this question in their pre-filed direct testimony. This panel is here to talk about the proposed large load tariff. I would, with the 4.5 hours plus cross that we have reserved for this panel and the commission's desire to move expeditiously through this cross, I would request that we have questions on their testimony.
I would sustain that objection. I think they've articulated they have very limited knowledge and expertise in this area. So, I mean, I think with that as a part of the record, it's difficult for them to respond to questions that are asked and propounded repeatedly about matters which they do not possess expertise.
Understood. Thank you. And those questions were asked only because they included that information in their testimony and used it as a justification for this proposal, but understood, and I will be happy to move on.
Understood.
Is it your understanding that large load customers or some large load customers have tried to work with the company and the public staff to implement a new clean transition tariff in order to allow them to accelerate and pay for new clean energy generation resources?
We've heard that, yes.
And your proposal that the costs of required facilities be recovered from the specific customer they were incurred for is, in your own words, a departure from historic practice which socialized these costs across rate classes?
Yeah, some of those required facilities costs, the portion that large load customer created.
And the record in this docket does not contain, to your knowledge, a class by class analysis of how this proposed departure would impact other classes of customers, does it?
Yeah, I saw proposals that other customer classes not be harmed.
So the question was, the record in this docket does not contain an analysis of how this departure that you just testified to would impact the different customer classes, does it?
Well, we do have a section of our testimony about some costs that Duke incurred in the past that we believe were socialized to other customers and should not have been.
Dr. Weaver, I want to come back to your testimony about docket number E100 sub 208. The public staff did not propose Schedule LL in that docket, did they?
No, we did suggest that a tariff might be a good option that should be considered in the next general rate case.
And the public staff actively participated in the comprehensive rate design study that DEC witness Jonathan Byrd testified to. Is that correct?
I can't testify to that. That's not anywhere in our testimony. We did not participate actively in that study.
It's your testimony that the public staff did not actively participate in the
Public
rate
staff
design
may,
study?
but This witness panel may have been involved, but that wasn't part of our large load analysis.
Were any of the three of you on the stand today involved in that comprehensive rate design study?
I was not.
I was not.
I was not. I think a lot of this, again, could be directed to witness David Williamson to provide some clarity.
And they are directed to you because you are the panel sponsoring this proposal, but thank you for that. So the aggregation provision in your proposed Schedule LL would apply to loads, quote, at either a single site, at multiple sites within 1 mile of each other, or from a common service point. I want to ask a question about that testimony. Would multiple metered loads of an existing customer be aggregated in order to force a customer onto Schedule LL under your proposal?
If they met those requirements, yes. If they were at one site, yes.
You testify, I believe it's page 6, but your testimony's been corrected twice, so bear with me if that's not precise. But you testify on page 6 that the public staff recognizes the substantial economic benefits that developments requiring large load electric service bring to North Carolina, including but not limited to capital investment, job creation, increased state and local tax revenue, increased demand in the local economy, infrastructure improvements, and economic stability, correct?
Yeah, the benefits can include those things you mentioned, yes.
And you acknowledge that those benefits are, quote, vitally important to our state's economy, correct?
Yes.
And you also acknowledge that under certain circumstances, large load development can lower average system costs by creating more megawatt hours across which to spread fixed costs. Is that right?
That could happen if a large load's able to, use more megawatt hours, but not require substantial grid investments.
In other words, there could be a scenario in which such a customer puts downward pressure on rates for other customers.
That could happen, yes.
If I could elaborate on that a little bit, there's been multiple times in this hearing discussion of the potential benefits that large loads could provide. And I'm not contesting that our testimony doesn't say that under certain circumstances that could happen. But the public staff has done additional analysis on this large load impact analysis that Duke presented in the CPIRP. We filed it in our DEP testimony. We also have a potential cross exhibit number 45, which is a white paper that summarizes the results of that analysis. But if the commission wouldn't mind, I'd like to expand a little bit on our concerns regarding those benefits to highlight the fact that it's only under certain circumstances, and we're concerned that those circumstances may not necessarily come to fruition.
And Presiding Commissioner McKissick, I would just say if Counsel for Public Staff wants to direct this witness accordingly on redirect, that is certainly within their purview, but right now I'm asking witnesses questions on cross-examination and would like to continue.
I think Dr. Weaver's response as a member of the panel was appropriate since it was directed explicitly to the language in their testimony on page 6, which you duly noted and identified as additional benefits. I think it's simply an explanation that more fully responds to the panel's concerns relating to that particular language that's in their pre-file testimony.
Thank
So I
you.
would provide her with an opportunity to continue to provide any additional comments that you believe are relevant to the questions that have been asked specifically.
Thank you, Commissioner. I really appreciate it. So just to level set for everyone, this analysis that Duke conducted for the CPIRP is attempting to compare the costs of incremental generation and transmission infrastructure to the expected revenues for a specific set of large load customers. And it does that on an annual basis and then sums up the net benefit or cost of those different amounts. And we have a variety of concerns, one of which is that the values in this analysis are nominal. So they're a little bit overinflated. They're not going to account for the time value of money or inflation. But we have three major concerns I'd like to address. So the first is the timing of the generation assets in this analysis. The analysis is based on the preliminary base portfolio from the CPIRP, which, as the Commission knows, is not the actual request that Duke put forward. The NTAP moves some of those gas resources forward in time, and that contributes to a more expensive portfolio. The NTAP is $2 billion more expensive than the base portfolio. And we showed that just simply moving the timing of those gas resources results in a net decrease of $500 million of that benefit. And more critically, if you have that cross exhibit open in front of you, that first figure, it shows that the timing of those benefits is drastically changed. So for the first 7 or 8 years, there's a net cost to customers, and it's going to take several years before those benefits accrue enough to break even effectively and see those benefits. So they may occur eventually, but they're not as immediate as what Duke has expressed. Additionally, that analysis is specifically looking at certain gas generation assets. It's not considering the cost of the whole system to serve that energy. So it's effectively discounting the costs associated with the energy to serve those customers. It's looking at the cheapest, most soon available units, not solar, not battery, not nuclear, not any of the more expensive units. It's additionally not reflective of the additional build out that might be required. As we saw in the rebuttal forecast that Duke proposed, there's a lot of additional build out, and this is only looking at the specific units in the preliminary base portfolio. And then additionally, with those gas generation assets, it's not including all of the costs that those generation units would require. So there was a lot of discussion in the CPIRP about liquid natural gas. I believe its CC units 4 and 5 would require either liquid natural gas or significant pipeline expansion. Those costs are also not included and would significantly reduce the benefits. And then lastly, the public staff conducted an additional sensitivity analysis based on the assumed demand. So Duke's analysis assumes a 95% demand that those customers it's looking at are going to be operating 24/7, 365 for 15 years at 95% of their contract demand. And we just didn't feel that that was realistic. So we conducted a sensitivity that was the minimum bound. So right now, the HLF tariffs minimum billing demand is 75%. So we repeated the analysis, assuming a 75% demand, recognizing that that also maybe isn't realistic, but it's a minimum bound on what could happen. And we found that that did not produce enough revenue over the 15-year period to fully cover the costs of that incremental generation and transmission infrastructure. So that was a net cost of $1.8 billion in that sensitivity. So I just wanted to highlight for the Commission that under certain circumstances, there may be benefits. These customers are going to be providing revenue, but that timing is very important. And this analysis was very sensitive to certain assumptions that were made. So thank you for the opportunity, Commissioner, to elaborate a little further.
And Dr. Weaver, this is not a resource planning docket, correct?
No, ma'am, it is not, but it was referenced in Duke's testimony multiple times, the CPRP and this analysis that they conducted.
But here, we are here for a cost recovery proceeding, and this is where the rubber meets the road in terms of rates and how costs get allocated and how revenue is apportioned to customers, correct?
But Duke's, in rebuttal in this case references that study twice. The testimony of witness Timothy Duff and the Bird Beverage rebuttal. So Duke is using the results of what Dr. Weaver just quoted in this rate case.
And I would highlight that this is just really highlighting the importance of what we're doing in our proposal for the large load tariff and these ESAs. It's just highlighting that, you know, there are these potential costs and we want to make sure that large load customers are paying their fair share of those costs.
And you testify that the public staff met with multiple large load stakeholders. Is that right?
That's correct.
You don't mean to imply that the public staff speaks for any of those stakeholders, do you?
We represent those large load customers. They're customers of the system, so we represent them, but we're not pushing forward their agenda in this testimony or in this rate case.
And perhaps that's why 285 minutes of cross time has been reserved for this panel.
I can't speak to the minutes reserved.
So back to the comprehensive rate design study, recognizing that the three of you were not involved in that process. Did you hear Mr. Bird's testimony that a couple of things came out of that process, including but not limited to Schedule HLF?
I heard him testify. I can't remember everything that's happened. I can't remember all the testimony that occurred last week.
Is it your understanding that one of the other results from that study was that non-residential customers were forced to move to mandatory time of use rates?
I don't remember that.
And going back to the change in the public staff's proposal that you testified to in response to some questions from Mr. Josie, the change in your position occurred between when the public staff filed its testimony in the DEC rate case on May 29th and last week on July 6th, when the public staff filed its testimony in the DEP rate case. Is that correct?
I think it was July 9th. Whenever, but that was in our DEP testimony that we filed last week.
And so it's fair to say that over the past 6 weeks or so, the public staff's proposal has changed.
That's correct.
And if the commission was to order that a stakeholder process ensue to further investigate and evaluate potential options for large load rate design, would the public staff be willing to participate in that process?
Yeah, we would participate if the commission decided to hold that process.
If I could elaborate a little bit on that as well, we would of course participate, but you know, we're urging the commission to consider this in this case because of the urgency of the issue. As the commission has seen, this is something that's rapidly evolving, and we believe that this is our, you know, soonest opportunity to handle this. That doesn't mean that the tariff can't be changed in future rate cases, but we believe the time is now in this docket to handle this issue.
If I might add, on page 12 of our testimony, we talk a bit about the E100 sub 208 proceeding comments, and starting from line 7, we say, in its reply comments filed on September 4th, 2025 and sub 208 proceeding, Duke stated on page 5 that other issues related to cost allocation and tariff design are more appropriate for consideration in future rate cases. And consistent with this, with Duke's statement, we believe that a rate case is the appropriate proceeding to implement specific requirements related to providing electric service to large load customers. So just further highlighting some more of the things that my fellow panel mates have mentioned.
And Dr. Singadzi, I am glad you mentioned that because I want to ask some questions about how a technical conference is different from a stakeholder process. Have you been personally involved in a stakeholder process on behalf of the public staff?
I personally have not, but I believe my witness mates can speak a little bit more to that.
And would you agree with me that a stakeholder process is less formal than a technical conference, which happens in this room and which is transcribed on the record?
I'd agree, stakeholder process is less formal, yes.
And perhaps a stakeholder process that is not happening on the record in this room will lead to more candid conversations and potentially a more collaborative, hopefully consensus-based approach.
That could happen, but like we've said, because of the timing involved, we've had electric service agreements in just a little over 2 years of over 6.7 gigawatts, a huge number. Duke Energy's two largest power plants are the Oconee and Roxborough plants. Those are very large power plants. Total, those two power plants combined are only 5 gigawatts. And when I say only, I say that in comparison to the 6.7 gigawatts that Duke Energy has signed in electric service agreements in just a little over 2 years. So we think we need to move quickly. And we recommend that the commission adopt our tariff.
And North Carolina prohibits unjust and unreasonable discrimination in rates, correct?
Yes.
Thank you. Nothing further.
Okay, this might be a good point for our morning break. It's this point in time, it's 10:51. We will adjourn approximately 11:01. want to note that Commissioner Vanderbar is here today. He's been here since we convened at 9:30 a.m. He is continuing to experience an ongoing family emergency that could call him to be displaced from time to time. So I guess bring that to the attention of those who are here today, and we hope that everything works out well for him. I see Chair Brawley has not yet returned. Let's give him a minute before we restart. No, I will not start without you. We're always going to wait for Chair Brawley to enter the room. All right, and next in the queue is CUCA, and I will state at this time, we're going to have a hard stop at 12:30 for lunch. Okay, so that is a hard stop, regardless of where we are. CUCA, the
Thank you.
witnesses are available for cross-examination.
Thank you, Presiding Commissioner. Panel, Marcus Trayton for CUCA. Try to ask you some questions from the perspective of my client, which is an industrial trade association. If you would turn please to page 53 of your testimony. I don't know that you necessarily need to be there, but
Page 53. It was 53, is that correct?
that's correct. And essentially between lines 5 and 14, your testimony contends that DEC included certain costs associated with the large load facilities and the revenue requirement in this case, correct?
Yes, that is correct. Based on our discovery and DEC's own classification of facilities that were solely for serving particular large load customers, and also facilities that had some mutual benefits but were caused by these large load customers, we were able to come up with those numbers that you've or that testimony there that you've referenced.
Okay, and I believe that DEC disputes aspects of that, and I don't want to get into that dispute, but the point I'm trying to tease out is the nugget of your concern here is that the contracted megawatt hour sales from those customers are not included in the billing determinants used to set rates. Is that correct?
We didn't really testify about billing determinants.
Well, there's a mismatch between revenues and costs. Isn't that your fundamental point?
Yes.
Okay, and so even if a particular customer were to commence operation during the pendency of the proposed MYRP, the billing determinants which are used to set rates in a multi-year are not adjusted to account for the customer growth. Is that correct?
That's not in our testimony. We're talking about billing determinants and customer growth. We didn't really testify about that.
Mhm. Well, that's where the revenue is coming from in the rates, correct?
When customers start taking service and using megawatt hours, yeah, they'll be paying Duke energy charges, demand charges, and customer charges.
And I've correct me if I'm wrong, but I believe your point is that those revenues would not come in until the next rate case. Is that correct?
Well, no, the customers start paying for service the day they take service.
If I might add, I think with these large load customers as well, we had some discussion earlier about load ramps, and how particular load ramps can have impact on various quantities of revenue. Hence why we had some discussion even about, let's say, the benefits that might be actualized to the system by having various large load customers on the system, depending on the service that they're able to provide from their stated ESA. So The timing of the load ramp over time, in short, can have impact. And I think my witness, fellow witness might be able to add.
One thing I could add is, I mean, even if the customer has a load ramp, the day it begins taking service, it'll pay for that service, but the load ramp is a lower use by the customer, so lower payments for demand and energy.
Okay. All right. Well, let me shift gears. The general risks that you're trying to solve for here arise principally from, I think, what you described as the unprecedented scale and speed of data center type loads. Is that correct?
Yes,
And traditional industrial customers have been part of DEC's load for decades, and the system has grown organically to serve them, correct?
in past decades, the system has grown to serve a slower pace of industrial growth.
If you could turn to exhibit, I guess it's 2, the large load, your proposed large load tariff.
Exhibit 3.
Okay. I'm looking at the corrected, I thought it was 3. I'm looking at the corrected version. It says exhibit 2. Anyway, it's schedule LL, the large load tariff. Are you there?
Yes.
Okay. So I believe it was established with the cross-examination by Ms. Crest. I won't repeat that, but the proposal would apply to incremental expansions by existing customers of 50 megawatts or more, so long as the load factor is satisfied.
Yeah, any new customer of 50 megawatts or greater and incremental increase of 50 megawatts or greater would require a customer to be on this tariff.
So an existing manufacturer that seeks to expand its plant by 50 megawatts could be, after January 1, 2027, could be swept into this schedule.
Yes.
Okay. And so that would include the new requirements, which have, financial implications, including the 10-year minimum contract for the lower tier, 75% minimum billing, exit fee, notice obligations, mandatory curtailment. All of that really would be, those would be new requirements for an existing manufacturer, correct?
Yes, and we would recommend this because Duke Energy is going to have to make investments to serve that additional load. And we want to make sure that all customers are protected if that customer terminates load or reduces its load and Duke is unable to recover its investments.
And just to be clear, it would be an existing customer that is growing by an increment of 50 megawatts, which is a significant amount of load.
And wouldn't you agree that the imposition of these new risks and costs might cause a manufacturer in this situation to forego industrial expansion?
We can't say up or down whether a customer will make his decision based upon this tariff. That customer is going to have to make its own decisions, and we have to make our recommendations to protect all customers.
And you've not conducted any analysis about that sort of potential adverse effect, correct?
No, we have not.
Your availability clause, sticking with Schedule LL, says that you would propose to measure demand based on a 15-minute demand interval. Is that correct?
That's correct.
And this means that, as I understand it, you'd average demand over 15-minute periods and then take the highest measured demand in those periods. Is that correct?
Yes, that'd be over a 15-minute aggregated demand. Yes, that'd be.
Okay. And And the OPT dash V tariff, I call it opt V. The opt V tariff uses a 30-minute demand interval to measure demand, correct?
Duke, yeah, under DEC's current OPTV, yes, it's using 30 minutes.
And the high load factor tariff also uses 30-minute demand.
Give me a moment, I'll check that tariff.
Well, just subject to check.
Subject to check, yes.
And wouldn't the shorter demand period penalize facilities with intermittent or variable loads, for example, a manufacturer with a batch process?
Well, we are concerned about highly fluctuating loads. A large load customer that fluctuates load frequently will have an effect on the grid that Duke is going to have to match. Also, we have learned about artificial intelligence training data centers, and they have highly fluctuating loads. Duke has to have assets in place and have grid management in place to deal with a highly fluctuating load.
Okay, well, and typically a data center by itself would have a flat, consistent demand, would it not?
I'm sorry, say that again, please.
Typically a data center by itself would have a flat, consistent demand.
No, we can't testify to that. Some types of data centers can have fluctuating loads.
With respect to the curtailment provision in here, as I understand it, you have framed your proposed curtailment provision in part based on EPA limitations on diesel generators when they can operate for maintenance and testing. Is that right?
Yes.
And your rationale would assume that the customer has on-site backup generation capable of carrying the load during the curtailment.
We're not assuming that, but we have to have curtailment provisions to protect the grid. It's up to the customer whether it wants to have on-site generation or actually reduce its operations.
And to be clear, our provision is mirroring the provisions that Duke has already established in its ESAs.
And would you agree that manufacturers often or perhaps typically don't have backup generation?
I can't testify to that. But the customer should be aware grid emergencies can occur regardless of what Duke plans to do. Weather events, other types of events can take out service. So the customer has to be aware of that and be prepared for that.
And Mr. Trey, if you could speak up a little louder or speak in the microphone so everybody can hear you. That's here part of the DS as well as in the back of the room.
Thank you.
Thank you.
And have you done any assessment of the cost associated with installing backup power facilities?
No.
Estimates that I've seen for natural gas backup system for 50 megawatt facility is between 60 and $90 million. Does that sound right to you?
I can't testify to that.
And have you considered whether the imposition on this sort of requirement on manufacturing might effectively wall off North Carolina for new industrial recruitment?
No, we have not done that type of analysis, but like I said a minute ago, we have weather events, hurricanes, tornadoes that can take out power for many hours, sometimes days. That customer is going to have to determine what sort of risk it wants to take, whether or not it installs backup generators.
Would the panel be open to clarifications designed to help minimize potential adverse impacts on manufacturing companies from this proposal?
We recommend our tariff be implemented as planned. If Duke Energy wants to petition for a change, it can, but we would have to consider it. But right now, we are recommending our large load tariff as stands.
On page, changing gears here, on page 33 of your testimony, you referenced the continued availability of existing tariffs such as Rider PS and the on-site generation service program. Do you recall that?
That's correct. Yes.
Now, the on-site generation service program is an option for utility ownership of backup generation.
Yes,
On page 35 of your testimony, you referenced the president's ratepayer protection pledge.
I'm sorry, just give me that page number again.
35.
Give me a moment, please.
Which version of the testimony are you referring to? I think that may make a difference whether it's on page 35 or not.
I've got our original testimony that's on page 19.
Oh. Let's go to 19.
Just for clarity, of the record, it appears on page 19 of the corrected testimony as well.
Okay. Very good.
Thank you. All right. 19, do you see the reference to the ratepayer protection pledge?
That's correct. I see it.
And you see the first element of that pledge is to encourage the ability of data center companies to build, bring, or buy new generation resources necessary to serve the load.
I see that.
Would you agree that to the extent that a customer is able to build their own generation capacity, that bypasses a number of the concerns you're attempting to solve for with your tariff? I mean, they're assuming the risk then of
If a
bringing their own
customer was
generation.
not connected to the grid at all and generated some power, it would mitigate a lot of our concerns, yes.
But there's nothing in your recommendations that would make it easier for a company to actually do this, is there?
No, we haven't addressed that in our testimony.
Shouldn't it be a higher priority to make this sort of option more readily available?
We can't testify to that. No, no one's proposed it in this rate case. We would have to evaluate it and come up with a recommendation.
Okay, I mean, you're making a whole series of recommendations on this issue in this case. Isn't this something that deserves a higher priority?
No, I can't say that. We've made our recommendations and we have not evaluated industry that builds all of its own generation, has no connection to the grid. We just have not assessed that situation.
That's all I have. Thank you.
Thank you. Let's see if next in the queue is Environmental Defense Fund.
Good morning, Ben Smith from the Environmental Defense Fund. I'm going to ask you a few questions. I appreciate my client's sponsored testimony from Tim Linnell and Karan Pol at Daymark may be directionally aligned with a number of your panel's testimony in some ways. So I'm going to be exploring where there's some differences. I'll start off with, have you all read the Linnell Pol pre-file direct testimony?
Yeah, we've read it, but don't have it memorized.
Sure. Your proposed Schedule LL, would you say it provides a bright line of parameters for what types of load fits within this tariff?
Yeah, it's a bright line, a new incremental load of 50 megawatts and up and an 80% load factor.
And new customers that qualify would be under your proposal placed in this tariff automatically?
Yes.
One of Daymark's concerns about is to do with these bright lines, and how does the public staff sort of analyze and address concerns with respect to potentially dynamic customers or new customers who can potentially control considerable load, potentially have numerous customer sites, and might be able to sort of work around those bright lines? Did you all talk about that as you developed LL?
Yeah, we cover that in our testimony. Don't have the exact page, but we do address like customers gaming the system and trying to bypass the requirements. That is a concern that could happen. We want Duke Energy to monitor that situation and report if it suspects customers would try to game the system and get around the requirements, but still create the need for lots of assets on Duke's part.
So if you found some amount of gaming the system, for instance, if a customer or customers figure out how to run load factor 79.9%, or they build a system of load centers that are at 49.9 megawatts, for instance, would the public staff continue to sort of study and sort of figure out how to deal with that kind of gaming the system going forward?
Yes.
And I think the struggle is there that you have to draw a line somewhere. So this is where we chose to draw that line.
And speaking of drawing the line, talking about the type of customer that falls in, and you all have been asking questions about this, but the distinction between large, either industrial or manufacturing load with a high load factor versus data center load. Do you all have concerns about the potential for sort of cross subsidization intra tariff sort of class because of these bright lines that you've established and potential for, not accidentally, but scooping up a large manufacturing and industrial load?
I didn't understand the last part of your question.
Yeah, it was clunky. So if a hypothetically, if a large manufacturing or industrial customer came online with a site and it was over 80% load factor and over 50 megawatts, it would fall within this tariff.
That's correct.
However, there might be some distinctions in the way they operate versus a data center with this computational load. Is that right?
That could happen, yes.
So how do you all address concerns about potentially cost causation principles within the sort of tariff class that you've described there?
We did not address any kind of cross subsidization. We're mainly addressing assets that Duke has to build to serve that customer and cost recovery of those assets.
And if I could add, that is an issue that we're aware of and have thought about, but part of the challenge here is a lot of these customers maybe aren't taking service yet or are just starting to take service. So when we're talking about cost causation and cost allocation, some of that is still hypothetical. And so those concerns are maybe something we'd continue to look at in the next rate case when those costs are actually coming in and being included in the rate case.
Thank you. Are you all familiar with the concept of ring fencing with respect to large load?
We are aware of the concept.
And with respect to some large load tariffs, some utilities such as Excel have built ring fencing into their respective large load tariff. Are you aware of that?
I've heard of some, but I'm not any particular utility.
Did the public staff, when they developed Schedule LLs, the Schedule LL proposal, did they consider having an adder or some other instrumentality to allow ring fencing to be included as an optional addition that might allow these LLCs to make choices on their power investments?
We discussed it. We decided not to. Ring fencing is a complicated financial arrangement and very difficult for Duke to track what's inside the ring fence and what's outside of the ring fence. We did not recommend it in this case.
Okay, and actually I'll leave it there. And the way I read Schedule LL, you all think about curtailment to some degree, but I wanted to know, did you think about incorporating a customer side demand response or load flexibility option for the customers to opt into?
No, we did not. And we do review demand side management programs proposed by Duke, and Every 2 or 3 months, we do have a stakeholder meeting, and anyone who wants to propose new programs, DSM or energy efficiency is welcome to do so.
And so it'd be something you all would consider adding later on if it
We would
was a-
consider that, yes.
Last question. You have 10-year contract term, I believe, under Schedule LL for the, I think 50 to 100 megawatt. What was the basis for that 10-year number?
We did not do any mathematical calculations, and like we've stated, we want to encourage businesses to come to North Carolina. We did not want an extensive term, like a 20-year term. We thought that'd be too restrictive to businesses, but we want some amount of time to be able for Duke to recover its investments. Like I said, there's no calculations, but it was a balance of serving the customer and having Duke Energy recover its asset costs.
No further questions.
Thank you. Next in the queue will be Google.
Good morning.
Good morning.
Heather Fennell of the law firm of Brooks Pierce on behalf of Google. Thank you. I'm going to start with one question on curtailment. I'm happy for anyone on the panel to answer. The counsel for Amazon asked several questions on curtailment. Do you recall?
Yes,
And you referred him to several of the definitions that Duke uses, correct?
well, it referred to some that are in the existing ESAs.
Is it fair to say that the public staff is aligned with Duke on when curtailment would be used? But the difference in your proposal is how long curtailment will be allowed to be used.
And Ms. Fernell, if you could speak a little louder, just so everyone can hear you. Thank you.
Excuse me. Just
What do you
restate it.
mean, difference with Duke in what it's had at CSAs?
Your proposal in Schedule LL. So when you're gonna, when curtailment would be utilized? For example, if it was an emergency, you referred to the Duke definition. Is that true?
Yes, it could be used then for extreme economic conditions.
Okay. So let me put it this way. Are you envisioning that the curtailment would be used more often under your proposal than for Duke? So are you actually proposing it differently than what Duke is utilizing it now?
I can't say it would be used more. It depends on the facts during that day. It could be used more under our proposal.
The maximum is the same still.
The maximum, could you?
There's a limit on the number of hours that could be curtailed in a given year. But maximum number of hours is the same.
Yes. Okay. Moving on, I'm going to ask questions about your CIAC proposal. And I'm just seeking clarity on what you're proposing, okay? So turning to page 38 of your second revised testimony, that's the page numbers I'm referencing. This is your figure 3. This is your chart. So this is where you note that the public staff is proposing that DEC update its contribution in aid of construction to ensure that revenues from the customers are sufficient to recover the total cost of required facilities and the typical cost to serve. So excuse me, this quote's actually from page 39.
Yeah, I see
But
that.
you're referencing this chart. Is that correct? So can you tell me a little more about the types of facilities you're referencing in this box on the right on page 38? The facilities that benefit both the LLC and other customers?
It could be just about any assets, like a example, a substation transformer or a transmission line that could benefit a large load customer and other customers.
And I can add, these are assets that Duke and their own discovery has mentioned to provide mutual benefits to the system. So they were caused for the majority of these, let's say, facilities that benefit both the LLC and other customers. They were caused by these large load customers being put in place, but the transmission assets or the distribution assets are having some potential to provide benefits to the larger system. there might be some murkiness there in terms of understanding what benefits might be provided to the bulk system. There could maybe be some more investigation to that. But these are things that Duke has mentioned are things that provide benefits to the system.
Are they limited to transmission and distribution? Or are you intending this to include other facilities?
Within the scope of what we testified to, we mainly focus on transmission and distribution. There is a very small amount that was actually pertaining to generation for DC, but it's relatively small when compared to transmission and distribution.
So I believe, Mr. Lucas, you actually clarified this earlier, but I'm going to ask for the facilities, for these types of costs that benefit both the large load customers and other facilities. Are you intending that the large load customers bear all the cost or only the portion of the cost that they are benefiting? from that?
They only pay the portion of the cost that they cause.
That they cause or that they benefit from?
It's the cost that they cause.
So are they bearing the entire cost of the facility?
No, if some of that facility is intended to serve other customers, then they would not, the large load customer would not pay that portion.
Have you provided guidance how to make that determination? Can you-
No, Duke's, that's going to be on a case by case basis by Duke Energy.
So looking at page 45, lines 6 through 7, this is where you state that you're seeking to change how CIAC charges are determined and what portions of revenue from the customer should apply to CIAC. It's on line 6 through 7. Again, I'm
Page
sorry, I'm on the
45.
second corrected.
You said, sorry,
I'm sorry.
line 6 and 7 of page 45?
Yeah, of the second corrected. I think you had.
Yes.
So there's really two parts to this, determining the cost the large load customer should bear and whether the revenues received are sufficient that they're paying their fair share. Is that a fair statement?
Yes, that is a fair statement. And if I may, I might provide a bit more context. I think with regards to CIAC or contributions in native construction, DC has a lot of discretion with regards to whether or not CIAC must be paid by a large load customer to contribute towards revenue. They have a lot of discretion with regards to various interconnection costs that might need to be needed. Whether particular studies are needed. So with regards to CIAC, we just have some concerns that the traditional way of doing things may not be capturing the costs that some of these large load customers might be putting up front. And we discuss a little bit about how, and one thing we propose is that if we were to put in a CIAC over, let's say, the course of an ESA, that would account for various aspects of the dedicated facilities that they're causing. It would be a relatively small percentage with respect to their annual payments for typical bills over the course of their ESA. So we came up with a number, I believe, a few pages later of about 2%. If you give me a moment, let me see real quick. Yes, so on page 55, we mentioned that if this were used as a system of providing some way to keep customers whole, providing a CIC for the dedicated facilities that would be relevant to a particular large load customer, and we give this example from table 3 on page 54. It would only add approximately 2.3% to this large load customer's annual bill. Yes.
Thank you. On that note, going back to page 43, the bottom of the page, lines 19 to 20. The public staff is stating that if there's not sufficient revenues to serve the LLC for the costs that they have caused or triggered, the cost will be recovered via a required facilities charge. And you state that this could either be paid upfront or over time. Is that correct?
That's correct.
Okay. So one of the concerns that the public staff has stated is about the timing mismatch between when Duke or potentially other customers are paying for these facilities and when the revenues are coming in. Can you help me understand how this proposal to either pay them upfront or over time helps? Is this intended to help with this timing mismatch? Or is it not?
I don't think that proposal was intended specifically to help with the timing mismatch, but this is more reflective of what happens on the generator side. In generator interconnection agreements, there's often the option to either pay upfront or over time. So we're sort of mirroring the way that works on that side of things.
But do you agree this is the provision in your sort of suite of the large load tariff, the revisions to the ESA, and the revisions to the service agreement that is intended to capture the cost that these large load customers are causing the system? Is that correct?
Yeah, it's supposed to recover all the, what Duke's does not anticipate recover from other methods. Yeah, these provisions we put in here are to make sure Duke is made whole.
Okay. So if the required facilities charge is not the mechanism that is addressing the timing mismatch, is there another provision that I've missed that is what the public staff intends to capture this timing mismatch between when costs are incurred by the utility and when these customers pay?
Give me a moment, please. Could probably talk more if we go to a confidential session, where we talk about our Exhibit 4 that has more detail on the provisions of collecting money from that customer to make sure that customer pays us full cost of service.
Okay. Why don't we put a pin in that for 1 second? I have questions on Exhibit 4 and we can figure
Okay.
out if we need to go into confidential session for
Sure.
that. Okay. So has the public staff developed a proposal for how Duke or DEC should change its CIC methodology?
Well, yes, we're asking Duke to not socialize the costs, and also our Exhibit 5. Pull that up, where we do talk about that some for the service regulations.
Let's flip there. I'll tell you where it is.
Okay,
I believe.
it's page 3 of 16 in our
Yeah.
Exhibit 5.
So I believe you're referring to paragraph 6, transmission, distribution, service.
That's
the-
it,
the
yes,
Second paragraph.
yes.
So this is where you say for customers greater than or larger than 50 megawatts, Duke shall or DEC shall determine whether a CIC or cost and aid of construction contribution is needed, and it will require a customer specific study based on the cost of service and take into account the approved tariff rates. This is the paragraph you're referring to.
That's right, that's correct.
But to be clear, you haven't created a proposal. You're asking Duke to revise its proposal. Is that correct?
I'd say based on some of the things I mentioned before with regards to that example with, I believe, table 3 on page 54, and then also mentioning a little bit more about how if, let's say, for example, if I can break this down for you to provide a bit more clarity. In table 3, we're going over an example of a large load customer with various allocation inputs of key importance, let's say contract demand, load factor, applied tariff type, transmission interconnection costs, distribution interconnection costs, and ESA term. And what we're saying here is, if we account for all those costs with respect to transmission and distribution, and we essentially, these are rough numbers, but if we decide to annualize those dedicated facilities, transmission and distribution costs over the course of, let's say, a 15-year ESA, rough numbers, we're not accounting for, let's say, net present value of money or time value of money. The cost each year that we could have them pay would be about 2% of their annual payment for regular operation. So to clarify, what we do provide as an option to look into is applying a CIAC over the course of an ESA over time that would address the dedicated facilities, whether transmission or distribution plant, that would be pertaining to a particular large load customer.
Just to clarify, going back to your chart on page 38, we're not just talking about dedicated facilities, we're talking about required. So we keep using these two terms.
Yeah.
And you're actually talking about required facilities, not just dedicated facilities. Is
That's
that
true. They
correct?
have to,
Okay.
a large load would have to pay its portion of the required facilities that Duke has to build.
So accepting that on page 55, you've done a calculation that the dedicated facilities are about 2.3%. You're actually asking for a larger potentially. And what I'm asking is how do you, what is your vision for what this policy is going to look like when Duke comes up with it? Is it going to be revisions to their service regulations? Is it going to be a separate standalone new tariff? What is this going to look like? You have what I would characterize as guidance for how to change the methodology. But at this point, there's not an actual methodology. Your testimony directs Duke to go develop the methodology. Is that correct? You've asked them, go develop this. If the or you're asking the commission to direct them to do that.
Well, I think everything we've put in our large load tariff, our ESA application, and the service regulations provide enough guidance that Duke can take that, analyze a large load customer. We provide an example in our testimony, but these large load customers are so varied. The smallest will be 50. We've had large load proposals that are over a gigawatt. So Duke is going to have to take this guidance, and we can't specify how each one is going to be, if it's an 80% load factor or 95% load factor, but Duke's going to have to evaluate what kind of CIAC would be appropriate for that customer.
All right, I want to talk about your exhibit 4. And I'm going to acknowledge your exhibit 4 is marked confidential. It is Duke's Form ESA with your revisions. I was hoping that we could ask questions. I asked Mr. Axis last night.
Yes, thank you.
I'd like to ask questions. I'm just going to tell you what I'd like to do, and then you can talk. That's okay.
I might be able to make it easier.
Go ahead.
So we were asked, this relates to our Form ESA. It's an attachment to Exhibit 4. Parties for a number of the council for a number of the parties asked us yesterday if we would consider allowing disclosure of the Form ESA, no customer specific provisions for purposes of conversation here. While it was previously designated as confidential, that's why public staff testimony designated as such. Based on further engagement with the business team this evening and this morning, we confirmed that it would be acceptable to allow disclosure of the Form ESA in those terms to allow fulsome discussion of those topics in the hearing room today. If that's okay with presiding commissioner and council for public staff.
I would have no objections to that redesignation and classification.
Thank you. I appreciate that. So we can talk to our heart's content about exhibit 4.
Well, let's see what public's.
Yeah, I believe that Mr. Drack has the correct characterization of the confidentiality designation that we put on exhibit 4. I would like to just ask the panel, since they are the parties sponsoring this exhibit.
Yes,
if
I
they
think
can
you are
confirm
correct.
that exhibit 4, if Duke is no longer designating it as their ESA application is confidential, does the panel have concerns with exhibit
Sorry,
4?
just to confirm, based on what you were mentioning, is this the form as Duke originally framed it, or is this the form as the public staff or
This is
panel
your-
presents it?
Your exhibit 4, which is their ESA with your revisions. And if it
Okay.
helps, I'm only going to discuss your revisions.
Okay, and we've agreed that this is okay to discuss.
Correct.
Okay.
That is what I'm understanding, if the panel has no objections. Does the panel have any objections?
No.
All right, so it seems like everybody's on the same page, so
Yeah.
Attorney Fennell, you may proceed.
Okay. Turning to exhibit 4, I'm looking at page 6 of 13. And this is the required facility charges. And I believe, Mr. Lucas, this is what you wanted to reference earlier. Paragraph 16 and 17.
Paragraphs. Okay.
Okay. Yeah,
Yeah,
paragraph.
okay, I'm there.
So paragraph 16 is very similar to what we were just talking about in the service regulations, where it's providing what I would call guidance to how the CIC calculation should be calculated. And then paragraph 17, middle of the paragraph, has like a list of facilities. Do you agree with that?
Yes.
Okay. Did you want to go back and state, you had something you wanted to say about this earlier? when I was
Could you
refer-
repeat that question so I could?
Not sure I recall the question. that
Okay,
you were- Let me look.
Well, I talked a little bit generally about this. You were asking about some of the details about
Yes.
CIAC. And how would Duke apply this for one particular customer? If a customer shows up, I want service, I'm a large load customer. Well, just for starters, we want the exhibit 4 made public so that all potential customers know that they're being treated fairly. They know upfront what's expected of them. And we do add some details in those paragraphs 16 through 20 about what Duke should do to make sure that customer pays its fair share.
Okay. And again, what's in 16 is very similar to what's in the service regs, and that's what we just read. Paragraph 17 discusses, middle of the paragraph, there's a list of transmission distribution facilities there. Do you see that?
Yes.
Is this an illustrative list or a comprehensive list of the type of facilities that can be assigned to an LLC that will be paid for under the required facilities?
Yeah,
charge?
it's illustrative. It's the beginning of that sentence says, these needs can include but not be limited to, and then it lists them.
So there are more charges, there are more facilities that could be included.
Yeah, we try to think of all types of distribution and transmission equipment in case we left something out that would be reasonably considered.
And again, going back, this was stated in your testimony, I can state the page and line number if you'd like, but this is going to be either paid upfront or in their charges when the customer comes online, correct? This is it's referenced in your tariff, the extra, the required facilities charges. So you're either paying it upfront or over time.
That's correct.
Okay. So again, I'll ask, this is, I believe, what you wanted to reference. Going back to your timing issue that the public staff has raised, is this the part of your large load tariff suite that addresses the timing component? Or stated another way, is there another provision in your large load tariff, your ESA revision, or your service regulation revisions that addresses the timing issue you raised that you're aware of?
We believe it's taken care of here in this paragraph 16 through 20, and in our service regulation proposed changes.
But to be clear, just like with the revenues under the tariff that they're paying now, it actually wouldn't kick on until they start taking service. Is that correct?
Are
there-
Well,
Unless they pay upfront.
unless they pay upfront.
There are also additional provisions in the tariff that we discuss in testimony, like credit security payments and these advance notice requirements and termination damages, as we've discussed, that while they may not, move when the payments happen to when the costs are incurred, they help account for some of that potential stranded asset risk and financial security.
Okay, thank you. All right, one last line of question, different timing issue. So as I just stated, pulling all this together, the public staff has recommended that Duke revise its CIC methodology. You've recommended your proposed Schedule LL, revisions to ESA, and revisions to their service regulations. So this will be used to determine that the revenues used to calculate the amount of the required facilities are covered by the LLC and what the required facilities are. Okay, that's what 16 and 17. And this will be determined the amount of the required facilities charged under the proposed tariff.
Yes.
Is correct?
Yes.
All right. So the commission's final order of this proceeding is expected sometime before November 16th. Is that correct? That's when the end of the suspension period is.
Okay.
So, yeah. So, and as I asked before, how would this methodology that you're directing Duke to develop, how will that get approved by the commission? Like, how will it appear, in what form will it appear, and how will that, if this commission accepts your recommendation and directs Duke to do this methodology, in what form will it appear before the commission get approved?
I don't understand the question. I mean, if the commission adopts all the changes we've made, starting January 1st, 2027, Duke would implement this and start working with each customer that approaches Duke, each large load customer, and implement this, start developing a CIAC and dedicated facilities charges and required facilities charges.
So all of this together is sufficient, and there's nothing else that Duke is going to produce to give guidance to customers about how this calculation is going to be calculated, or this commission?
No, it's going to have to be on case by case. Like I mentioned earlier, these large load customers vary a lot. So Duke's going to have to take reasonable measures to deal with each one fairly.
So when you tell Duke to develop or to change its methodology, what you're actually directing them to is to use what's in your tariff going forward. And they're not developing a new methodology, they're using your methodology.
Yes.
Okay. No further questions.
Thank you. Next in the queue is Microsoft. And I notice you've reserved 60 minutes, and we're respectful of that. We will stop at 12:30 for lunch. I don't know if you intend to use the full 60 minutes or not.
I will try to be as expeditious as I can, but I do have a lot of ground to cover.
Thank you, sir.
Good morning, rather. Hi, Ben Snowden here on behalf of Microsoft. We'll give me just one moment, please. Dr. Weaver, you discussed a little bit earlier today the public staff sense of urgency to develop a large, I believe it was you, Dr. Weaver, but the public staff sense of urgency to develop a large load tariff. Is that right?
Yes, I mentioned that.
Okay. And the issue of a large load tariff has been on the public staff's radar at least since the technical conference last year. Is that right?
That's correct.
As vitamin before that, I think we put that in our comments filed in August of last year. So
Okay, for over a year then, right?
just about a year now.
Okay. And when did the public staff start putting pen to paper on a large load tariff?
That was during the rate case. Can't give the exact date.
Okay. So, but presumably after Duke filed its
Yeah,
application.
after Duke filed its application.
Okay. And it was only then that the public staff decided that it needed to move forward with proposing a large load tariff?
No, we've thought about it before. We got started designing the tariff after Duke filed its case.
But to be clear, the public staff's proposed large load tariff was not shared with any stakeholders, or rather any large load customers prior to it being filed with your testimony.
Yeah,
was it?
that's the first time we released it was May 29th.
Okay. And on page 14 of the panel's testimony, you will discuss the public staff's engagement with large load customers on the issue of a large load tariff. Is that right?
Yes.
And you say that you discussed the topic of and the need for a large load tariff, and you sought the perspective of large load customers on such a tariff. Is that right?
That's correct.
Okay. And you say that the purposes of these discussions included understanding the needs and risks of that large load customers consider, and avoiding unintended consequences, correct?
That's correct.
Okay, and so I take it from that statement that the public staff believes that it's important for the commission in considering a proposed tariff to take account of the risks that large load customers consider.
Yes.
Okay, and it's important to avoid unintended consequences.
To the
Yes.
extent possible.
Okay. Were you all part of this? I assume you all were part of the discussions with large load customers. Is that right?
I was in some of them. Yes.
Okay. What specific questions did you ask large load customers about a potential large load tariff?
Can't remember any specific questions. It was more of a listening. Tell us your concerns. Tell us what you would expect. And we got different answers from different people.
Okay, and how, if you can say, how did the public staff incorporate feedback from large load customers into its tariff? Can you provide any specific examples?
Yeah. Some customers wanted transparency. They wanted to know as soon as possible what would be expected of them. And that's one reason we want our Exhibit 4 made public. It's the ESA application. Right now, that's all confidential. Others leaned a different way. They wanted more flexibility. They wanted more negotiation of what they could get from Duke Energy to get service.
Okay, so flexibility versus transparency. But in terms of the substantive terms of the proposed large load tariff, did the public staff incorporate any specific feedback from customers on that?
It's hard to tell. We had meetings after public staff met internally after meeting with these potential large load customers, and we considered their input, but I can't tell exactly which segment of our tariff came from large load customer discussions.
Okay, but none of the terms of that large load tariff.
No, not specific terms. That's correct.
Okay. I'd like to talk briefly about the disconnect between Duke's payment of costs to serve large load customers and when the revenues from those customers will start coming in. There's been some discussion of that this morning. Is that right?
That's correct.
Okay. Is it true that, well, you would agree that, and this is reflected in paragraph 13 of the application, discussing refundable advances. It's true, isn't it, that large load customers must make refundable cash advances when they sign a letter agreement with Duke? And here I'll direct your attention.
Yeah,
It's paragraph
14. Okay.
13B1.
Okay, here we go.
And you see here it says, pursuant to the letter agreement between the parties, the customers made an advance payment to the company of blank $1 million, and there are 10 digits in there. You see that?
Yeah, I see X millions of dollars.
Right. So this suggests, though, that those refundable advance payments are likely to be in the tens of millions of dollars.
It could be, and I need to bring up another point.
But I only asked you about
we're talking
provision.
about this. You talk about what's this in this ESA application, and our concern is Duke, as it sits right now, can change this ESA application anytime it wants. It can change it tomorrow. It can change it 4 months from now after this rate case is over. So that's why we developed this Exhibit 4 to have a commissioned approved ESA application.
Okay, thank you for that. Under this ESA application, whether it is as Duke has used it heretofore, or whether it's approved by the commission, customers are required to post tens of millions of dollars in refundable cash deposits when they sign a letter agreement. Is that correct?
Yeah, that's what this version says. But like I said, if Duke wanted to pull that paragraph out tomorrow, it could.
Okay, understood. And those customers don't get interest on those refundable payments, correct?
I'm not aware of that. But what's going to happen is Duke Energy is going to have to start spending money to serve that customer. So it's not like, say it's $10 million, that just sits in the bank and earns interest. Duke's expending funds to serve that customer.
Well, yeah, thank you, Mr. Lucas. And that's really my point here, is that those refundable cash advances do at least help to bridge the gap between the time that Duke begins expending money and the time that revenues begin to be recovered from the customers, correct?
They do bridge the gap. It depends on the amount of the advanced funds and the amount that Duke has to spend to serve that customer.
Okay, thank you.
If I could add also that the refundable advance specifically says it's for customer requested facilities, and I can't say that I remember exactly how that's defined in the ESA, but there are additional costs that Duke is also incurring. So we don't disagree that this is helping bridge that gap, but it's definitely not, filling the gap completely.
Okay, thank you. I'd like to move on and talk about required facilities. And there's been a fair amount of discussion of that. Just to recap, the public staff's position is that where a required facility is intended to serve other customers, the cost of that required facility is allocated between the large load customer and ratepayers. Is that right?
That's correct.
Okay. What about when a required facility is built to serve the large load customer but provides benefits to other customers? Is the cost allocated in that circumstance?
Well, depends what you mean by benefit. Duke's going to have to determine if it's built facilities that do have capacity to serve other customers. Duke's going to have to evaluate what's the potential of that facility serving other customers.
I understand. Yeah. In the public staff's testimony, you do distinguish between those two categories of required facilities. And this would be pages starting on page 36 and 37.
Yeah, I'm there.
Okay. And so you say that required facilities would include dedicated facilities, but also projects caused by the large load customer that benefit multiple customers and or the bulk system. And those include projects that will serve other customers, but were triggered by the LLC, and also projects that are intended to serve both the large load customer and other customers. Is that right?
A better characterization would probably be that facilities that benefit both the large load customer and other customers are facilities that have been put in place due to a large load customer, and they do happen to provide mutual benefits to the larger system.
Okay, thank you, for that clarification. And my question is just whether, with respect to those facilities that you just identified, the costs would be allocated or would they be fully charged to the large load customer?
So from some of our disallowance that we've mentioned in our recommendations, we were trying to focus primarily, if we were looking at figure 4, we're primarily trying to focus on dedicated facilities. So if we're going to page 48 of our testimony, we're primarily focused on dedicated facilities costs. So these are transmission or distribution investments that are, as Duke has mentioned in their data responses or discovery responses, these are costs that are for solely the well-being of these large load customers. We do have then also too, if we look at this figure, values, as you were mentioning, for multiple customers or benefits to the bulk system. So for the scope of this rate case, this is our proposal. You were mentioning on page 38 how it does say recommending going forward the cost of required facilities be recovered from the specific customer they're incurred for. Yes, we listed that out, and we can see the portion of, let's say, the dedicated facilities and required facilities that's covered by the mutual benefits section is relatively small. So we are proposing moving forward, this might be looked at a bit further in terms of, okay, there are costs that are caused by these large load customers. And then there can be a process by which the costs that are supposed to be providing benefits to the larger system and also the large load customer can be investigated a bit further, because there is some murkiness. We're not very sure right now, even if we're looking at, let's say, page 48 If we're looking at this bottom bar that says total, we have 198.1 million for the dedicated facilities, and then there's also 49.4 for the large load facility and also other customers. We're not very sure how much of that money is actually benefiting the larger bulk system or is primarily benefiting the large load customer. There is some murkiness that can be investigated a bit further. And I'll let some of my other colleagues speak more to that.
Yeah, I can give an example. We have some large loads that locate in rural areas. A lot of rural areas are losing population. And if Duke installs facilities to serve a large load customer that may incidentally have some extra capacity, Duke should not socialize that cost to other customers. If a facility happens to have extra capacity, but there's no potential for customers to use it, other customers shouldn't have to pay for it.
And I just want to make clear that because as Dr. Sanganzi said, there's a lot of murkiness about what these required facilities are. To speak a little bit generally, I think the dedicated and required facilities we're talking about are typically interconnection facilities, network upgrades, things that are very clearly tied to a specific project and a specific customer. Obviously, there's going to be a lot more investment in generation and transmission infrastructure to serve these customers. And we're not suggesting that the entire body of those costs be recovered through these EFCs. That is more, recovered through the tariff, and the various other provisions we've discussed will help with the stranded asset risk associated with that broader investment cost.
All right, thank you. So what I'm hearing from you, and I'll try to paraphrase what you all been saying, that with regard to certain required facilities where there may be benefits to other customers, there's a lot of murkiness. It's complicated, and more investigation will be required before we can figure out how we might allocate the costs of those between large load customers and other ratepayers.
No, I disagree. I think Duke is going to have to determine this on a case-by-case basis. I think we've given enough guidance through our tariff, our service regulations, and our change to the SA application that Duke can figure this out. Like in my example, in a rural area, if Duke installs facilities that happen to be above and beyond what a particular customer needs, that cost should not be socialized. Like if a customer's load creates the need for a 100 MVA transformer, but won't use quite the entire capacity. But if it's in a rural area, that capacity is not going to be used. Other customers should not have to pay for it. That facility was put in just to serve that large load. And if it has some incidental extra capacity that might not get used, other customers shouldn't have to pay for it.
Well, Mr. Lucas, I understand that you provided what you believe is a clear-cut case, but wouldn't you agree that there are instances where, as your colleagues have said, it's murky and it's not clear how those costs should be allocated?
And that's what Duke's going to have to do on a case-by-case basis.
Okay, so Duke will just figure that out case by case?
Yes.
Okay, what methodology should Duke use to do that study?
It's got to look potential growth in the area, and what facilities are needed to serve the large load customer, what facilities are needed to serve growth in the area.
Okay, Mr. Lucas, those sound like important factors to consider, but that does not sound like a methodology to me. What methodology are you proposing?
Oh, we can't have that much detail. It's going to be on case-by-case basis.
Okay. You would agree, though, that the amounts that the public staff talks about allocation of here could be in the hundreds of millions of dollars. Is that right?
It could trigger. One customer could trigger hundreds of millions of dollars of upgrades. Yes.
Okay, and it's your view that Duke has got sufficient. It can just figure out how to allocate those hundreds of millions of dollars on a case-by-case basis?
Presiding Commissioner, I think at this point, in light of your directive that parties avoid duplicative topics, this topic about the methodology and the criteria that the public staff has established in its testimony and exhibits and direction that it's given to Duke on what it should do for these calculation of extra facilities charges has been covered by multiple parties prior to Mr. Snowden. I recognize it's an important topic, but I think at this point, we're also multiple questions in and sort of taking a couple of few bites at the apple at this point.
I understand, and I've read the pre-filed testimony. Mr. Snowden, you want to be heard?
Yes, sir. Respectfully, Presiding Commissioner McKissick, I have asked, and I understand that the the question about whether there's a methodology has been asked and answered. I have, however, gotten different answers from or conflicting answers from different members of the panel as to whether this issue is ready to go forward or whether there needs to be further investigation. I have asked all the questions I'm going to ask about whether there's a methodology. I do have a few questions that are on that topic, but are not duplicative of anything that anyone else has asked.
Well, I'll give you a leeway to ask those non-duplicative questions.
All right, thank you. So without a methodology approved by the commission, would you expect all large load customers to simply accept Duke's allocation of hundreds of millions of dollars?
Oh, no, they'll have to go in discussion. We can talk about in our testimony, there are letter agreements, there's ESA application, they'll have to go into discussion.
Mhm.
And this large load growth is unprecedented. So these very large load customers are creating large costs that we have not seen before, but we've laid out guidance that Duke can use to provide fair and reasonable service to these large load customers.
Okay. Well, Mr. Lucas, so presumably if Duke is allocating the cost of required facilities between a large load customer and ratepayers, might it also find itself in the position of allocating the cost of required facilities between two or more large load customers?
Yes, that could happen.
Okay.
If-
Okay.
Yes.
And it seems that without a commission-approved methodology, there would be a lot of potential for conflict between large load customers when it comes to deciding which of two or more competitors is going to be allocated the cost for those facilities. Wouldn't you agree?
No, we've had a similar situation before with interconnection of generators. We've had interconnection procedures for decades, and we've had multiple generators want to connect to one area of Duke Energy or connect to one circuit. And we've developed methods where all customers get treated fairly.
Thank you, Mr. Lucas, for bringing up interconnection. I think you're one of the few people in this room, I think, who's been working on interconnection for longer than I have. Wouldn't you agree, though, that it took a decade or so of work before this commission and its stakeholder groups and a fair amount of conflict to finally come up with a cost allocation methodology and a process that is reasonably acceptable to everybody involved?
But a lot of that work's been done. Duke can do that. Duke can allocate those costs in a fair manner. I mean, it's capable of doing that.
All right, thank you. I'd like to move on and talk a little bit about minimum billing demand. Around page 30 of the panel's testimony, you will testify about the minimum billing demand requirement.
Okay.
And you say that the large load customer has to provide sufficient monthly payments to ensure appropriate cost recovery of DEC's facilities associated with serving the customer. Is that right?
That's correct.
Okay. So the minimum billing demand is intended to establish a minimum payment the customer's got to make, right?
That's correct.
Okay. And the minimum billing demand is set at 75% of contract demand. Is that right?
Yes.
Okay. And that minimum billing demand is expressed in megawatts of on-site load, right?
Yeah, contract demand is set in megawatts, so it'd be 75. Yeah, the units are megawatts.
Okay. So while Duke imposes demand charges on a per megawatt basis, it charges for energy on a dollars per kilowatt hour or megawatt hour basis. Is that right?
Yes.
So how exactly does that minimum billing demand in megawatts translate to a minimum monthly payment?
Well, that's just part of the payment. The customer's going to have to pay for all its kilowatt hours. But if it's got a contract demand for, say, of 100 megawatts, it's going to have to pay at least 75%. 75 megawatts of demand charges.
Okay, so are you saying, and again, I'm talking about the minimum billing demand here, not the actual, but the minimum. Are you saying that payment of demand charges by a large load customer and only demand charges based on that megawatts of minimum billing demand is sufficient to satisfy the minimum billing demand?
I'm not sure I followed that. Could you repeat?
Well,
your question?
yeah, so I'm trying to understand the public staff's view of how the minimum billing charges work. Because in the tariff that is proposed, minimum billing demand is in megawatts, but Duke charges, for energy on a per megawatt hour basis, not on a per megawatt.
But it has
basis.
demand charges too.
Yes. So is it the demand charges? If you pay your demand charges based on your minimum billing demand, you're good?
Yeah, so our minimum billing demand provision is the same as what's currently in tariff HLF. There's a demand charge component to the tariff, and then there's an energy charge component to the tariff. And the minimum billing demand, the goal is that Duke has invested, to serve this customer, even if the customer doesn't use any energy, there's still investment that's been made. And so that minimum billing demand is helping to recover those costs.
I appreciate that as the function of the minimum billing demand. This is a take or pay contract. I'm really, and I'll tell you why I think this is important, what I'm getting at here. The public staff's calculation of liquidated damages is based on payment of the minimum billing demand for the remainder of the contract. So it's important to understand what minimum billing demand looks like to a customer when they are entering into the contract. So that's why I'm asking these questions. So, Mr. Lucas, I think what you're saying is that if the customer pays the demand charges equal to its minimum billing demand, then that is what satisfies the take or pay provision. Is that right?
Yeah, that section, that requirement for minimum billing demand, yes.
Okay, so the customer doesn't have to pay any energy charges,
It just pays whatever energy it uses, yes.
Okay.
But see what's going to constrict that is we require that to meet the large load tariff, you have to have an 80% load factor. So that customer will be using some energy.
Okay, so that's what I'm getting. So you have to, whether you use it or not, you're going to need to pay at the 80%. You pay for as though you had been consuming energy at an 80% load factor.
That 80% threshold for large load factors just to place customers into the tariff. It doesn't say you're going to have to use certain amounts of energy. That customer would be using energy, have an 80% load factor. So there will be energy charges to that customer as well as the minimum billing demand.
If I could try, and Mr. Lucas, tell me if I'm misrepresenting you, but I think you're trying to communicate is that it's extremely unlikely that a customer who's expected to have an 80% load factor who's included in this tariff would have a billing period where they don't use any energy and thus have no energy charges. We're not saying that there's a minimum energy charge. We're just saying it's extremely likely that there will be an energy charge because the customers are expected to have a high load factor.
That's correct.
Okay. All right. Well, all right. I'll have to clarify something else about minimum bills. Moving to page 52 of your testimony, you discussed the expected revenue from a hypothetical large load customer. You see that?
Yes.
Okay. And it says here that much of the revenue from a large load customer is related to variable fuel costs. For example, a 250 megawatt large load customer with a 90% load factor on schedule OPTV has over 40% of its bill allocated to fuel costs. Is that your testimony?
Yes.
Okay. And so based on this, would you expect that a significant portion of its minimum bills would also correspond to expected fuel costs?
I'm sorry. Let's talk about minimum bills here.
Well, let's just say hypothetically, the customer, they are, for whatever reasons, one of these customers that has a business interruption and they're not consuming energy at the expected load factor for a month or 2 months or something like that. And they're on the hook for their minimum bills instead.
Minimum billing demand.
Minimum billing demand, right. And so what I'm trying to understand is whether that minimum billing demand charge they're paying would also include fuel costs.
No.
Okay. All right.
But that's like Dr. was saying, that somebody's qualifying for having 80% load factor. They're going to be using a lot of energy along the way, even if they shut down for a month or two.
Yes, I understand. But a lot of the discussion we're having here is, I sense the public staff is concerned not about what happens when everything is hunky-dory and the large load customers are trucking along and using energy at their expected load factor. It's about what happens if something goes wrong and the large load customer decreases their load or terminates or something like that.
That's
Is that
correct.
fair? Okay. So I do have a few questions about the exit fees that are specified in the public staff's proposed large load tariff. And there's been some discussion about this already. So under the large load tariff proposed by the public staff, if a large load customer terminates its load or reduces its load by more than 20%, that customer owes liquidated damages equal to all of the remaining minimum billing requirements plus accelerated payment, or rather the NPV of its required facilities and extra facilities charges. Is that right?
That's
Yes.
correct.
Okay. And the customer is on the hook for those liquidated damages as soon as it signs the ESA, right?
So it is our understanding in discovery with Duke that for lack of better terms, they might provide some grace in terms of the period in which liquidated damages might be collected from a large load customer.
Well, let me ask you this. Under the public staff's proposal, is there such a grace period, or is the customer on the hook for liquidated damages as soon as it signs the ESA?
While Mr. Lucas is checking, my understanding would be that if the ESA contains liquidated damages provisions, then it would be subject to those provisions, but our proposed tariff wouldn't apply until the customer is taking service.
Yes.
Okay, so the customer, as far as the large load tariff is concerned, the customer could terminate service prior to energization, could terminate its ESA, and there would be no liquidated damages?
No, the ESA,
Mhm.
okay, once the customer signs an ESA, then it's subject to the terms of the ESA.
Right.
And it could be a while before that customer starts taking
Mhm.
service. So yeah, like Dr. Weaver said, the terms of the ESA would take effect.
Right, so under your proposal, and whether it's under the tariff or under the ESA, under the public staff's proposal, the customer is on the hook for liquidated damages as soon as it signs the ESA, correct?
Well, go back. Let's see, this is our paragraphs we added, paragraphs 19 and 20 in our proposed ESA. It talks about what commitments the customer is going to have to make. Like paragraph 19 is within 60 days after the company determines the cost of extra facilities or required facilities, the customers must provide payment, post a surety bond, or provide an irrevocable letter of credit for 60% of the extra facilities or required facilities costs. So the customer is going to have to start making financial commitments soon after it signs the ESA, before it takes service.
Okay, and I'm just talking about the exit fees. I'm not talking about payments. I'm just talking about liability, and we can move on here.
Okay.
Do you have any reason to disagree that the customer is liable potentially for exit fees or liquidated damages as soon as it enters that ESA?
Not the exit fees in our tariff, but whatever requirements are in the ESA, it is subject to.
Okay. Is the exit fee intended to act as a penalty for termination?
No, it's to compensate Duke for the investments it made in infrastructure to serve that customer.
Okay, thank you. And you would agree that if the exit fee was substantially higher than the amount needed to recover stranded asset costs, it would be excessive, wouldn't it?
Well, and I use that word stranded, if customer exited and had not paid the full cost of facility to serve that customer, and Duke or the customer were not able to find a later customer to use those facilities, that customer would have to pay. And we have this set up so the customer should not be paying far in excess of the cost to serve.
Okay, so you would agree that the customer should not be required to pay liquidated damages that are far in excess of what is necessary for Duke to recover any stranded asset costs?
That's correct.
Okay. And going back to the structure of the exit fees, those include both the accelerated payment of all the remaining minimum billing demand, and also the NPV of required facilities charges and extra facilities charges, right?
I can just read this. See, the exit fee consists of the sum of the minimum annual bill for the remainder of the contract term, plus the net present value of any extra facilities charges and required facilities charges not yet recovered by DEC.
Okay. And my understanding is the required facilities charges are intended to pay for, as we've discussed, the required facilities, those capital investments that are triggered by the large load customer, right?
Yes.
Okay, so my understanding is that Duke would be made whole for those investments by the payment of those required facilities charges, right?
Over time.
Okay,
But if the customer exits before it pays for all those required facilities, that's when these exit fees would kick in.
understood. It's gotta make an accelerated payment of its remaining required facilities charges, right?
Yes.
Okay, and that's what makes Duke whole for its capital investments, right?
Yes.
It depends on which capital investments you're talking about. So as we were discussing, the required facilities charges are these very specific customer incurred costs. But Duke is, as we know, making hundreds and millions of dollars of investments for the bulk load growth that includes these large load customers. And so the minimum billing demand portion of the exit fees is helping to address that issue.
So that's stranded generation assets, is that right?
I think it could be generation and transmission and distribution. I mean, it depends on what Duke is seeing as needed for their system.
And I'll just say, we're not just making these numbers up, like Mr. Snowden made. He called it a penalty or a punishment. It's not. We've had large load customers, two recently. One was an automobile manufacturer, another was a chip manufacturer, go pretty far along in building their site and then stop and change their plans and reduce the demand they wanted. So this is a real risk. And we lay out all these requirements to reduce that risk. And other customers are not stuck paying these costs. Like the example I gave, the automobile manufacturer, the chip manufacturer who stopped construction on their sites after starting and leave stranded assets.
Presiding Commissioner, I would like to mark Microsoft's confidential potential cross exhibit 2. It is a confidential exhibit. I am not going to discuss any confidential information in that. There's only a small amount of confidential information in that, so I don't believe we have to go into confidential session.
Second, very good.
And I would ask that that be marked as Microsoft's cross public staff large load direct exhibit number 1.
Mr. Snowden, I'm not seeing a copy of it up here.
It's up here.
Potential exhibit 2, you do not see under Microsoft. Let me see myself.
Two copies.
And could you remind us when you get back to the microphone which one we're looking at?
Yes, that's exhibit number 2.
We do have access to it.
Okay, thank you.
So it's duly noted and identified.
All right, thank you. And these are, this is a copy of Microsoft's data request to the public staff, number 1. Do you see that?
Yeah, we see that.
Okay, and I'd like to direct your attention to data request 1-8.
And
Okay.
Mr. Snowden, I hate to interrupt you, but it's been brought to my attention and it's now 12:29 and 47 seconds.
Okay.
And we have a hard stop at 12:30.
Okay.
Which for reasons that I do not need to get into. So we're going to go ahead now and recess for lunch. We will continue the hearing at 1:45 PM, hour 15 minutes.
Okay, thank you.
Okay, apologize for the interruption. If somebody could close the door at the back, that would be appreciated. Mr. Snowden, we interrupted your cross-examination, so why don't you go ahead, proceed and continue.
Thank you, Commissioner McKissick. Good afternoon, everybody. I want to follow up briefly on clarify a couple things from earlier. First off, with regard to required facilities, is it the case that required facilities, as the public staff is thinking of it for purposes of its tariff, could include generation?
I'll let Dr. Singanzi elaborate a little bit, but the intent isn't to include generation. I think there's a narrow specific example.
Yes, with one example from data that Duke provided, there was a small amount pertaining to generation, but very small relative to transmission and distribution.
Okay, just looking forward though, going on a forward-going basis, is it the case that required facilities could include some allocation of cost for generation?
Perhaps. I think that would be dependent on the ESAs in place with the various customers. We'd have to look into a bit more why particularly generation was allocated for various customer in which it was put in place. But there's possibility perhaps.
And if we go, one thing, if we go into confidential sessions, we can provide more information on that.
But just to be clear, I think it would be a very specific situation where that customer has requested some kind of specific generation, and not speaking to the broader legal context of whether that's even allowed or not, but like it would be specifically connected to that customer, not the generation that's serving the system as a whole.
Okay, thank you for that clarification. And we don't appreciate the offer to go into confidential session, but I think that was the answer I needed. Thank you. Also, one other follow-up question. I'm sorry, this is not a follow-up question, but going back to exit fees, as proposed by the public staff, the exit fees consist, as we've talked about, of the sum of the minimum bills that are left, plus the net present value of extra facilities and required facilities charges not recovered by Duke, right?
Yes, as we've stated. That's
Okay,
what our
and-
testimony says.
And my question is, why are required facilities charges and extra facilities charges reduced to net present value, but not the remaining minimum bills?
Those required facilities are actual things that Duke has constructed specifically to serve the customer. Whereas minimum bills are for the system as a whole, that lots of customers, not just large loads, have to pay billing demand, pay for the system as a whole.
But in the normal course, those would be paid to the utility over time, in the future. So why aren't those also reduced to net present value?
We just didn't see the need at this time.
Okay. Mr. Lucas,
Okay.
could you please look at the cross exhibit that I marked just before the break? That's the potential cross exhibit 2, and going to data request 1-8.
I'm there.
Okay. And you see here, this data request asked the public staff to identify all studies, analyses, benchmarking data, models, or other materials the panel relied on in selecting this metric for exit fees. You see that?
Yes.
Okay, and the answer is the public staff did not conduct studies, analyses, benchmarking data, models, or use other materials, as we relied on simple principles in our experience on these methods. Was that your answer?
Yes, and we've had minimum bill amounts for many years. It's not something we just made up. Extra facilities charges, they've been around for years. We didn't just make that up. But those two things do play a part in making sure these large loads customers pay their fair share. It's not possible to set out required facilities charges because, for an exact customer, because, ahead of time in a tariff. Duke is going to have to determine those required facilities because it can vary greatly. If a large load customer located in the north side of Charlotte, it'd be easier for Duke to serve that customer. It's got a lot of generation and transmission in the area. But that same customer, same load, identical characteristics, went 50 miles north into Wilkesboro. Duke has no generation in that area and very little transmission. So the required facilities charges could be very different.
And Mr. Lucas, sorry to interrupt you. I guess I want to be clear. I'm not really asking about the required facilities and the extra facilities charges. We covered that ground. I understand the public staff, how that calculation was arrived at. What I'm specifically interested in is understanding how the public staff arrived at the accelerated payment of the entire minimum billing demand for the contract as the sort of basic requirement for.
If
the
the customer exits.
Right.
Well, the customer is committed, and typically in an energy service agreement, the customer is committed to paying minimum bills.
Mhm.
And Duke makes investments to serve that customer, and the minimum bills are supposed to help cover that investment.
Mr. Lucas, did the public staff analyze or calculate what those exit fees would look like in practice for a hypothetical large load customer?
Like I just said, we can't because the amount of facilities could vary greatly.
Well, and again, I'm not speaking, please, leaving aside the required facilities and extra facilities, I am not asking about that. I'm not interested in that. I'm interested in the accelerated payment of the remaining minimum billing demand.
Okay.
You follow me? So did the public staff look at or calculate, hey, what would this amount to in real dollars? What would this look like for a large load customer if they were to trigger these LDs?
Well, different customers have different minimum billing demands.
Okay. Well, let's, if you don't mind, turn to page 54 of your testimony. And there, the public staff provides an example of a hypothetical large load customer with a contract demand of 720 megawatts. And I understand that the purpose of that discussion in your testimony, I think, is for the CIAC, and I'm not asking about that. But since the public staff has provided some analysis of this customer, this is what I'm going to use. And it says there that utilizing illustrative calculations, the customer would pay approximately $402 million annually under the OPTV transmission tariff. You see that?
Okay, you're looking at table 3.
It says page 50. Yeah.
I think it's lines 17 and 18.
That's right.
Okay, you're like right under the table.
Yes, sir.
Okay,
Thank you.
there we go.
Okay. And so over the course of a 15-year contract term, this customer would, in this hypothetical, pay about $6 billion in charges to the company. Is that right? And that's without any required facilities fees or extra facilities fees.
How many years did you say?
15 years.
10 years. Yeah, that's correct.
Okay. And the minimum billing demand for this customer would be 75% of the contract demand, so about 540 megawatts, right?
Yes.
Okay. And this is, I'm going to go back to this issue because I'm still a little confused. Is it the case that the minimum billing revenues would be about 75% of the expected annual revenues, or is that wrong?
Well, everything rolls into revenues, energy demand. Or can you say more specific about which revenue?
The minimum billing demand. So again, I'm focused on the issue of the exit fees,
Okay.
and I'm trying to understand what the exit fees look like, right? How much are the exit fees going to be, right? And the exit fees are based primarily on accelerated payment of minimum billing demand.
If they had to pay exit fees, yes.
Yes, right. So then that's what I'm trying to understand what this looks like in real dollars to a you're a hypothetical customer. So, and I'm still, as I said, I'm still a little confused about how the minimum billing demand charge is calculated. I know it's 75% of the contract demand, but is it the case that the minimum billing charges would be 75% of the expected revenues or something else?
No, because as Mr. Lucas said, the expected revenues are including all the energy costs, all the riders as well.
Okay. So it would be the accelerated payment of like the demand charges for the rest of the contract.
Yes,
Is that right?
just the demand charges.
Okay. Okay. So I've done some math here, and you can check me on this. So under the OPT tariff, I'll say this: subject to check. Okay, assuming a 540 megawatt minimum billing demand under the OPTV tariff over a 15-year contract, I have calculated the total minimum billing charges to be $921 million. Subject to check, would you agree with that?
Yeah, I'd have to do the math, but okay.
Okay, and if that's right, then 75% of that, which is the exit fee, if the customer provides the advance notice, that's $691 million in liquidated damages. Is that fair? 75% of 920 is about 691.
Have to trust you on the math.
Okay.
I can't do the math that.
Okay, understood. I had time to do this. So subject to check, would you agree that under the HLF tariff, that same customer would owe over the course the minimum billing charges based on demand charges over the course of that 15-year contract under the HLF tariff would be $2.165 billion. Do you have any reason to disagree with that?
Yeah, HLF tariff has higher billing demand charges. And that's because it's set up for like witness Jonathan Bird said, it's set up for a very high load factor customer.
Understood. And so 75% of the accelerated minimum billing demand charges for that customer would be $1.6 billion. Do you agree with that? So pitch check.
Now you've really gone down a lot of math. I
Okay.
can't follow.
Well, let me just ask you this. Did the public staff for any hypothetical customer, any size customer, look at or analyze what the actual liquidated damages would be if they were to terminate their contract?
Presiding Commissioner, I think this is asked and answered. You already asked the question if the public staff performed this analysis.
Well, the discovery request was, please identify the studies that the public staff has done on the methodology. We've established that they didn't do any studies of the methodology. What I am trying to ask is whether the public staff knows what these numbers look like in practice, and I don't think that they have answered that question yet.
Well, I'm going to overrule the objection so the question can be answered to witness's ability to do so.
Well, one thing I need to explain, these minimum billing demands are 75% of contracted demand. It's not 100%. Duke has to build facilities to serve 100% of the demand. We're backing off down to 75% of billing demand to be conservative.
Okay, I appreciate that. I understand the rationale, but the question is, did the public staff look at what the numbers would be like for any customer?
Not the total.
Okay, thank you. Okay, and if a customer signed up for a contract that was longer than 15 years, that would increase their exposure to exit fees because it would increase the amount of the remaining minimum billing charges, correct?
Yes.
Okay, and so that would probably dissuade folks from entering into contracts any longer than 15 years, wouldn't it?
Well, if it could get a longer payment period for something like a required facilities charge, it have a longer period over which to pay those charges. So that might be an advantage to a customer to go from a 15-year to 20-year contract.
Did the public staff consider whether exposure to the magnitude of risk of liquidated damages that we're talking about here might inhibit large load customers from signing ESAs with Duke?
Well, some of them already have. Some of them already had agreed to liquidated damages, and
but to be clear, those contracts, the liquidated damages in those contracts they are significant, and people have signed up for those. They are not the same measure or metric that the public staff has proposed, correct?
I can't remember exactly what the terms were.
Okay.
Mr. Snowden, I'd also like to highlight that you're talking about a very broad group of customers. It's very difficult for us to do such an analysis when there's so many different types of customers that Duke is looking to add to its system. And like, we can't evaluate the business decisions that those customers might be making.
Did you ask any customers whether this kind of exposure to liquidated damages might be too big a risk for them to undertake?
Other panel can correct me if I'm wrong, but I don't remember any customer bringing it up as a problem.
But you'd agree that you hadn't shared the tariff with the public staff's proposal for liquidated damages, wasn't shared with any customer before it was filed, correct?
Our calls were open-ended. We didn't give people a list of questions, said, these are only things we'll talk about. Tell us what you're concerned about. So
And I will add that the exit fees were one of the issues that we discussed on the calls.
And to be clear, did the public staff hear any customers object to the concept of exit fees?
I don't think anyone here did.
Okay.
I don't think we did.
Okay,
here.
and to be clear, what I'm trying to get here is not that the concept of an exit fee is inappropriate. Simply whether this metric is appropriate. But I've finished my questions on that. I'll move on. It's okay. I would like to ask a few questions about the curtailment provisions of the public staff's large load tariff. And I'll try to be brief here. Just to be clear, that the public staff, the proposal on the table in this case proposes to require curtailment for the entire duration of a large load customer's contract, right?
That was our original proposal, but of course, as we discussed, and more in line with our DEP testimony, we've changed.
Okay. And you're aware that in its rebuttal testimony in this case, Duke has included a similar curtailment provision, but it allows a customer to petition the commission for a relief from that curtailment obligation under certain circumstances. You're aware of that?
I can't remember specifically, but anybody can petition the commission for anything. I mean, there's nothing to stop a party from filing a motion to get rules changed, some provisions changed.
Okay, well, does the public staff take issue with or would it agree to Duke's modified version of the curtailment provisions as represented in Duke's rebuttal testimony?
We would have to discuss that more internally, make a decision.
Okay. You would agree that not all large load customers can actually reduce their need for power by 95% or even by 50% for an extended period of time, wouldn't you?
Well, they might have to. If a weather event turns off their power, they're going to have to be without power for whatever number of hours or days.
Okay, understood, but that not all customers can do that without a very significant interruption to their business operations.
I don't know about any specific characteristics of a particular customer suffering from curtailment.
So you're not aware of whether large load customers across the board are able to reduce their on-site load or their usage of electricity without interrupting their business operations? That's not something that public staff has looked into?
We're aware that could be an interruption, but also aware that weather-related events can also great problems. Also, system emergencies can also require interruption. So, a large load customer has to be ready to be able to curtail if necessary, not be supplied with electricity. Duke Energy cannot guarantee a steady supply of electricity.
It does its best though, right?
It does. I
Okay.
cannot guarantee that.
All right. So would you agree that certain customers can only comply with curtailment instructions without a huge interruption to their business by switching to on-site generation?
If their business is very dependent on having continuous service every hour, every minute of the year, I would recommend that they have on-site generation.
Okay. And at this time, the behind the meter generation that customers in North Carolina are most likely to use is diesel generators. Do you agree with that?
I can't say, but I know some folks talked about earlier today, natural gas fire generation, batteries are another possibility.
Mr. Lucas, actually, Dr. Weaver, I believe you mentioned earlier, you made reference to concerns about the long-term supply of natural gas in North Carolina. Do you recall that?
Yeah, I was talking specifically about some generation investments that Duke has proposed.
Okay, and would you all agree that there is, the public staff has certainly expressed concern over the long-term availability of natural gas, especially during high load, winter events in North Carolina?
We haven't testified anything like that.
Okay. So you don't personally think that there is a concern about, you don't personally have any concern about the availability of gas during?
It's just not under my, not under my workload that I do. I'm the manager of rates and energy services.
Okay. Has the public staff done any analysis of what it would cost a large load customer to comply with curtailment instructions under a large load curtailment program?
No.
Has the public staff talked to large load customers about what the impact of a mandatory large load curtailment program would be on their business operations?
Yeah, so that came up during our conversations with different stakeholders when we were having those conversations during this process, but I don't know that I can recall specifically any specific customers, the impacts it would have for particular.
Okay, and I wouldn't ask you about specific customer feedback. I'm just asking if you all receive feedback generally from customers.
And I can add to that. We're not putting curtailment out there just because we want to. We have our Duke Energy has signed contract for 6.7 gigawatts of load. Just did that in a little over 2 years. But we're a long ways out from having enough facilities to serve that level of load. Curtailment is an option if Duke Energy simply does not have the generation in place. But if these customers want service and they're able to curtail that load, it would make this state more attractive if it can't get service anywhere else.
We also have seen an assessment of some ESAs that some companies or large load customers are willing to have curtailment provisions just for them to be able to get into the market. So they've made a business decision to say, okay, at this point in time, it would be beneficial for us to accept curtailment provisions for us to be able to break into the market and accomplish various things that we might want to accomplish. I think that's all I'll mention on that.
Okay. I'd like to, it's my last topic here. I'd like to go back briefly and talk about the issue of what I'll refer to as the retroactive application of this tariff. I believe you all discussed this with Mr. Josie earlier in the day. Do you recall that conversation?
Yes.
Okay. And I just, what I heard was that the tariff would apply to all customers that are meet the applicability requirements, but that the proposed ESA would not be applied retroactively. Is that right?
If the customer has signed an ESA, they can operate on the ESA. This ESA application we proposed would not go into effect until January 1st of 2027.
Okay, understood. And so if the terms of the tariff conflict with the terms of the ESA they have signed, what happens then? What applies? The existing ESA they've signed or the tariff terms?
Presiding Commissioner, I'll just note, to the extent that this calls on legal conclusions for the conflict between an existing contract and an applicable tariff, I would just ask that the panel only ask, as being non-attorneys, answer the question in their non-legal capacity and not offer legal opinions. To the extent the question calls for that, I would object.
I will acknowledge that the panel are not attorneys and I'm not asking for a legal conclusion. I'm asking what the public staff, what the plan is and what the intent is.
I think your respective opinions are duly noted in the record, and the panel will address the questions of their capacity to do so, being non-attorneys.
Would you like me to ask the question again?
Yes, please.
Okay. In the event that a provision of the tariff conflicts with the provision of the existing ESA for a customer that already has an ESA, what is the public staff's intent, that the ESA should control or that the tariff should control?
Do you mind providing a more specific example?
Sure. I believe that earlier you all discussed the question of if there was a conflict between the 5-year limitation on the load ramp in the tariff and a longer load ramp in the ESA. And I believe that it was y'all's testimony at that point that in that example, in that case, sure, the load ramp and the ESA controls. Do you recall that? Is that the fair summary of your testimony?
Yeah, I understand. It depends on when that customer takes service. This tariff will go into effect January 1st, and if the customer has not started taking service, then our tariff will take effect for that customer.
Okay, but so would that customer who's taken service after 2027, who's got a 7-year load ramp in their ESA, would that customer then have to go to a 5-year load ramp because the tariff provides that?
Yes, if they have not begun taking service.
Okay. Similarly, if the customer's ESA does not have a curtailment provision in it, and the tariff does have a curtailment provision, does that customer then have to accept curtailment?
If they begin taking service on January 1st, 2027 or later.
Okay, so to be clear, what the Public Staff is proposing would in effect rewrite some of the material terms of existing ESAs, correct?
I don't think it's rewriting. I think it's the Utilities Commission approves new tariffs all the time, and customers have to comply with those tariffs.
Understood, Mr. Lucas, and there was an example about net metering tariffs. I understand that, and I will absolutely credit that customers taking service subject to tariffs are subject to changes in those tariffs. This is a little different because here a customer has a signed contract, signed enforceable contract with Duke Energy that was not governed by a tariff, and the question is whether it's the public staff's intent that this new tariff, not a modified, but a new tariff, will override the bargain for terms of that contract.
Yes.
Okay. Can you think of an example in which this commission, in the absence of wrongdoing by any party, has rewritten and without a request by any party of the contract, has revised or rewritten the terms of an arm's length contract between the utility and a customer?
Not to my knowledge, but this is unprecedented load growth. And we're concerned about the cost that Duke's going to incur to serve all these customers and make sure that those customers pay their fair share.
Mr. Lucas, you would agree that the customers that have signed ESAs with Duke Energy have made very significant financial commitments in those contracts and also significant financial investments in the development of the projects that go along with those contracts. Would you agree with that?
I don't know the level of their investments, but they should be where they have to conform to commission's tariffs.
Okay, well, you'd agree. You've seen the terms of the contracts, and I'm not asking for specifics. You'd agree that under those contracts, very large financial commitments, including cash deposits, have been made, and customers have agreed to put themselves on the hook for very substantial financial penalties if they terminate those contracts. Would you agree with that?
And Mr. Lucas, I would simply say, to the extent that it requires you to draw up a legal conclusion, and if you're not an attorney, you don't have to address the specific issue if you're not certain or you do not know. So I simply, my prior ruling said answer it to the extent that you're aware.
I can't speak to cancellation of contracts. I know what we want in our tariff.
Okay, Mr. Lucas, has the public staff considered the message that it would send to businesses looking to make investments in North Carolina if the commission were to rewrite substantial terms of bargain for contracts that include significant, financial commitments?
No, but like I said earlier, if there's a particular problem, Duke or anyone can file a motion to get a waiver or whatever it needs to continue to do business.
Okay, thank you. Those are all my questions.
All right, very good. Thank you. Next in the queue is North Carolina Justice Center et al.
Good afternoon. Nick Jimenez with NCJC et al. So I'm going to try and be brief as we talk about some of well, I do have a lot of ground to cover, as others have said, but recognizing what's been covered, and I'm going to try to limit the citations to your testimony that we need to give. Hopefully we can skip some of those. So you referred to 7.9 gigawatts of potential LLCs in the advanced development phase. Do you recall that?
Yes.
And that has something to do with the 103 billion in capital spend in the next 5 years that y'all referenced.
Tell me page number. I'm trying to get that number correct.
That's page 24, line 2.
Okay, I'm there. So let's see. Yeah, Duke Energy's capital spend is 103 billion.
And I'm just saying those two are connected in some way, right?
Yes.
And you also noted that in Duke's large load update, there were 4,337 megawatts of signed ESAs. Some pages 24, 25.
I see that. Yes.
And just recently in response to Mr. Snowden, you talked about 6.7.
6.7 is
Yeah.
we've gotten more ESA since we filed this testimony.
Can you give any ballpark estimate of the capital spend necessary to serve that amount?
No, I can't.
And you testified about some evidence that Duke is actively pursuing large load customers, right?
Yes, they're 24/7. They're pursuing large loads. Yes.
So you don't expect this to stop on its own?
No.
No, and if I may, there are some things I do want to mention that would require a confidential session with respect to some of the things that you've mentioned to address your concern.
I didn't plan to take us into confidential session, but that's fine with me if that's the panel's response.
So are you asking us to go into confidential session so that question can be addressed?
Yes, Presiding Commissioner, I would make that request.
All right. John, I would ask that you discontinue the live video feed at this particular point in time. Anyone who has not signed a confidentiality agreement or provision that allows you to be in the hearing room at this time, I would instruct you to exit the hearing room, and we will let you know when this testimony has been concluded. You may continue your cross-examination.
Thank you. So a little more foundation for what we're talking about. The public staff sees potentially severe levels of both inter and intra-class cross-subsidization. Is that right? Again, I'm trying to just skip referencing your exact. Hope we can do that. If it's helpful.
Yes, we talked about in our section 7, early costs for dedicated facilities that could be spread across all customers.
And you said under certain circumstances, large loads can bring down costs.
Yes, as long as they don't create the need for additional facilities, a lot of additional facilities, they could bring down costs, but there's a time lag. It's not like a data center connects next year, starts buying more megawatt hours, brings down costs for customers. It's not like the customers' rates change that year.
Okay, and it's not a guarantee that they will bring down costs at all, is it?
That's correct.
And I heard your colloquy a little earlier, I think with Ms. Kress, is it fair to say the public staff isn't fully convinced by the large load benefit analysis that Duke put forth in the carbon plan?
Yes, we found some problems with it.
But you didn't file that?
We weren't able to file that in this docket due to the timing of when it was introduced, and I don't remember the exact dates of when rebuttal was filed in the CPIRP, but this is all, new information. So we didn't have that analysis completed at the time we filed our testimony in this docket, which is why we took the opportunity to discuss it today, but it is included in our DEP testimony.
So is it fair to say that we, or the commission in particular, need to take some action to avoid or to get that outcome, rather, the bringing costs down?
Yes.
And the commission shouldn't be limited by contracts that Duke and large load customers might have signed to date, should it?
I'm just going to go ahead and lodge an objection here. This has been approximately 20 minutes so far of friendly cross, and I have tried to give council some leeway without interjecting, but this is very clearly an issue upon which these two parties are directionally. And this is friendly cross, and we've had this witness panel introduce 2 of their own exhibits in response, which I think goes to show that this is very friendly cross happening.
I believe they referred in their answers to 2 exhibits. I will sustain the objection, but because I do think we're getting in a friendly cross, and we've spent a lot of time here today, but I will give you a little leeway to wind things up. I know
May I respond?
Yes, go right ahead. Yeah.
So there's a difference between friendly cross and laying the foundation for adversarial cross that makes the point that, well, we might be directionally aligned that something needs to be done, more should be done. And a lot of the time that we've taken on this topic so far has been crossed by 3 of the world's largest companies, representatives from those, and others aligned with them saying we shouldn't do something effectively, or we should do less. And so I think it would help the record for the commission to have a little more fulsome cross from a party that thinks we should do more, which is still adversarial.
Well, I'm going to give you a little leeway, sir. Okay. But understanding what thoughts I have articulated.
Understood. Thank you. Okay. So you referenced in your testimony a couple of other actions at other levels of government or regulatory bodies. For example, you cited President Trump's ratepayer protection pledge.
That's correct.
You're aware that that pledge says signatories will sign on to new rate structures in addition to paying for their infrastructure?
Give me a moment. Let me find that so I can confirm what we wrote.
If I may, I don't think we say that specifically in our testimony, but subject to check that that's what the pledge says.
Thank you. Turning to your large load tariff proposal, we've talked about how you proposed that it would be tacked on to existing rate classes.
Yes.
For a given large load customer, say it has 100 megawatts and an 80% load factor, it would have different bills under those underlying rate structures, wouldn't it?
If I'm trying to understand your question, like if it chose HLF or OPTV, it would have different bills if it chose either one of those tariffs.
Exactly.
Yes.
And it's safe to say that where a large load customer has the option, it is going to choose the rate schedule where it pays the least.
That's typically what they do.
And if that's usage changes in some way, and a different tariff would save it money, it will switch.
Yeah, would attempt to switch, yes, if it qualified.
And for, I think you said for, actually, I'll skip that. You talked about how 17 of the 18 customers that signed ESAs recently chose OptV, one chose LGS.
That's correct.
And you talked about concerns you had with OptV and the degree to which customers on that tariff would pay sufficiently towards transmission and distribution costs.
On the page, I don't know if we said customers in general, large load customers pose the risk of not paying for all the assets that they use.
Okay. Well, I'm looking at page 44, lines 16 to 22, where you talk about how the line extension plan and service regulations were not designed for the unique type of large loads now connecting to the grid.
I see that, yes.
Isn't the same true of OptV, that it wasn't designed for modern large loads?
And we envision that customer operating under existing service regulations, existing line extension plans, and on that OPTV tariff would pose a risk of not paying its fair share.
So now I want to explore some reasons that the public staff might or might not have considered proposing a large load tariff that created a rate class. Now, for these questions, for simplicity, let's keep everything about the public staff's proposed tacked on large load tariff the same, except imagine that it creates a rate class and then compare that to the proposed tariff. Does that make sense?
Yes, but our tariff was designed not to be standalone. It would have to be tacked on because it has no rate provisions per kilowatt hour or per kilowatt.
As written, sure.
Yes,
But
yes.
if we can imagine writing one that wasn't
Yeah, they
intended to
did
be a
include
rate.
those. I see.
Isn't it true that creating a separate rate class would enable tracking costs and revenues from the class created by the large load tariff better?
Yes,
Isn't it true that this group of customers defined by high demand and high load factors have differences from other customers on OptV that would result in different revenue to cost ratios?
yes. What we put in our testimony, we just did not propose a tariff. We proposed changes in the service regulations and changes to the ESA application. We think these three things working together would provide much more ratepayer protection.
And if I could add that my understanding of part of why we didn't propose a rate class, and not being a cost of service expert, but as I said before, a lot of these customers are not yet taking service. We don't have all the data. We might necessarily need to appropriately allocate costs, and that's just my understanding as not the expert on cost of service.
Yeah. As far as connecting large loads, we have very little connected now compared to what we anticipate being connected over the next several years.
Well, that gets to my last point or question on this point. Isn't it true that putting those customers in their own class would give them advance notice that they will have their own rates in the next rate case?
Yeah, if the commission did that in this rate case, put them in their own class, yes, then they would know. Future, they would not have kind of intra-class support or subsidy going the other way.
So I want to move to the threshold that y'all chose, or multiple thresholds for this. Starting with the demand threshold. So in Exhibit 3, the tariff says it's required for customers with, and I'm quoting, 15-minute aggregated demand at 50 megawatts or more.
Yes.
Call it. And in testimony, you explained that that 15-minute aggregated demand is different from DEC's historic 30-minute aggregated demand. But you justified that, right?
Yes, currently DEP uses a 15-minute aggregated demand.
Okay. And so the 15-minute aggregated demand is used for applicability for the 50 megawatt threshold. But then each tier in Exhibit 3 is set based on 30-minute aggregated demand.
We did correct that. I believe that was one of our.
Oh, that was
That's corrected, yes.
okay, I missed that. All right, well, that clears that up. Okay, so going to the 50 megawatts, if you'll refer to your figure 2 on page 27, this is the histogram. You would agree that, well, you said 13 of the 25 customers fall below 50 megawatts.
That's correct.
And so you chose 50 megawatts, you said, because it exceeds the demand of the majority of traditional commercial and industrial customer loads and marks the threshold at which DEC might need to make substantial incremental generation or transmission and distribution investments to serve the customer. Is that right?
Yes.
And I think in response to the AGO earlier, you clarified that you just kind of had to pick a threshold.
Yes.
Now you said the threshold, this 50 megawatt threshold is slightly higher than the average of the other approved tariffs that you reviewed in E100 sub 208, the large load additions docket, right?
Yes, and I say 50 megawatts is also what Duke Energy agreed to in rebuttal. It said its threshold at 50 megawatts. And that is lower than what Duke originally proposed when it changed its service regulations. It proposed a 100 megawatt threshold for additional requirements.
So sticking with that docket, I would like to introduce the NCJC et al. Potential cross exhibit 92. This is the public staff's presentation from the large load technical conference.
Does that have a potential exhibit number?
92, sir.
92.
Is there a particular slide you'd like us to look at?
Yeah, first I should probably say I would ask to mark that as NCJC et al. Cross public staff large load panel exhibit 1. And I would refer you to slide 4.
Duly marked, notified, and identified for purposes of the record.
Thank you, Presiding Commissioner McKissick.
We're there.
Do you see the bar at 500 megawatts?
Yes, I do.
That's going to bring up the average a lot, isn't it?
I mean, mathematically, yes.
So eyeballing, I'm seeing about a dozen kick in right around 0, another 5 just after that. Doesn't it look like the median would be closer to the Dominion tag?
So I don't recall the exact list of tariffs that I used to calculate that average. I do want to note that this figure includes some tariffs. It may also include rules and riders. I definitely didn't include rules and riders in that calculation. What I'm trying to say is that the tariffs here may not be the exact same subset because I did, try to ensure that we were comparing apples to apples tariffs when I was calculating that number. But I agree with you, yes, that looking at this figure, that median is probably below 50.
And I think you referenced in testimony Dominion's tariff. I think you're familiar with the high load customer class GS5 tariff.
Yes.
And it kicks in at 25 megawatts.
25, yes.
And you're aware, of course, the Utilities Commission has set a reporting threshold at 25 megawatts.
That's correct, yes.
And in your testimony, you propose continuing ESA reporting at 25.
Yeah, still reporting, yes.
You would agree, wouldn't you, that 13 different 49 megawatt large load customers would likely trigger incremental investments?
It could. Yeah. But we had to set the threshold. We didn't want to capture too many customers less than 50 megawatts because they just would not have that large of an impact on the grid.
And I'd like to add also, when we're talking about Dominion, going back to the comments that were filed in sub 208, Dominion's, diversity of customer base that tariff would apply to looks very different from what Duke is experiencing. And if the commission would like to refer back to the confidential information in that session, I think there's more details there about what exactly that looks like. But it's not, their GS5 is applying to a different group of customers than Duke's tariff would apply to.
Moving to the second threshold requirement, the load factor of 80% or more.
Yes.
Try not to cover too much of what you said. So you essentially said, this is on page 29, you picked 80% because it captures customers with high demand and high energy usage. Is that fair?
Yeah, I mean, in combination with the 50 megawatt threshold.
Right. And you talked about how high load factor customers trigger base load build out, right?
Yes.
So the theory is basically that high load factor customers require more expensive generation build.
No, it's for generation, it's the high load, not necessarily load factor. High load factor is high load plus high energy usage.
Right. I think I don't want to get bogged down on that.
I can add a little more clarity. Customers with a lower load factor can typically manipulate their load to avoid on-peak hours, so they do provide a benefit to the grid. But high load factor customers cannot. They need electricity at a high demand, even during peak periods. So that's why we wanted to get them in this tariff.
I think that's a perfect segue into what I wanted to ask about. So they're triggering base load build out, but a customer with lower load factor can shift its peak to different times.
Typically, yes.
Typically. So if the customer's peak is the same time as coincident peak, and the customer is going to have to build, or the utility is going to have to build a peaking generation
Yeah,
to meet that,
yes.
they could shift it to some other time. So I'd like just to drill down on this point a little bit. I would like to introduce my second exhibit. This is Microsoft's potential cross exhibit 1, the Tyler Norris et al. Duke University paper titled Rethinking Load Growth.
Duly marked, noted, and identified for purposes of the record.
Thank you, President Commissioner. And I would ask to identify it as NCJC et al. Cross Public Staff Large Load Panel Exhibit 2. I'm not going to walk through the famous Duke University paper in detail. I just want to cover a couple points. Do you see on page 2, starting a paragraph about halfway down, it says, specifically, we estimate the gigawatts of new load that could be added in each balancing authority BA before total load exceeds what system planners are prepared to serve, provided the new load can be temporarily curtailed as needed.
Yes, it says that.
And then on page 3, the 4th paragraph, I'll try not to read this whole thing to you. Talks about highlighting how flexible load strategies can tap into existing headroom and more quickly integrate new loads at lower cost.
Yes, it says something to that effect.
Okay, now I'd like to refer you to figure 1 on page 4. Do you see the row for DEC about halfway down?
Yes, I see it.
And the green bar for DEC showing a 3.7?
Yeah, there's a bar that shows 3.7.
That's gigawatts, right?
Looks like it.
And the green bar represents load addition at 1% curtailment, right?
That's what the figure says.
So to the extent we're trying to avoid needing to build new baseload plants, shouldn't we be looking at flexibility requirements like those studied in the Duke University report?
And we can look at it, but some customers just don't have that flexibility. So they will need more generation to meet their high load factor. But like we said earlier, they'll have to pay for that, those assets as well.
Okay. I want to move on to contract length. I think you refer to this as contract demand on page 30.
Okay.
This is one of the terms that varies by tier in your proposed large load tariff. Looks to me, is it fair to say 50 to 100 megawatts, it's 10 years, and 100 and 200 megawatts, it's 15?
I see, yes.
And just for clarity, there's 100 megawatt or more tier. Should that be 100 to 250 megawatt?
Yes.
So concerning term lengths in your testimony on page 30, you referred to, again, Dominion GS5, which has a 14-year term length. Then you said that a 10-year term for loads between 50 and 100 megawatts strikes a balance between allowing flexibility and protecting other ratepayers.
I see that, yes.
You would agree that your proposed large load tariff at 50 megawatts for the same group of relatively diverse large load customers would apply to fewer entities than a 25 megawatt threshold, wouldn't you? All else equal.
If we'd lowered the threshold, yeah, it would have captured more customers, yes.
And you would agree, in terms of protecting other ratepayers, 20 years would be closer to the expected useful life of the assets that Duke will be building to serve large loads?
That would be closer, but since we've recommended required facilities charges, if it's a 10-year contract, Duke will have to collect those required facilities charges over 10 years. If it's a 15-year contract, it'd be spread out over 15 years. So there's a mechanism that we propose that would protect the public, protect the ratepayers with these shorter contract lengths than what you suggested.
So I have a few questions about back-end risk after the contract ends, risk to other ratepayers. Do you agree that back-end risks exists?
You'd have to define that for me.
So that if we build things to serve large loads and then they leave or after their contracts are up, the grid assets that we'll have built will have useful lives and payoff periods longer than the minimum contract terms?
It could, and that's why we recommend a required facilities charge. And there is a risk. We want to have a balance between attracting customers and protecting the ratepayers. If we thought if we had very long contract terms, it would be discouraging to customers that wanted to locate in North Carolina.
Did the public staff consider making large load customers responsible for a portion of capacity reassignment at the end of term?
No, not anything beyond the contract term.
Just at the end, finding.
I'm sorry, like if the contract term's over.
So the contract term's over, there's some back end infrastructure that needs paying off. Make that large load customer that's leaving responsible for finding another customer.
No, not after the contract term. I mean, if they do before, we've recommended a mechanism by which that customer could find an additional load to use the same assets.
And did you all consider writing a large load tariff so that back-end costs were socialized, but only to the large load customer class or a large load customer.
We did not consider that.
Finally, did you consider accelerated cost recovery? So grid assets serving large load were fully paid by the end of the contract term.
That's sort of what our required facilities charges do. It's a payment for the facilities that the large load customer uses within the contract term. Not based upon the life of the asset.
But that's just for the required facilities, right? Not
Yeah.
for, I think you testified earlier, I forget which council was cross-examining you, but to the effect that there's a lot of other stuff that will have to be built to serve them in addition to, you know, really proximate required facilities. Isn't that fair?
I can't say up or down on that. We've designed this so that the customers will pay for the facility, portion of facilities that they use.
Moving on to minimum billing. Well, let me just ask one more on that. I mean, we talked about 6.7 gigawatts, you know, signed up in the past 2 years. Surely there will have to be generation to serve that energy need, right?
Yes, but that generation will serve all customers.
But it wouldn't have been built but for the large loads.
That's hard to determine because over the next 10, 14 years, Duke Energy plans to retire eight gigawatts of coal-fired power. If Duke has to build new assets, those assets have longer service lives, they will have higher efficiency. Those assets will bring advantages to all customers.
Okay, so the public staff position is that the outside of the required facilities, the additional things that Duke will have to build are kind of categorically benefit all customers.
Yes.
Okay. I want to turn to minimum billing demand. You proposed 75% of contract demand.
Yes.
Just real quick, is it, well, you said on page 31, this is lines 2 to 7, you said that 75% ensures DEC will receive payment for most of the contract demand while allowing the LLC some flexibility and help ensure that capital cost recovery is not completely shifted to the broader customer base if the anticipated load fails to materialize. Did I read that right?
Yes.
So is it fair to say that the higher the minimum billing demand, the lower the risk that capital cost recovery is shifted to the broader customer base?
Yeah. If we raise that minimum billing demand to 95%, it would recover more money more quickly if the customer wasn't operating at 100% of its contract demand.
But there's also a balance there to be had of, you don't want to make the requirements so stringent that no businesses ever come to North Carolina, as some of the other council has alluded to.
So I want to get to load ramp schedule. That's 5 years for all tiers, right?
Yes.
And the rationale is basically that it's adequate for the large load to develop load and DEC to build resources.
That's correct.
Okay, so I'm not clear whether the minimum contract terms you propose begin immediately with the signing of the ESA, say, or after the load ramp period ends. You say the requirements in your proposed Schedule LL begin at the time the large load begins taking service. So I think the contract term begins then, is that?
Well, no, the ESA is the contract, and that, of course, that has terms that begin long before the customer takes services. There's some items that Duke having facilities in place. Take a look at our Exhibit 4. ESA has a lot of requirements that we want the large load customer to meet before the first day it takes service.
Okay.
I think what you're getting at is the 10 years or the 15 years that would be when the, when the large load customer begins taking service, including the ramp period to when they terminate service, but the amount of time that they're sitting on that ESA not taking service is not included.
Okay. So wouldn't you agree that starting the contract term after that load ramp period would better ensure the utility receives, the fixed number of years of full capacity payments from the large load customer?
I'm not sure I understand the question. We've got a recommended load ramp period of 5 years, starting from the day customer takes service. And, but you also talk about the contract term as being something different. I mean, it's a longer period of time, like say a 50 megawatt load signs a 10-year contract. It's got a 5-year ramp. Well, it's got 5 years to come to full load and operate at 5 years till the end of the contract term.
That's what I'm getting at, is that the load ramp period is within those minimum contract terms.
Yes.
And I'm saying if you made if the contract terms start at the end of the load ramp period, so ramp up 5 years and then add 10 years for the 50 to 100 megawatt category, wouldn't that better ensure the utility would receive full,
Well, that's why we have our required facilities charge, to make sure that that Duke and its customers are made whole.
But again, I think it's a balance. Like, we could have a contract length of 35 years to ensure that a CC that's built is, the asset life matches, but that would be overly burdensome. And so we were trying to find the balance between those two. Enough time to recover sufficient funds, but also not so long that no customer will ever agree to it.
So turning to exit fees, I think we've gone over what the exit fee is. So I'll try and skip through that. In the proposed tariff itself, it's not listed separately, right? It's kind of combined with the notice periods in items 4 and 5. Is that accurate?
This is on page 31 and 32.
I'm talking about in Exhibit 3, actually.
Oh, okay.
It's got, item 4, about advance notice, and item 5, if the customer fails to meet advance notice.
Right. And just to be clear, the proposed large load tariff says the fee is paid to the company, but the idea, I hope, is that all of it would flow back to ratepayers as an offset to the cost of the infrastructure built, right?
Yes.
Okay. And as long as the notice is given, so it's fair to say that the purpose of the exit fee is to protect customers from paying for stranded assets if the utility builds things and then the large load customer leaves.
That's correct.
But under the terms of the large load tariff, they're only paying 75% if they give notice.
Yeah, and the goal with that is to incentivize the notice. If there's no benefit or penalty, then the company is not incentivized to give notice. And so that's where the 25% reduction is coming from.
Okay. So now I want to understand how this shows up in the proposed service regulations, because something isn't quite squaring for me. So if you look in Exhibit 5, that should be your service regulations, as redlined by the public staff. If you look on the first page, the unnumbered section titled Cancellation of Agreement for Non-Residential Service Customer's Request. You see that?
Yes, I see it.
And there's no red text in that section, right? So you didn't propose any changes to it for the large load tariff?
No, but, I mean, we put our changes in section 6. Yeah. In section 6 to require have more detail on contributions in aid of construction.
I just want to stick with this section because it seems, I want to figure something out. So if you look at that section, again, trying to save some time here, is it fair to summarize the termination charges as the lower of the minimum bills or the loss due to early retirement of all transmission and distribution facilities specifically installed for the customer.
I mean, both of those, and you're talking on page one, A and B, make sure I'm putting it correctly.
Page one,
Sure, I don't misinterpret.
I'm hearing that's right.
Okay.
I don't remember it having an A and B, but
Okay.
yeah.
And I'm not understanding, I quite understand your question. It's not,
I'm trying to figure out what your understanding of those cancellation of agreement for non-residential service charges are. Because I'll just tell you, I think there's a discrepancy or an inconsistency between what these cancellation charges are in the service regs and the minimum exit fee in the proposed large load tariff.
yeah, our tariffs strict, would in some cases be stricter than this. Or it depends on the case. This could be stricter, like a B, loss due to early retirement. That's assuming all that transmission and distribution that Duke installed to serve a large load customer was taken out of service completely. I mean, that's
But you agree it says the lower of those two, right?
yes. And then of course, go back to A, okay, say the net present value monthly bills. That's largely, A is largely what we've put in our tariff.
So just to illustrate the concern, suppose the cost of transmission and distribution to serve a large load customer at a reduced contract demand is the same as the cost of the T&D to serve the large load customer at its original contract demand. Under the service regs anyway, the customer could reduce its demand at zero cost, couldn't it?
I don't think it allows zero cost. Are you thinking item A would be zero cost? I'm not sure which one you're saying zero cost.
Well, it says the lower of those two. So if you had, so I'm focusing on the cost of the T&D and assuming that is the same at a lower contract demand, it seems like that would be the lower cost and the large load customer would pay that lower cost, which would be nothing.
I don't say it would be nothing. I'm sorry, I'm not following you. How would it be nothing? The customer have to pay nothing? I don't understand.
Well, I'm saying the lower of the two amounts, and there's no difference in the T&D costs. So there's no cost to recover there. And that's the lower between the cost of the T&D and the LDER.
It does say that the amount shall not be less than. Oh, I misread. My apologies.
Not less than zero. I read it. Yeah. Okay, I think I'll just move on.
Yeah, I think as Mr. Lucas highlighted, our tariff has more stringent requirements than what is in the service regulations.
And not to ask a legal question, but is the public staff's idea that the tariff would govern in that case?
Yes, whatever's stricter.
Okay. So I want to move to curtailment. Closing in on it. We've talked quite a bit about the requirement y'all proposed and that it mirrors what's in some of Duke's ESAs. Am I remembering that right?
Yes.
I think Google's counsel, Ms. Fennell, asked about how long, and I think she was getting at how many years rather than the duration per year. Is your proposal is indefinite, right?
Yes, but we've recommended something different in our DEP testimony, and we've agreed in this hearing that we will agree to what we reckon in DEP testimony where the curtailment's limited to 5 years with possible extension.
Okay. You testified the recommendation, so coming back to per year, the recommendation of the 50 hours or 100 hours is based in part on EPA's limitations for diesel generators.
Yes.
So is it fair to say the public staff expects large load customers to meet curtailment requirements with diesel generators?
No,
Yeah.
it can choose whatever technology it wants, but if it had diesel generators, that's what it would have to meet EPA standards.
So again, I'm not trying to elicit any legal opinions here. I want to understand the constraints that y'all thought you were operating under as you came up with this proposal. Are you aware that the limitations you're referring to come from new source performance standards and national emission standards for hazardous air pollutants? Federal regulations.
Let me find that. Let's take the fact sheet from EPA final amendments to the emission standards for reciprocating internal combustion engines. This was January 15th, 2013. It says here, emergency engines may be used to prevent electrical outages and to test and maintain engines for up to a total of 100 hours per year.
So are you aware that under those regulations, it is only possible to use a diesel generator for up to 50 hours per year for non-emergency demand response or financial gain if it is dispatched by the local balancing authority or local transmission and distribution system operator?
I wasn't aware of that requirement.
That's 40 CFR 63.6640 F4 Romanet 2A.
Okay.
For those following along at home.
And to be clear, this is very similar to what Duke has put into some of his ESAs.
Understood. So to the extent that happens and the generators are being dispatched by DEC, aren't we effectively meeting the grid's peaking capacity with diesel generators?
If something happens and Duke cannot serve that load, if Duke does not have the capacity to serve, yes, there would be some hours per year where those are generators meeting peak load.
Are you aware that operating a generator for more than 50 of these non-emergency demand response or financial gain purposes would make it no longer an emergency generator and different legal requirements would apply?
I'm not aware of that.
Are you aware that the 50 hours of operation for non-emergency situations are counted as part of the 100 hours per calendar year for maintenance and testing?
No.
And so using diesel gensets for 50 hours for these non-emergency DR purposes could have the unintended consequence of limiting facilities' ability to maintain the engines or do emissions testing?
I mean, they can do that emissions testing and maintenance. I mean, maintenance for based upon running the engine during that 50 hours.
So, and if we're designing these curtailment provisions, around the limitations on diesel generators, is it safe to say that that prevents us from doing something like the 1% flexibility that we talked about in the Duke University study?
Presiding Commissioner, I'd just request that the panels testified that this particular diesel, provision for curtailability and running and the maintenance periods and all the rules that they've modeled that based on Duke Energy's recommendation in their tariff. So to the extent that we have additional questions about why that's being done, this panel's sort of accepted that for purposes of their tariff, but Duke perhaps can speak more to that when they're up in
on a rebuttal.
Yeah.
Yeah. And I would, to the extent that constitutes objection on the basis of the testimony is being elicited this time, I'll hear you out, but uh, do you have any reason why you wouldn't want to just address this with Duke when they come back for rebuttal?
I'd be happy to do that, Presiding Commissioner. Just since it's in their testimony, I assumed the public staff, had a basis for it and looked at the regulations as well. And I guess I want to see whether, learning a little more about or considering the other limitations in federal regulations changes their opinion.
Why don't we address that on rebuttal if we could? So I'm going to sustain that objection and address it on rebuttal.
Understood.
I think Mr. Felling has, on the record, identified the way it was modeled, the way it was addressed. And the witnesses are there to answer questions, but I know right now the testimony's gone on for quite some time. I don't know how many more questions you have before your cross-examination ends, but can you give me some idea?
I am 6/7.
6 or 7 minutes more.
No.
I tell you what we're gonna do. We're gonna take a break, okay, our afternoon break, our recess. It is now 3:12. We will return at in about 7 minutes and try to wind it up in no more than 5 minutes, sir, if you could. So try to reassess what you would intend it to ask and see if it can be restructured in a way that you can get what you need, but not go on longer than another 5 minutes.
Understood.
Thank you. We'll continue roughly in about 10 minutes or so. I take it you've reorganized your thoughts and have a few pointed questions left that can be answered in about 5 minutes.
That's right, Presiding Commissioner.
Thank you.
Is the panel aware that the Texas Public Utilities Commission just a few days ago approved ride-through rules for large computational loads that contemplate co-location with energy storage resources?
I've heard something about that in the news, but I didn't get to read the entire article.
Shifting gears, we talked about the ESAs that are coming online a lot. Safe to assume that more ESAs will be signed by the end of the year,
Yes.
especially if there were a deadline in place after which a large load tariff applied.
I can't guess at what a customer's business decision, a customer's business decision would be.
Okay, moving to your testimony about ESAs. To keep this brief, in a couple places in your testimony say there's something Duke should do. So we're talking about if Duke, I'm trying to be shorter and taking longer. The question I'm trying to ask is, in each place where you say use the word should, is that something that the public staff is proposing that the Utilities Commission require?
Could you give us an example of that?
Page number, line number.
Yeah, 1 second. So if you look at page 41, lines 6 to 8, you say if DEC needs to update the language within an ESA or in circumstances warranting a unique ESA between DEC and an LLC, DEC should seek commission approval.
I see that.
And just to be clear, are you all proposing that that would be a requirement?
Yeah, if Duke wants to update the language, update the language within the ESA, it should seek commission approval. It can't, and what that sentence is saying is that Duke should not unilaterally update the language within the ESA before getting commission approval.
And I think that goes along with our recommendation that we've proposed this pro forma ESA. And so we're saying that should be the pro forma ESA. And if any changes are made to it, Duke should seek approval to have those changes made.
I'd be more comfortable if we said Duke must seek approval.
So that's right.
Okay, that's what we mean. We mean,
Thank you. No further questions.
Thank you, sir. All right, next in the queue is Nucor.
Presiding Commissioner, would this?
Oh,
be the
that's right.
time
You
for-
do have a couple of exhibits here. Yes, yes, sir.
I would move at this time to enter into the record NCJC et al. Cross Public Staff Large Load Panel Exhibits 1 and 2.
Without objections, your motion is allowed.
Thank you.
Presiding Commissioner Ben Snowden here from
Yes.
Microsoft. It has occurred to me that I neglected to ask that my exhibit be admitted to the record, so I would ask for that now,
You
please.
were correct, sir. I noted it. Without objection, your motion is allowed.
All right, thank you.
Mhm.
Good afternoon, Commissioners. My name is Joseph Briscar. I represent Nucor Steel Lexington in this proceeding. How are you today?
very good, thank you.
And I think everything's been pretty much asked, but I have a couple clarifying questions. As you've discussed, to qualify for the large load tariff, there is an 80% load factor requirement, right?
Yes,
And this would be an anticipated 80% load factor?
yes, well, it would be either anticipated load factor or an existing customer had an 80% load factor and an incremental increase in load of 50 megawatts.
Okay. So it's anticipated if it's a new customer, but if it were an existing customer, you would be looking at their existing load profile. Is that right?
are you talking about a customer that is expanding service?
Expanding.
If it's expanding service, it has to sign a new ESA. And I would recommend during those negotiations that the customer work with Duke Energy, say, hey, tell them what their anticipated load factor is going to be.
Okay. We'll look quickly at your testimony. I believe this is the second corrected on page 29. Lines 9 through 11, you state, for purposes of tariff eligibility, we are recommending a minimum load factor of 80%. The load factor is a customer's average energy usage divided by its peak demand over a specific period. Is that right?
Yes.
What specific period is the staff recommending? Is it annually, monthly, something else?
I'd have to go with annually.
Okay. You talked with several council today about the applicability, but I do have a couple clarifying questions. As you just said, the tariff says that incremental service would be required to take service under the large load tariff, right?
Yes.
And when you say incremental service, you mean existing customers that are adding new load or an expanded load, right?
Yeah, something above 50, an incremental increase of 50 megawatts or more.
That's right. And I think Dr. Weaver said earlier that it is an expansion of 50 megawatts or more, right?
Yeah, so regardless of what the existing customer's current load is, if they're adding 50 megawatts of load or more.
Okay. And it does not apply in a situation where a customer adds load to bring it. Let me give an example. So if a customer has an existing demand of 30 megawatts, they add 25 megawatts of demand to bring them to 55 megawatts, the tariff would not apply in that situation, right?
That's correct.
And in the event a customer were to add 50 megawatts of load, these provisions would only apply to the incremental load. Is that right?
It's hard to separate. I mean, some of the provisions like building extra facilities would apply for the whatever the incremental increase was, because assuming that assets to serve the existing load are already in place.
Okay, I think it makes sense. But regardless, in either situation, whether it's an expanded load or a new load, it's a minimum load factor of 80%, right, for the tariff to apply?
Yes.
Okay, that's all. Thank you.
Thank you. And Walmart?
Yes, Your Honor. I will do my best to stay within my 10-minute allocated time. I'd like to start where we just concluded. So you have an existing customer, add 50 megawatts of load. Are the minimum demand charges going to apply to just the 50 megawatts or to the entirety of the customer's load?
It'd be just the incremental increase, because let me explain why. If it's going to add that load, it's going to have to negotiate a new ESA and have a new contracted demand. So that new contract would be, the requirements would only apply to that new 50 megawatt load.
But then the customer would also have to completely separately meter that facility to ensure that those 50 megawatts were kept separate from the pre-existing load. Isn't that fair to allow all of those calculations and billing under the new tariff provisions to only be applied to that incremental load?
I have to think about that. As far as meeting minimum billing demand, that doesn't have to be metered. If it, say it's contracting for an additional 70 megawatts of load, it would always be billed for at least 75% of the 70 megawatts of additional load.
Well, but so, okay, so let me ask this question, because in response to Nucor's counsel, what I thought I heard you say is that the load factor and eligibility for the tariff would only be determined on an annual basis under public staff's proposal, correct?
Yes.
Okay, so the only way you would know that is either by estimating or assuming on the front end that the customer is going to have an 80% load factor or by waiting a 12-month period after taking service to determine if in fact the customer had an 80% or higher load factor. Isn't that right?
I'm not sure I follow your question. Can you ask that again, please?
Let me try again. So, and I'll break it up into two parts. So one of the ways in which you can know that a customer has an annual 80% load factor is to have 12 months of load data.
That's correct.
The other way is you assume that they're going to have an 80% or higher load factor based upon information that they have given at the time of executing the ESA.
Yes.
And so, but if in fact a customer over the course of those 12 months did not maintain an 80% load factor, what would happen?
Well, if it's contracted for 80% or higher load factor, it would still have to meet the contract that it's signed with Duke.
Okay. Okay. Then in response to some questions from Microsoft Counsel Snowden, there were a couple of questions about the funds that are advanced, and the back and forth that you had was, do those advanced funds close the gap? And I think that your answer was yes. Do you recall that?
What do you mean by advanced funds? You mean required facility charges?
I think that was the context
Yeah,
of the discussion that you were having.
That's the intent of required facilities charges, is to close whatever gap between what the customer would pay without those charges versus what Duke's going to have to spend to serve that customer.
Well, and I apologize. I actually think that the discussion that Mr. Snowden was focusing on was under the current ESA, which is sort of these advanced funds that are being provided.
Okay, okay. I'm asked a question regarding those funds.
So the context was, do those advanced funds close the gap between as I understood it, between what the company is expending in order to serve that customer in between when those funds are advanced and when they take service?
It depends on where that level's set. If those advanced funds are insufficient to cover Duke's investment, then it would not close the gap.
But are those advanced funds actually applied to offset costs?
They are, but if they were too low.
If I might, I think there's sort of two gaps that are being discussed here that might be being conflated. There's the timing of Duke needing to make investments and incurring costs to do so. And then, it takes a while for the customer to come into service and repay. And so the refundable advance is helping with that timing lag. But then we're also saying that there's investments that Duke is incurring, and we don't know necessarily that refundable advance is covering the entirety of the cost of the investment.
I guess where I'm getting hung up is if it's a refundable advance, what is it offsetting if it's refundable?
Exactly. It's helping with the timing so that Duke has that capital up front and then it refunds the capital eventually. Okay. It's not necessarily helping with the offsetting the costs.
As the customer every month pays its bills, it is contributing to the assets. It's helping pay for the assets that Duke built. So if it's advanced payments and Duke's recovered its cost, it can release some of those advanced payments back to the customer because the customer's made Duke whole in some part.
Okay. I also would like to go back because I want to make sure that I understood the discussion that you had with Mr. Jimenez about figure 2 on page 27 of your testimony. And it discussed that you have a higher number of ESAs that are less than 50 megawatts in size than you do total number of larger ESAs. Do you see that on figure 2?
Yes.
And I just want to make sure that I understand. Some of these ESAs that are less than 50 megawatts, it was my understanding based upon your testimony at, I believe, page 34, lines, let me make sure I get you the right site here, lines 6 through 11, that if those facilities were in a campus or located within 1 mile of one another, that even if they individually were below 50 megawatts, you would aggregate them together for purposes of qualifying for public staff's proposed large load tariff. Am I misunderstanding?
Well, make sure I got it clear. That was for one customer that had.
That's right.
But load. If they had multiple meters or even within a mile, if they had 2 facilities within a mile of each other, that load would be aggregated to trigger the requirements.
So if you had 3 25 megawatt same ownership customers, you would aggregate those loads and they would be subject to the large load tariff.
Yes,
So simply because the figure 2 shows that there are ESAs for loads less than 50 megawatts, it does not mean that each and every one of those ESAs would not be subject to public staff's
that's
proposed
correct.
tariff.
Some of those could fall in if they're,
But to be clear, I don't think we're speaking to whether or not that hypothetical is true. Like, we don't.
That's right.
No.
But as proposed, your aggregation proposal could bring in smaller size, like less than 50
Yes.
megawatts individual, if they meet your aggregation definition.
yes.
I do want to ask for purposes of clarity of the record, and I'm not sure if this is a public staff question, Your Honor, or a Duke question. But earlier you all had indicated that the marked as confidential public staff exhibit 4, the Form ESA with their red lines, did not need to be maintained as confidential. Would there be any objection to that now being filed in the docket as a now public record so that the parties can more easily cite to it throughout the proceeding?
There be any objection?
No objection from Duke Energy.
And so then knowing that we're going
Let's hear from the public staff.
Yeah, thank you, Presiding Commissioner. That was an issue. Thank you, Councilor Walmart, for flagging that. That was an issue I was going to address, and we propose to address that in either however the commission directs us to. I've seen in other dockets where simply the confidential header, the word confidential, is stricken from the exhibit once it's been released as a public exhibit. So we are happy to refile it without the confidential designation if that's the commission's preference. Otherwise, it can simply be stricken.
Striking it is certainly one way to do it. I think it's cleaner if you just go ahead and refile it, and then it's real clear that it was not somebody slipping up when it got out there.
I think that's great. We'll be happy to do that.
Sure. Thank you.
And I think the last issue I just want to address to ensure that the record is clear. You all had a number of questions back and forth with Mr. Snowden about whether or not your all's proposed tariff would override the bargain for terms of a pre-existing ESA. Do you recall that discussion?
Yes, I do.
And I just want to make sure that I'm clear. If we look at Exhibit 4, and I'm looking, I think, right now at page 1 of 13 at paragraph 7.
Yes.
Only the language that is in blue is language that has been proposed by public staff.
Now mine is green, but it's the very last sentence is only proposed.
So the underlined language or struck through language, sort of red line, no matter what color, I guess yours appears, to the extent it is not marked through or underlined or anything like that, that is the pre-existing Form ESA to your knowledge.
Yes.
Okay. And so you did not then propose, you proposed an addition, but with respect to paragraph 7 that says that the agreement is subject to changes or substitutions, either in whole or in part, made from time to time by a legally effective filing of the company with, or by order of the regulatory authority having jurisdiction. You didn't add that language.
I did not, and this is what most of the large load customers that have ESAs have signed.
Okay, and so to your knowledge, the existing ESAs already have within them contractual terms that put those large customers on notice that they are subject to changes that may be approved by this commission.
Yes.
Thank you. Those are all my questions.
Okay. It looks as if all the interveners who had reserved time have had an opportunity for cross-examination. Will now give public staff a chance for redirect.
Thank you, Presiding Commissioner. Panel, I'm not going to try to redirect on every topic that has been asked to you today. We might be here for longer than the commission wants to, so I'm going to try to focus. And if I jump around, please let me know if you need time to catch up. You were asked questions from counsel for Amazon regarding considerations for a longer load ramp than was contemplated in the public staff's tariff and ESA. Do you recall those questions?
Yes.
Does a longer load ramp further extend the time delay between costs occurring and costs being recovered from cost causers?
It could be, because Duke has to have facilities in place to serve wherever the customer is on the ramp, has to have these facilities ahead of time. So yeah, that could happen.
would that scenario potentially shift costs to other ratepayers during that longer ramp period?
Yes, if the large load customer had not paid for the facilities ahead of time, that longer ramp period could have those costs borne by other customers.
And if I could add to that, part of that is the regulatory lag that I think has been alluded to, that, you know, even as these customers are coming online and they're ramping, that doesn't mean that a rate case has happened yet that includes those sales. So the costs are coming before the full revenue of the customer.
Okay. I wanted to move on. You were asked a question about whether this panel or the public staff had a definition that it had contemplated for the use of the word emergency.
Yes.
Do you recall that question?
Yes.
I believe that was from also counsel from Amazon. Are you generally aware of the existence of NERC reliability standard EOP 11, which requires balancing authorities to develop plans to mitigate operating emergencies?
Yes.
Are you generally aware of the existence of, quote, emergency load reduction plans and emergency procedures, quote, filed annually by DEC in docket E100 sub 10A, which is DEC and DEP's incorporation of NERC standard?
Yeah, I'm generally familiar, yes.
All right. Are operational emergencies generally defined by industry standard terms and definitions, such as energy emergency alert levels EEA 1, 2, and 3?
Yes.
Would you expect that curtailment of large load customers would generally occur during system emergencies as defined by those EEA events?
Yes.
Anything else for the panel? I want to give you all the opportunity to speak if you want. Okay. You were asked questions from both Council for SIGFR and CUCA regarding the use of the 80% load factor and sort of what consequences that might have on existing manufacturing or other industrial customers. And so I think just so that it's abundantly clear in the record, can you sort of explain what that 80% load factor means?
It means that if a customer had used its maximum demand 100% of the time, that would be a 100% load factor. An 80% load factor means it only used 80% of the energy that it could have under its maximum demand.
Is it the panel's sort of expectation or understanding based on your experience that the average manufacturing customer or industrial customer in North Carolina operates at an 80% or above load factor?
I don't think very many of them I don't think many of them do.
Okay. And is the use of the 80% load factor as a threshold for sort of establishing eligibility under your large load tariff also a threshold that Duke uses for its proposed large load tariff?
Yes.
Do you think that Duke would have, do you expect that Duke would have proposed that threshold with the expectation that it would sort of apply to traditional manufacturing?
No, I think Duke chose that because of the special circumstances of the new large loads we're seeing.
All right. And you were also asked the panel was asked questions from counsel for Microsoft about conversations that the public staff has had with large load customers and other stakeholders. Do you recall those questions?
Yes.
Does the panel have sort of a recollection of or understanding of any framework or topics at a high level that the public staff discussed with or sought to discuss with those customers?
Yeah, so over the lunch break, I was able to review my notes a little bit on those conversations, and we did send an agenda out before those calls. And so that agenda included various questions we were interested in getting more insight into, including their general position on a new tariff, and then some of the specific terms like minimum demand, curtailment, contract length, exit fees. And then we also talked to them about like their experience in other jurisdictions and that sort of thing. So there was a list of specific questions that they saw ahead of time related to this topic.
Okay. On that similar line of questioning from Counsel for Microsoft, you were also asked if you could indicate specific tariff terms or ESA terms that were informed by those conversations with large load customers. I'm not going to re-ask that question, but at a high level, can the panel sort of indicate general areas or topics or portions of the tariff or ESA that would be informed by those aggregated discussions?
Yeah, so I think the miscommunication there with council had been that we didn't, take any specific proposal from any specific stakeholder. It was all sort of accumulating information and synthesizing it. But we did take into account a discussion regarding minimum demand, the contract length, and also where to set that threshold. There were conversations around those that influenced our decision and when we designed this tariff.
You were asked a question by counsel from Microsoft about the public staff's computation methodology for liquidated damages and the suggestion that large load customers might not be willing to pay those liquidated damages. Can you elaborate on whether the public staff proposed the liquidated damages provisions as a way of ensuring that large load customers that are exiting the system were paying their fair share of systems that were being, or costs that were being brought onto the system to serve them? Can you expand on that?
We were concerned that some of these large load customers might stop taking service before the end of their contract.
And can you speak to whether the calculation of those liquidated damages, whether it was designed to recover those costs?
It's an attempt to recover those costs, yeah.
Okay. And I think, Mr. Lucas, specifically, you mentioned a White House pledge that many large load customers have signed as a commitment to paying. Can you speak more to that? Who are those customers and what have they signed? What is the commitment, rather than me trying to summarize that for you?
Yes, give me a moment. Let me find that. Yeah, this is the Ratepayer Protection Pledge. It was released by the White House on March 4th, 2026. And Amazon, Google, Microsoft, Oracle, some others were signatories to the pledge, and they agreed to build, bring, or buy new generation resources to cover the cost of all power delivery infrastructure upgrades required for their data centers, ensuring such expenses are not passed to American households. Under the Ratepayer Protection Pledge, these companies will negotiate separate rate structures with utilities and state governments and commit to pay these rates for power and related infrastructure brought online to service their data centers, whether they use the electricity or not.
I wanted to turn now to the topic of curtailment. I believe that there was a question designed to imply that the curtailment provision is essentially being forced on customers through the ESA. And so my question is, are you aware that large load customers in North Carolina are signing ESAs that contain curtailment as a bargain for commercial term? As a term of taking service?
Yes, a lot of them do sign ESAs that have curtailment.
And is it your understanding then that those companies that engage or that willingly sign those ESAs make an economic decision as part of taking service, that curtailment is a term that they can agree to?
They did agree to it, yes.
Counsel for Walmart, just before my redirect here pointed you to paragraph 7 of the public staff's proposed ESA and essentially acknowledge that this was existing language in Duke's ESA that was
Yes.
not something that the public staff had proposed.
Yes.
Is it your understanding then that a customer that would agree to a contract that was subject to commission's sort of ongoing review of rates and changes in substitutions, is it fair to say that that customer would expect that those terms might change?
Yeah, they signed the contract agreeing that the rates and other items could change according to the commission's decisions.
Okay. And panel, are you familiar with chapter 62, the definition of the word rate as used by the commission as applying to practices or contracts affecting any such compensation for, in this case, electric service?
Yes.
All right. So, and is it your understanding then that the commission has the authority granted to it under chapter 62 to change rates as circumstances dictate?
Yes.
And in that case, rates could include contracts. Is that correct?
Yes.
I also wanted to draw, actually, presiding commissioner, if you don't mind, I just want to make sure I have the language correct here before I ask
Sure.
this question.
Go right ahead.
Okay. Panel, if you could turn with me to your exhibit 4. This is the Form ESA. And let's go to section 11, subsection F. Let me know when you're there.
I'm there.
Can you, Mr. Lucas, just read subsection F to me?
Sure. The monthly charge for the extra facilities to be provided under this contract is subject to the rates, service regulations, and conditions of the company, as the same are now on file with the State Regulatory Commission having jurisdiction, and as may be changed or modified from time to time upon approval by said regulatory commission. Such changes or modifications shall be made a part of this agreement to the same as effect as if fully set forth herein.
And Mr. Lucas, did the public staff panel add this language to the ESA, or was this existing language?
It was existing.
Okay. And as I understand it, this applies to this particular section applies to extra facilities charges. Is that correct?
That's correct.
All right. Presiding Commissioner, there were a number of exhibits that were referenced by the panel.
Yes.
That I'd now believe would be appropriate to mark and identify as redirect exhibits and then move that they be admitted into the record. So I'm going to go through those.
Let's go.
All right, Miss Weaver, I believe during your testimony, you referenced public staff potential cross exhibit 45. Is that correct?
That's correct.
And if I'm juggling multiple tabs here and comparing to our exhibit index, that was the public staff's analysis of large load impact analysis presenting in the 2025 CPRP rebuttal. Is that correct?
That's correct.
Okay. Presiding Commissioner, at this time, I would propose that exhibit be marked as public staff redirect, public staff large load panel direct exhibit 1.
It's duly marked. And I assume you're making a motion at this time that it
So
be
moved.
admitted. All right. Your motion is allowed
Thank you.
without objection.
All right. Dr. Sengazi, I believe during your response to questions from attorneys here, you identified a potential public staff potential cross exhibit 52.
That is correct.
And before I turn to my index, also public staff potential cross 220.
That is correct.
All right. And as I cross-reference those, public staff potential cross exhibit 52 is a February 27, 2025 Board of Director presentation. And that's a confidential exhibit.
That is correct.
And public staff potential cross exhibit 220 was identified as Jeffries, the Carolina Convergence Regulatory Alignment drives Duke's next chapter, also confidential.
That is correct.
Okay. Presiding Commissioner, I would move that public staff potential cross 52 be marked as public staff redirect, public staff large load panel direct exhibit 2. And I think I should add a confidential word.
You
in there
should
somewhere.
add confidential. That is
Confidential exhibit 2.
That is correct, sir.
And I would move that that be admitted into the record.
Without objection, your motion is allowed.
Thank you, Presiding Commissioner. I would also move that public staff potential cross exhibit 220 be marked as public staff public staff redirect, public staff large load panel direct confidential exhibit 3.
Duly marked and identified without objection, your motion is hereby allowed.
Thank you, Presiding Commissioner McKissick. And lastly, all right. Panel, you all referenced at numerous times throughout your testimony today, large load panel testimony that was filed by this panel in the DEP rate case.
Yes.
And that was identified as a potential cross exhibit by SIGFR. That was SIGFR potential cross exhibit number 26. Presiding Commissioner, at this time, I would move that SIGFR potential cross exhibit 26 be identified as public staff redirect, public staff large load panel direct exhibit, confidential exhibit 4.
Duly marked and identified, and your motion to have it admitted is allowed without objection.
Thank you, Presiding Commissioner. Presiding Commissioner, that is all the redirect I have. Thank you.
Well, thank you. We will now move to questions from our commission staff. And I will alert you in advance that there are a number of them. And give me 1 minute to pull those all up because they have been amended today in real time from what they were coming into this hearing this morning. And as technology would have it, it's not coming up immediately, but give me a second. Go back one more time and make sure this link is. And the link on the third attempt has functioned as it should. There are approximately 17 questions, which does not include the subparts. So you could be here for a while. I would ask you to provide clear, succinct answers. They need not be exhaustive answers. With that being said, on page 5 of your testimony, you state large loads are not unique to one business sector and can include large industrial applications, data centers, and advanced manufacturing. Your testimony indicates that you are familiar with NERC's proposed definition of computational load. Please provide us with your definition of data center and explain how, if at all, you distinguish data centers from NERC's computational load definition?
We don't define data centers, and we really haven't drawn a distinction between data centers and computational loads. Got anything to add?
Okay, so you've not done that at all to make that distinction.
No.
Okay, thank you. I think that eliminates a few of these. For purposes of the next set of questions, let's divide prospective new large loads into two groups. Traditional, which would be a manufacturing plant typically employing thousands of workers, and number two, non-traditional, which would include data centers. Do data centers impose operational risks to Duke's system that are different than traditional large loads? And if so, please elaborate.
There are some types of data centers, artificial intelligence training loads that have a lot of fluctuations. Those could provide, could create extra risks for Duke. Duke might have to install extra protection equipment to deal with that fluctuation.
Okay. Now, on page 7, you mentioned that Duke Energy Corp has approximately 7.9 gigawatts of potential large load customers in the advanced development phase across its combined service territory. It might be helpful if you can provide more granular information about this load, so you can tell us, for example, how much of the anticipated load is expected to be coming online in the next 3 to 5 years.
We can go back and do that. We have ESAs for 6.7 gigawatts, and there are some ramping periods in those ESAs. So we would have to go back and take a look at those. Going back to what's in the planning phase would be a little more difficult, but we believe we can get you some good information on when those loads are going to show up.
Well, if you could provide us with a late file exhibit that would provide that information, it would be excellent.
Okay.
And of course, a follow-up to that, and it might be good that be included as well. Please provide a breakdown of the potential 7.9 gigawatt loads into traditional and non-traditional loads. How many customers and how many megawatts are traditional load?
Okay.
And also, is it your understanding that Duke's ESAs for large load service in North Carolina are and will remain subject to future modification of Duke's North Carolina tariffs and service regulations? I think that's been asked and answered, but to the extent to which you could elaborate further.
The customers signed that they will be subject to determinations by the commission, and we believe that will continue. One reason we propose an ESA in our Exhibit 4 is we want to have a commission-approved ESA. We're concerned that Duke can change these ESA applications at any time. We want to prevent that.
Very good. Are the concerns you describe on page 9, line 18 to page 10, line 2? I'll give you a minute to get there. Are you there yet?
Yes.
All right. Regarding Sutton disconnection and Sutton reconnection, unique to or enhanced for non-traditional loads because of the speed with which non-traditional load, that is computational, can be turned on and off.
We know these disturbances can occur. We're not as familiar with the exact details of how large loads disconnect and reconnect from the grid. We would have to investigate that further. And we do have a requirement in our large load tariff that large load customers file a plan with Duke and get approval of that plan to how to manage sudden disconnection and reconnection.
Okay. And I assume that you are familiar with the NERC definition of computational load.
Generally familiar, but not completely.
All right. This question kind of goes to some of that. Are non-traditional computational loads, electric service reliability and stability needs different than traditional loads? And if so, why?
We don't have enough data here in North Carolina. We've only got a few small computational loads, so we haven't been able to assess that. I can say, like Duke's witness Janice Hager said, what we have for data centers now is very small compared to what we're expecting.
Okay. Is Duke's system currently designed to accommodate sudden disconnection and sudden reconnection of 7.9 gigawatts of new non-traditional load? If not, at a high level, what changes, if any, must Duke implement to accommodate these operational characteristics? And what would be the expected timing and cost of such changes?
We're not aware of Duke's specific equipment or preparations for sudden disconnection and reconnection. It is going to require further evaluation, and it's dependent upon the size and the location of the load, and depending on what Duke Energy, what protective equipment Duke Energy has on the site or nearby.
Okay. Now, did you consider and evaluate the feasibility of a tariff for computational load alone rather than a tariff for all large load, high load factor customers?
We thought about that, but we figured there are a lot of aspects that a non-computational large load could have on the grid, requiring lots of new facilities if it's got a large load and a large load factor. So we wanted to catch all of them, not just have a specific tariff for computational loads.
Okay. Now, are you familiar with AEP Ohio's data center tariff? I think it's scheduled DCT. And if so, what is your opinion of the tariff?
I can't speak specifically. We can check and see if that was one of the ones we reviewed in E100 sub 208. So give us a moment. We'll check to see if that's one of the ones we looked at. That is one of the ones reviewed. These are comments we filed 11 months ago, and we've got some information about it if you have additional questions.
I think the question simply was if you were familiar with it and what your opinion was of that particular tariff.
Okay, give me a moment. Let me take a
Sure,
look at.
take a look.
Yeah, we see some things we like and we don't like. One thing, the minimum contract length is only 8 years. We do like some things about it. It's includes termination fees. It's got cost recovery terms. Let's see, it does not have a minimum load factor. So there's some things we do and don't like about that tariff.
Okay, thank you. You described 3 types of financial risk associated with anticipated large load growth. Number 1 being projected load failing to materialize. Number 2, projected load materializing, but then failing to continue. And number 3, timing mismatches between cost and revenue. Let's focus on the third risk, the timing mismatch. On page 9, you express the following concern. Even if the load materializes as expected, current ratepayers are fronting those costs as the generation, transmission, and distribution assets must be built before large load customers connect and are fully ramped. Are you concerned about any timing mismatches other than the mismatch described on page 53 of your testimony relating to the $198.1 million in dedicated facilities?
We are course, concerned about infrastructure improvements like the dedicated facilities, but I think you had talked about some other timing mismatch.
Yeah, I think this is also getting at more generally the broader investment into the grid of generation and transmission that isn't, directly attributed to any one customer, but the bulk of the load growth that we're seeing and the billions of dollars of investment that will be needed. I think that's what this risk is getting at, and that is one of the challenges of designing this, is it's really hard to address that mismatch.
Okay, now on page 56 of your testimony, you recommend removal of the $188.1 million of costs related specifically to dedicated facilities, which solely serve large load customers. Are other states requiring the equivalent of dedicated facilities to be treated in the same manner? And if so, can you identify those states, particularly if they're states in the Mid-Atlantic region?
I want to say that I have seen that, but I don't know I can't think of the specific example. That's another thing where we could go back and review it in more detail. But sitting here today, I can't give you a specific example.
Okay, if you could prepare a late file exhibit that answers that to the best of your capacity to do so. The next question is, the first two types of financial risk associated with anticipated large load growth involve the risk of stranded costs. To address this risk, you propose large load tariff imposes potential fees based upon extra facility charges and required facilities charges. Do you believe any public staff oversight is necessary to ensure that the relevant costs are computed appropriately? And for some context, I think in pages 17 through 18 of your testimony, you expressed concern that DEC is not properly allocating the cost associated with the significant new generation transmission and distribution plant necessarily to serve large load customers.
Yeah, we do recommend some oversight. We want the all future ESAs to be filed with the commission very shortly after they're executed. That will give public staff some chance to review and the commission to review and make a determination if there's some kind of problem that we foresee that would create an unfairness to other customers.
And I think as well as things come into service in future rate cases, we would review specific projects at that time as well.
Thank you. Does the public staff contemplate any process for it to validate the reasonableness of prospective customers' proposed contract demand or load factor to reduce any concern about the risk of manipulation?
Yeah, we do. We do discuss that in our testimony. We ask that Duke stay vigilant and see if any customers trying to game the system and alert the commission.
Why in your proposals are you seeking to include collateral requirements in the form of ESAs rather than the tariff?
Well, the ESAs are an initial contract. They would obligate both Duke and the large load customer. There would be some requirements made for advanced funds, setting out a ramping schedule, other things that would occur. Generally, the requirements in our tariff start the day the customer takes service. And there's a little bit of overlap, but we see a difference between the two.
Okay. Who's responsible for monitoring ongoing credit rating changes and liquidity coverage? And what do you understand the consequences of a failure to properly monitor them to be?
We put that responsibility on Duke Energy, and that I think it has put some of that in its ESAs as far as like getting letters of credit and that sort of thing. Duke Energy is going to have to monitor that.
And I guess that takes into account any type of changes or reductions that might occur that would be ongoing.
Like the credit rating of a customer. Yeah, Duke should monitor that as well.
All right. And in your opinion, who bears the risk of full or partial credit failure? The contracting utility or its retail customers, e.g. failure to recover on a parent guarantee? I guess if there's a parent company
Oh, the
that,
parent guarantee, if there's a parent company that guarantees, that parent company should be responsible for, if that parent is part of the ESA and making part of the guarantee, that parent should be liable.
and with regard to proposed large load tariff, you state on page 27, and I'll wait for you to get there.
From there.
Okay. We believe that 50 megawatts is an appropriate threshold for the tariff to apply to large load customers that desire to interconnect with DEC because it exceeds the demand of the majority of traditional commercial and industrial customer loads and marks the threshold at which DEC might need to make substantial incremental generation or transmission and distribution investments to serve the customer. This threshold is slightly higher than the average of other approved tariffs we reviewed in docket E-100 sub 208. What is the approximate average threshold level in your tariff survey?
I'm sorry, Commissioner, I don't have that number on me right now.
All right. This one may be more challenging with that in mind. How many commercial industrial customers of Duke are currently expected to meet the 50 megawatt threshold as you define it?
We can go back into the ESAs and see which ones are 50 megawatts or greater. We may have to work with Duke and see if there are any that have anticipated load factor of 80% or greater.
Okay. We may get you to do why don't we just get you to do a late file exhibit to address that?
Okay.
And there's some subparts of
Presiding
this
Commissioner,
question.
I'm
Yeah.
so sorry to interrupt you, just so that their attorney has the request clear and can apply with your directive. Can you give some clarity on what that late filed exhibit should look like? I just want to make sure we have that.
Well, I know that the question was how many commercial and industrial customers of Duke are currently expected to meet the 50 megawatt threshold as you defined it. And there are a series of subparts here. I think 3 of them are additionally that might help provide the clarity in terms of additional information in that late file exhibit. For example, how many commercial industrial customers of Duke would be expected to meet the average threshold level in your survey? I think that relates back to the survey that was referred to earlier. How many commercial industrial customers of Duke would be expected to meet a 25 megawatt threshold? And then thirdly, if the commission were to adopt a computational load tariff using the currently proposed NERC definition of the term, would you expect any existing Duke industrial or commercial customers to be subject to the tariff? So perhaps certainly the first 2 subparts would need to be there. I don't know if you can address that third one.
We'd have to go back and review more thoroughly the NERC definition to make sure we answered your question correctly.
Okay. That would be excellent if you could do so and just answer it to the best of your capacity. Next question here on page 30. Your testimony says, and I'll wait for you to get page 30.
We're there.
All right, requiring 75% of contract demand as the minimum billing demand will allow DEC to receive payment for most of the contract demand while allowing the large load customers some load flexibility. The minimum billing demand will help ensure the capital cost recovery is not completely shifted to the broader customer base if the anticipated load fails to materialize. That's in quotation marks. If Duke adds 7.9 gigawatts of new large load over the next 10 years, what is the approximate dollar magnitude of the risk that will be shifted to the broader customer base if your minimum billing demand proposal is adopted?
Of course, that would depend on customers failing to meet their commitments. So that's hard to anticipate. If every customer does what it's supposed to do and our required facilities charges are in place, then no costs would be shifted to other customers. I guess we're depending on watching if other customers have a higher failure rate or have any kind of failure rate. There is that risk, and we can't see that other customers won't pay a single dollar for what large load customers have created costs for. We think our recommendation minimizes that. It'd be very difficult to put a dollar amount though.
Yeah,
Go right ahead.
I just want to add that cost is also just difficult to quantify. Like we can say how much Duke is planning to invest, but that investment is covering load growth in other sectors. It's covering generation that's replacing coal retirement. So pulling out exactly what these customers would be, incrementally incurring would be extremely challenging.
Understood. Your proposed large load tariff requires that customers provide a NERC compliant written plan to the company and receive company approval for managing incidental sudden disconnection and reconnection of load to avoid grid disturbances. Can you give us a sense of what you are expecting a plan to say, given the sensitivity of computational load to grid changes?
Yeah, so I don't know that I can speak to the exact details of what might be in a plan. The goal with that provision was to ensure that communication between the utility and the customer is occurring, trying to get at some of those reliability issues that have been seen in other jurisdictions like Virginia and Texas with the sudden disconnection. From what I understand, some of that issue was because the customer and the utility were not on the same page about what would happen in those situations. And so we wanted to make sure that Duke is taking the opportunity to communicate with the customers, level setting expectations, and then they can put forward a plan that hopefully tries to avoid those kinds of issues occurring here.
Thank you. What is the contemplated consequences of a customer's failure to adhere to the plan?
A customer could disconnect and reconnect in a matter of seconds or less. And Duke Energy has some sensitive equipment, some of the relays, some of the electronics that it uses to manage the grid can't manage that sudden surge, especially if it's hundreds of megawatts, capacitors, that kind of thing. They cannot manage very large shifts in load over a matter of seconds or even less in milliseconds. So that's why we're asking for this plan. So the customer is aware ahead of time, and Duke has time to assess what it's going to have to do and how much money it's going to have to spend to provide some kind of sudden disconnection and reconnection, or manage what the customer's expectations are. If the customer can put in control equipment to prevent any kind of grid damage from its disconnection and reconnection. So it's either side, Duke and the customer can both make efforts to protect the grid.
Thank you. Now, on page 38 of your testimony, you state, now wait, you get to page 38.
Okay.
You state this cost recovery will require DEC to update its method of determining contributions in aid of construction, CICA, to ensure revenue received from the customer is sufficient to cover the total cost of required facilities and typical cost to serve. This change is a break from historic practice which socializes these costs across classes. Now, would this change apply only to large load tariff customers or all transmission connected customers?
This could require to other customers. We've put some of these requirements in our service regulations, so it could apply customers that aren't captured by our load large tariff.
Okay. Now, did we consider a dollar threshold for the relevant cost in connection with or in lieu of the load size threshold?
It's like $1 of investment by Duke Energy.
Yes, I believe that's what they're going through here. Mhm.
That is one consideration for amount of risk. If a large load customer only created $500,000 of investment by Duke, that's certainly a lot less risk than another customer that creates $100 million of asset investment by Duke. That could be one consideration.
Okay, now on page 39, and I'll let you get to page 39. You state that a large load customer could attempt to avoid the required cost or characters required by Schedule LL by misrepresenting its expected load factor. This scenario may be unavoidable. We also recommend that the commission require DEC to monitor the load characteristics of new customers whose load and load factor meet the criteria for Schedule LL and require those customers to begin using Schedule LL at such time as they meet the Schedule LL qualifications. Since many of the provisions of the LL tariff that are presumably designed to protect other ratepayers need to be implemented before electric service is actually delivered, have you considered any approaches that are more proactive than monitoring after electric service begins? For example, could service be required to be established using typical or average load factors or a preset schedule of load factors for the relevant types of customers, and then allowing the customers on a case-by-case basis to be relieved of large load tariff obligations if the actual load factor over some relevant experience period is lower than 80%.
We could require a large load customer to provide more information to Duke. It can provide not just a contract demand, but an actual demand that could be lower. Also require that customer to provide load factor and with calculations to how it's going to use energy under its contract demand and under its actual demand.
Okay. Now, Dr. Weaver, at last year's large load technical conference, the public staff presented an analysis of large load tariffs being developed in other states. As you have continued to study this issue and refine that analysis, what specific tariff provisions from those other states stand out as most noteworthy? Put another way, which provisions do you believe the commission should pay particularly close attention to as it considers North Carolina's approach to this issue?
Sure. So I will say that I haven't, fully done an updated analysis like I had for the large load docket. So I'm sure there are things that are new that I haven't seen or things that have since been approved. Some provisions that stood out, and I apologize if I can't give specific tariff examples, but I think the tiering structure that other places have employed that we've attempted in our own way here is really valuable considering just the broad range of types of customers. I think there's a lot of really elegant ways other places have implemented the termination damages or exit fees. We've put forward our proposal, but there are definitely other ways to do it that might be just as valid. Let me think if there's anything else. Those are the main two that come to mind.
The most pertinent ones that stand out. Thank you. Now, your confidential Exhibit 2 provides a summary of DEC's filed ESAs under E100 sub 208A and demonstrates how contract provisions vary among customers. Without going into confidential session, can you speak to what provisions were changed the most from the template ESA to the executed ESAs or any other notable observations?
This doesn't necessarily reflect a change in the ESA, but maybe just capturing the timing of the changes and when things were signed. It's a little bit complicated, but the curtailment provisions is one that stands out to me. I'll let my colleagues add.
Yeah, contract terms are another one. The ESAs aren't consistent on the length of term of the contract.
Right.
Some ESAs do not have a minimum billing demand. Some ESAs do not have liquidated damages. Some do not have force majeure allowances.
The load ramps as well can differ between different ESAs.
Could you speak a little louder, sir?
The load ramps can also differ between different ESAs. Some load ramps might be quicker, some might be a little slower. Some ESAs have delineated measured amounts that they should reach. Some are a bit more loose just by certain dates.
Yeah, those are the main differences that we've seen that change throughout past 2 or 3 years on these ESAs.
Thank you for carrying those observations. On pages 17 through 18 of your testimony, I'll wait for you to get there. All right, you state a concern that DEC is improperly allocating costs associated with large load customers, resulting in particularly severe levels of both inter and intra-class cross subsidization. What evidence did you find to support this contention or concern?
So in our investigation, based on data that Duke provided or DC provided, they were able to provide us information regarding various projects. If we were to look at our figure, give me a moment. If we were to look at our figure 4 on page 48, Duke or DC provided information to us for 6 projects within the DC territory that they designated as large loads for single customers. From there, they're able to provide various information for transmission plant, distribution plant, and there was a little bit of generation plant for these 6 large customers. And by their own designation, they were able to delineate and provide information for us for transmission, distribution, and generation assets that were solely meant to serve these particular large load customers. And then also transmission, distribution, and a little bit of generation assets that were incurred or I guess propagated by these large load customers, but had larger benefits for the system. And what we show here in this figure, which we can talk a little bit more about, is that a great deal or great percentage of the costs that are being requested to be put in service, at least in the direct testimony of DC, were actually being designed or being built for specifically just single customers or single large load customers. So that's the basis for many of the concerns that we've mentioned today.
And just to add to that, part of the concern is coming from Duke has this method for calculating the contribution that customer should be making. And we were finding that that calculation didn't seem to sufficiently actually result in the customer contributing to the project. So that mismatch was our concern.
And how does your proposed tariff address this cost allocation and cross subsidization concern?
I'm sorry, can you repeat the question, please? I'm
How
sorry.
does your proposed tariff address this cost allocation and cross subsidization concern?
Well, we've asked for required facilities charges and dedicated facilities charges that will require these large load customers to pay for these grid assets and not allow Duke to socialize them across all customer classes.
Thank you. Now, on page 37 of your testimony, you categorize upgrade types required to provide standard service to large load customers as extra facilities requested by a customer for service exceeding the standard service. Now, in the case of a large load customer, how do you define standard service?
I can find that. That is in the service regulations. Give me a moment.
Sure.
That would be service that's at more than one point. Extra facilities charges also apply for service that's through more than one meter, more than one voltage, more than one rate schedule. Those are at the beginning of the paragraph on extra facilities charges on page 15 of the service regulations.
Thank you. Now, in Exhibit 5 on page 3, I'll give you a minute to get there.
I believe we're there.
Okay. And of course, you add that a specific CICA study is needed for customers larger than 50 megawatts. Can you explain more about how such a customer-specific CICA study would be conducted and audited for accuracy?
Duke is going to have to figure out what kind of facilities are needed to serve a customer that's greater than 50 megawatts. And we didn't think the existing service regulations were adequate. It's just concerned that the customer would not produce sufficient revenue without any real definitions of what sufficient revenue is. So we added the section in red to require Duke to go back and figure out what was needed specifically to serve a customer based on cost of service requirements. I can read some of it to you and take into account what the approved rates the customer has. Duke's going to have to figure out what costs it will recovery from the rates, but also figure out what additional costs the customer is going to create. And then and using that, figure out what contribution aided construction, how much money the customer should either pay in advance or pay in addition as a required facilities charge.
Thank you. I think that's covered all the questions that came from our commission staff. So I now want to look to my fellow commissioners for questions, beginning with Chair Brawley.
No questions.
All right, Commissioner Tucker.
I can take you up to 5 o'clock, or at least I can let my phone alarm and wake everybody up.
Okay, why
The
don't
way
we,
I see this crowd right now. Go ahead, sir.
we'll just go to 5 a.m. How's that?
Okay. That'll work too.
That'll work too. All right.
Yeah, I think what I'll cover has been covered. I just want to ask a question affirmative. I think it's in your testimony on page 48. line 3, 4, and 5. Mr. Lucas, if you'll read that. Page 48, sir, line 3, 4, and 5. I'll be glad to read it if you need me to.
If you wouldn't mind if Dr. Sanganzi read it, I think he's the only one of us that actually has the correct.
Okay,
correct
doctor,
version.
go ahead, sir.
Just to confirm, does it begin with the investments?
Yeah, the investment.
Okay. Lines 3 through 5. The investments to serve these 6 large load customers are shown in figure 4 below, totaling 247.6 million in capital costs, for which DEC is seeking recovery from ratepayers in this proceeding.
Okay, so ratepayers are going to be paying the 247 million for 6 data centers. Is that what I hear?
That is a correct assessment.
Yeah. Okay. Difficult assessment, but we'll move forward from there. This question is, to the extent that ESA customers are driving the load forecast that necessitates some of the revenue requirement before they start taking service, what solutions has the public staff considered to allow those customers to make upfront payments now to minimize the impact to other customers?
We have in the ESA application provision for the customers to make advance payments. So that would, assuming those advance payments are sufficient to pay for the investments by Duke, then we believe that would protect customers.
Well, in your testimony, I think you state that Duke, you're concerned about the lack of the size of the tariffs. So how can you be comfortable with the fact that you're going to get the upfront money necessary to offset some of the costs for other customers? Like this 247 million.
It might not get the money up front, but we are requiring the required facilities charges that the customer should pay to offset that cost.
Okay, so you stated 6.7 gigawatts.
Yeah, that's the total of the 29 ESAs we have so far.
Okay, and then Commissioner McKissick mentioned 7.9 gigawatts.
That's in the planning, that's the advanced planning phase. Not all of that 7.9 has an ESA yet.
And then you stated you couple that with the fact that Duke plans to retire 8 gigawatts of coal.
Of coal fire capacity.
Yes, sir. Do I hear from this panel the angst about the requirement for generation for Duke and the amount of capital required to meet these load requests?
Yes.
Okay. Commissioner McKissick asked you about what was, I think you call industrial traditional projects and data non-traditional projects. How was that split in the review of ESAs that you made?
We'll have to go back and look.
I do actually have this number because I thought Commissioner Tucker might ask.
Thank you, Doctor.
So all I can give you is data centers versus non-data centers. I don't have the full breakdown, Commissioner McKissick, but in the current ESAs that the public staff has, by customer, it's 57% data centers, and then by load, it's 92% data centers.
Okay. That's a lot. Okay. Well, that's clear because you anticipated I was going to ask that question.
He read your mind.
Yes, you read my mind,
I'm
and that's okay. Should make, never mind.
That's scary.
Let me ask you a question. It's been read twice. The President's Ratepayer Protection Pledge
Yes.
that was published. You
Yes.
read that twice. You are aware for sure that Microsoft, Google, and Amazon were represented here today, right?
Yeah, I mean, go back.
Three councils subject to check.
Yeah, they were subject to that, and I'm not saying Polk staff agrees with every word of the ratepayer protection pledge, but certainly the customer protection parts of it, we do agree with.
Okay, and so you've read the stipulations that the signatories agreed to in 1, 2, and 3, correct? You're welcome to look at it. You're welcome to look at it
The
again,
ones that were
sir.
in my testimony or the
one's in your testimony on page 19.
Okay.
I think it would be lines 18, 19 through 1, 2.
If I may read them.
Yeah, you're welcome
Just
to,
to
sir.
confirm. So number one, build, bring, or buy the new generation resources necessary to serve their load. Number two, pay for the new power delivery infrastructure required for their service. And number three, pay for demand and infrastructure requested whether they use the electricity or not. Is that correct?
That is correct. What part of that, Dr. Gonzalez, do you see where this pledge from the White House is saying that ratepayers should pay for 1, 2, and 3?
From my assessment, ratepayers are not included in 1, 2, and 3.
Then that must be why they call it a ratepayer protection pledge.
That would be a correct assessment.
Okay, and so, but you're saying over here that on these 6 LLCs data centers, that ratepayers are going to pay $247 million on page 48. You read it earlier?
Yes, that is, in my understanding, something that DC has requested, and I believe the commission has ability to provide some opinion.
Are you stating that these ratepayers are the ratepayers that are not stipulated in the president's ratepayer protection pledge?
I may not be able to give a legal opinion, but I'll let my witnesses.
believe
I don't
we've
know
got-
that it's
we've got- we've got
legal.
some we got a few ratepayers mentioned here that are data centers. They, how I interpret that pledge is those few ratepayers or large load customers, whatever you want to call them, they should pay. No other customers should pay.
Okay, very well, sir. Okay, I'm gonna, well, let me look at my notes here. I promise it won't take much longer. For the record, are you aware of what the book value is for the 3 companies represented here that are to be paying these expenses for new generation and infrastructure in this pledge?
No, I'm not sure of their book value, but I'm sure it's very large.
Yes, sir. Would you like to know?
Yeah, yes.
Yes, sir. Okay, I don't want to testify. I just want to say that according to the internet, Amazon's book value is 2.64 trillion. Microsoft is 2.86 trillion, and Google is 4 trillion. So my point is, would you think that they would have better ability to pay for the infrastructure and generation for these projects than the 247 million of those ratepayers that were recognized here in your testimony?
Yes, because they're building these data centers to make money. These are
Right.
money generating assets that will allow those companies to pay for the assets they use.
Right. Well, let me back up. This also too is not only about ratepayer protection pledge, it's also about national security, that we need these data centers, but we need to find a way to pay for them without the impact to your residential ratepayer. Would that be correct?
Yes, we're not saying data centers are or not essential. Some of
Right.
them can be essential.
Right.
We just don't want them to shift their costs to other customers.
Okay, and back on, golly, I lost the page, but there was a graph that, here on page 54, it talks about that utilizing illustrative calculations, this customer would pay approximately 402.2 million annually to do. You see that there on the bottom of 54?
Yes.
Okay, so these large loads customers run 24/7, 365. So they are absolutely the kind of account, if I was in the electric generation business, would you agree that Duke would want to have?
Yes, I mean,
Yeah.
these customers, in this example, this customer uses $400 million worth of electric service, so it should pay for $400 million worth of electric service.
Right, and in Mr. Sedaris's comments, did he not say that his economic team was recruiting data centers 7 days a week? Yes, sir. Oh, that's confidential testimony. I'm sorry. Well, we're all over confidential here. Sorry, Miss.
I don't, excuse me, Mr. Commissioner Tucker, I don't think that specific quote is confidential,
Okay.
from Mr. Sidarius.
Okay, well, I've said what I need to say. That's fine. He's doing a good job of representing Duke. Let me just lay out a hypothetical scenario, somewhat real and somewhat not, and you answer the questions for me. A real transmission line was presented to us to be run about a month ago for a specific data center in Richmond County. The line would not have been run, which cost 2.75 million, had the data center not been situated and planned to come online. Who pays for that $2.75 million transmission line now as we sit here today?
Right now, that cost be socialized to all customers.
Ratepayers.
Yes.
Okay, very well, sir. That did not count the substation, nor did it count the generation required for the data center. So in my hypothetical scenario, 2.75 million on one side, cost of the substation added to that. And then down in that area, Duke is planning to build $1 billion 900 megawatt gas plants. Why could you not eliminate the discussions about tariffs, modify the ESAs to state that the 2.75, the 60 million for the substation, and whatever the cost, say the cost of the gas plant's $1 billion, and they're going to take 300 megawatts of that load in that data center in Richmond County, they could pay a third of the $1 billion for the gas plant, the $60 million for the substation, and the $2.75 million for the transmission line, and we would call that rate fronting. That's a new term, paying the rates up front. That would not require Duke to have to borrow money. That would not require necessarily that there be a rate increase for data centers. And then it would be somewhat of a clean break up front. And then when they come online, the data center come online, Duke could rebate that off of their bill. Currently, we talked about one that was going to have 400 million a year that they would be paying on their electric bill. If it's a lesser size, it would be a different amount of money, and spread that over the 15 years of the ESA contract. And we don't have to borrow all this money. We can build all the facilities they want. Duke Power can own that facility. What holes can you shoot into that, Mr. Lucas, to not allow that scenario to take place?
Generally, what you described is what our required facilities charge recommendation is. So Duke could allocate like the dedicated facility, like the transmission line or any substation transformers specifically to serve the large load. Yeah, that's dedicated facilities. A customer can pay for that. And then there are required facilities further upstream that the customer uses a percentage of, and Duke would have to determine what portion of that facility, of those facilities that the customer is using, and put that in the required facilities charges.
And if I could add, I think one of the tricky things about the hypothetical you laid out is that generation piece. So the transmission and the substation where it's the customer needs that they're the only ones who are using it. That is our proposal with our dedicated and required facilities. But the generation is tricky because it's not like that plant has a hookup directly to the data center. The data center is drawing on the broader system and all of those assets. And so I think it might be a break in the way we've done rate making in the past to directly assign generation in that way.
And that was
Dr. Weaver, just in response to you, we've heard, have we not, unprecedented, unusual times, historical increase. All I'm saying is why, looking at all of this, why would not be the reason, and anybody can answer this on the panel and I'll be quiet, but why can we not look at optionality like this and cost causation like this to not impact ratepayers so much, and to be able to take some of the pressure off Duke having to go out and find investors to invest in these highly on-off situations, connect, disconnect, not ramping all the way up to the load, tariffs, all those things, just make a clean break. That's all I'm asking. What do you think, Mr. Lucas?
There's nothing to stop reviewing that type of cost causation.
Okay, very
And
well.
if I might add, I think some of the things you were mentioning, Commissioner Tucker, I believe were mentioned in a recent staff conference, I believe, on July 6, 2026, I believe for docket number E2 sub 1410. And I think one thing we just want to highlight, as we've mentioned many times through the course of today, is that Duke does have a vast amount of discretion in terms of how they can decide to solicit, sign, and serve load. So there, I'd say these are things that the commission, a lot of things that we presented in our tariffs today are things that the commission can think about. There might be various tools the commission can also use to take action on this, pertinent to some of the issues that you've raised. But we did just want to highlight that a lot of this is driven by the ability that DC has had to be able to sign various types of ESAs with interested parties, and have the ability to change these ESAs for various amount of reasons. And we've mentioned many concerns throughout this hearing, but I think there is potentially options if the commission is interested in employing on their own discretion to help address these things.
Okay, well, thank you for that. We're going to give the people their money back, their upfront money back over time through the, $100 million they may spend a year in electric rates. But I just thought I'd present that to you because you've been nipping around the bud, and Duke has some tools that you can do part of this and not all of it. And I was just trying to present a total package that was real, that's happening now, that we could, make a break on. That's all the questions I have. Thank you, Presiding Chair.
Sure. Commissioner Vandermark.
Yeah, I don't know if I can add much to that. I just want to make clear that this ESA, that's a bilateral contract and the ratepayers are not involved, right? And that your tariff, so I mean, if you're not at the table, you're part of the dinner, right? You're on the menu or whatever. But you're saying, recognizing that you get some of these costs, and I think Duke has a methodology that if the total revenues cover the cost of one of these required, specifically required assets, then they waive the requirement for a CAIC or
CIAC.
and that's what you're getting at. That was your example of, recognizing that and having the customer pay the additional 2% as part of their tariff. And when that goes on, that comes off the rate base. I mean, when Duke defers or waives that, that becomes part of the rate base. And even if the facility runs through its entire 15-year program, Duke still, I mean, that's still part of the rate base.
Yes, and that's why we recommended a change in our service regulations that requiring more contributions to native construction, but make clear that Duke does not get to count that as rate base.
Correct. And at the same time, from the customer standpoint, if they get that waived, they don't have to pay the 2% you're talking about. So what I'm seeing is a bilateral contract where the two parties are both ready and willing for that to happen, recognizing it'll just go to the rate base.
Yeah,
And those costs be socialized.
That
Potential.
Yeah,
You
and it has.
unless they're
it has
irrational.
it
Yeah,
has
I was going to say that's rational behavior.
Yeah.
So, that's what I understood. And that 240 million number, is that an estimate of just those kinds of costs aggregated over those projects?
So the 247.6 million figure is pertaining to what DC's proposing for this rate case for 6 identified large load customers that they.
That's what they're proposing as
They're seeking recovery of those costs as part of rate
I
base
see.
in this case.
I see. And those are specific, to those projects. And you're proposing that in your answer to Commissioner Tucker, that your solution could charge those to the customers?
Yes.
Okay, got it. That sounds good. Now, so that's when everything works correctly. In other words, the customer stays for the entire 15 years. Now, the other risk, there's another risk involved. And that is if they leave. And what I didn't quite understand, and I get it, it's kind of a blunt object there. You said, look, we need to get that back, and you cut it up based on their size, their size. Some of these assets are clearly going to be completely useless, like a substation that was built completely for. I mean, we should get those should be reimbursed to 100%. But there are going to be some assets, perhaps, that are not so useless. So I mean, isn't this kind of your proposal on the exit risk seems to me a little bit crude, whereas you could do some kind of an evaluation where if Duke might be able to find somebody to utilize those assets, and we shouldn't immediately charge this sort of flat. And the flat rate's no good either. I mean, you're even at 80%, 20%, which is left on the table for the ratepayer, might be a very big number. Anyway, I'm just wondering, is that just too much trouble? Is that, I don't know. What do you think?
Well, we did propose in our tariff that if
Customer.
Duke or the existing customer can find another customer to use those assets, that if that customer locates near where the existing customer is, then Duke can back off the percentage that the existing customer would have owed. So we do see a path for a new customer coming in using those same assets.
Yeah, I guess. Okay. Well, that's close to what I'm saying, but I would just pin everything on it. What I'm thinking is that kind of upfront recognition that that's how these end risks are going to be paid might incentivize both Duke and the customer to better plan the assets they're going to install to make them more flexible, perhaps, if things don't go well. I'm just thinking out loud. The last thing is, I thought, didn't Dominion go to a rate classification for data centers? And they've got a lot of
They got
experience.
they created Dominion Energy Virginia created a GS5 tariff.
Right.
That's specifically aimed at data centers.
But isn't it a rate classification?
I've got a copy. Maybe I can. Yes.
And I guess my question is what's the advantage? It seems to me that there's this disconnect between the ESA until the time they build, and you got all that. I mean, is there not an advantage to calling these guys their own classification? And then we have statutory requirements not to allow cross subsidization.
There could be an advantage by making them their own customer class. We are concerned there could be some other similar. We didn't want to shut the door completely. There could be some other type of advanced manufacturing that does have a high load factor and a high load. So.
But you said 92% based on load.
Yeah.
Is data. I mean, we're talking
data centers. Yeah, most of it is data centers. We just didn't want to shut the door completely on some kind of advanced.
I mean, but 92% of what was it, 7.9 gigawatts? I think that is big enough to be a class.
It's 92% of those 29 signed ESAs that we have. So there's
Based on load.
Based on load.
That
but
are data centers.
Is data centers, but the 7.9 gigawatt includes additional customers beyond that.
I know, but I'm saying when you've got of that universe, based on load, you've got 92% being data centers. That's just that's the tail wagging the dog, right? I mean, if that can't be its own class, hell, what percentage is that of our total load?
It is large. I did the quick math, and it's 92% of the 6.7 gigawatts of signed ESAs, not just projected load, these signed ESAs.
Are data.
92% is still over 6 gigawatts. Duke's total generated capacity in all the Carolinas, you added up everything it has, it's got 35 gigawatts of generating capacity. So
So you don't think that qualifies as a class? Anyway, I just saw that there might be some advantages to going to a new classification, including statutory underpinnings to make sure cross subsidization doesn't happen. And so I was just, so your thoughts when you went through this tariff, which sounds an overlay, if I get this right, it's an overlay tariff on the existing classification
yes.
tariff. It just sounds awfully complicated, but maybe not.
Well, we do have some other, we call them rider type tariffs like net metering. And when we go through rate cases and we go through
Okay.
cost allocation and billing determinants, and we determine rates of return, it's Duke Energy that comes down to the rates per kilowatt hour down to the 1/10,000th of a penny. Duke does those calculations.
Yeah, I
Public
guess
staff
it-
does it. We had to take this upon our own because it was a rate case, so the public staff developed this large load tariff that would have to work in conjunction. We were unable to go ahead and create a complete tariff like an HLF tariff or an OPTV tariff from scratch.
Yeah, I guess I'm figuring if it were a classification, it'd be easier for you to determine the actual prices, the costs. But anyway, that's maybe for a later date. But thank you very much.
Right, and Commissioner Gaida, I take it.
I have a long series of no questions.
Okay. I think most questions have been asked and answered today that were conceivable, reasonable questions, as well as some unreasonable ones. But with that said, I know we're at the end of the day. I want to look to my court reporter, Christine. Quick, do you need to leave at this hour? Or okay, we're going to go ahead and recess for today at this time. When we return in the morning, there may be one or two more questions on commissioner questions. Not that I necessarily anticipate there will be, but if there are, we will restart with that. And if not, we will go to questions on commissioner questions. And of course, as we would routinely do, entertain any preliminary matters that need to be addressed in the morning. So we will now stand adjourned, and we will recommence our deliberations and hearing tomorrow morning at 9:30 a.m. Thank you all. Sure. What do you do?